ಮೂರು ನಾಲ್ಕಿದೆಯೋ ಒಳ್ಳೆ ಸರ್ ಒಂದೊಂದು ಸಲ ಅಲ್ಲ ಎರಡೆರಡು ಮೂರು ಮೂರು ವಾಪಸ್ at least president are the this is our voice and understand ಚೆನ್ನೈ ಕೇರಳದಲ್ಲಿ ಮಾಡ್ಬೋದು ಮೇಡಮ್ ಕೇರಳದಲ್ಲಿ ಮಾಡಿ ಯಾವ ಡಿಡಿ ಅದಲ್ಲ 11ನೇ ಕೋಟಿಯನ್ನು 2ವರೆಗೆ ಮೆನ್ಷನ್ ಮಾಡು ನೀನೇ ಮಾಡ್ತಾ ನಾನು ಹೇಳ್ಕೊಡ್ತೀನಿ ಭಯ ಪಡಬೇಡ ಕರೋಲ್ ಮೇಲೆ ಹೇಳ್ಕೊಡ್ತೀನಿ ಮುಂಚೆ ಕರೋಲ್ ಆಗಿ ಇಂಥ ಡಿಫಿಕಲ್ಟಿ ಆಗಿ ನಾಳೆ ಪ್ರಿಲಿಮಿನರಿ ನಿನ್ನೆ ಇಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಮೆನ್ಷನ್ ಮಾಡೋ ಮೆಮೋದ ಮೇಲೂ ಬರೆದಿದೆ ಪುಟಪ್ ಮಾಡಿದ್ದು ಇದ್ರು ರೀಚ್ ಆಗಲ್ಲ One GMDRT matter, your lordships have disposed of on 10/4/2026. But in that, at para 3, the petitioner's property lot as mentioned as 45/3. It could have been 45/5. That is the only correction. Shall I hand it to our chamber orders?
Chamber it can.
Chamber order. I shall mark the portion and given the order copy.
Milords granted interim order for yesterday.
Memos order
against a bank and also purchaser. Purchaser's ranking is left out, Milords. Purchaser's ranking, respondent number 2 is left out in the order, interim order. Your lordship granted interim order on 25th, not to take coercive steps against, the order was against a bank and the respondent number 2. But the respondent number 2 is missing in the order, Milords.
What the order says?
That says not to take any coercive, order is also here.
Take that.
Considering the submissions of the learned counsel for the petitioner, the respondent number 1 bank shall not take any coercive steps. The auction purchaser is also there.
What coercive steps he will take?
Because they are going to demolish the buildings.
Huh?
Demolish the buildings.
Why the portion is delivered to them?
It is already, possession is taken by the bank.
Oh.
And now it is only on the procedure.
Give it to the court office.
Yes.
My lords, a memo for being spoken to, my lords. This matter was disposed on 9/4, my lords, giving us the liberty to approach the appropriate forum. Along with the interim orders were extended for a period of 4 weeks, my lords. But kindly the interim order may be extended from the period of the date of the receipt, my lords. 4 weeks from the date of receipt may be included, my lords.
4 weeks from the date of
the receipt of the order. From the day we collect the from the order copy has been ready.
When was it?
The order copy, this was on 9/4, my lords. The copy is ready on 27/4, my lords. Already 2 weeks are done, 2 to 3 weeks are done here.
9/4, 27/4, the order copies. What is happening? Take that. No, something is wrong with all of them. No, when I'm signing the orders on the same day, why it is taking 2 weeks to upload the orders or for the order copies to dispatch. Take that and show it to me in the chat. Yes.
Most.
My lord, we are already filing the interim or vacating interim order,
Huh?
interim order operating in the private company, my lord.
No. I'll not take up any matters vacate petitions now. Yes.
My lord, it's urgent. We already filed
Huh?
vacating. I already filed on several occasions. We are more
I will
than-
not take up now. That's what I'm making it very clear. How can you make a mention for vacating the interim order one day before the vacation?
No, my lord.
Yes.
30.
Where are we now? Where are we now? After 2 months. So now we have to say that.
Page number 5, page number 16, page number 6, page number 17 to 21, page 7, 22 to 26, page 8, 27 to 30, page 9, 31 to 35, page number 10, page number 36 to 43, page 11, 44 to 49.
And serial number 45, I seek time. I provide the judgment. I didn't get it. So I seek time.
This LSE Housing Finance,
No,
that's
I
what I
will,
adjourned it
because
to
there
today.
is in 2025, the same parties, the judgment one is the same parties have preferred.
Might be that court has not considered all this.
No,
but
I'll
because
provide,
there
my
is-
lord. I'll
Huh?
provide. One judgment is there. I could not lay my hands immediately.
Judgment of what?
Judgment of this maintainability of LIC housing finance writ petition.
Tomorrow.
Not, it is difficult, my lord. That's the reason. 2025 matter that I could not lay this.
List this matter as parted after vacation. Yes, next.
Page number 12, page number 15 to 53, page number 13,
Serial number 51, my lord.
Yes.
Serial number 51 is connected with MFA 7918 of
Any
2017.
of all these MFA matters I'm not taking up. It will all go after vacation.
Please.
Yes. Next.
page number 13, page number 54 to 56, page 14, 57 to 62,
60? Yes. Have you informed the petitioner? List this matter after vacation at the request of the counsel respondent. Submitted to the same is informed to the counsel for the petitioner. Look at it if interim order is there extra. Yes.
page number 15, page number 15, page number 63 to 67,
Yes, call the list. Parted matters will not be adjourned. Now, why you want adjournment? Huh?
My lord, serial number 17, my lord, 17, my lord. Senior and feeling not well, my lord. Kindly requested after
After vacation.
17.
Why you want adjournment 71?
My lord, after vacation.
Yes, same under the same caption, these two matters. Yes.
page number 2, page number 1, page number 2, page number 2,
My lord, seal number 2, my lord. Seal number 2, my lords. Senior is unwell, my lords. Can you have it after vacation, my lords? It's pertaining to license, my lords.
Two after vacation.
Oblige, my lords.
Huh. Appear for? After vacation at the request, in all these matters,
My lords.
at the request of respondent, interim order is there extended.
Lords, I am for the petitioner in that matter. Interim order needs to be extended.
They will extend.
Grateful.
Yes.
number 1, pronouncement of order, page number 1,
Accordingly, writ petition disposed of, giving liberty to the petition to avail the appropriate remedy before the appropriate forum. You shall have the benefit of section 14 of the Limitation Act. Appear further. The petition disposed of, giving liberty to the petition to avail the remedy before the DRT within 30 days from the date of receipt of the copy of the order. Till such time, the respondent bank shall not take any coercive steps.
Yes, Lordship.
Yes,
Yes, Lordship. A memo for being spoken is filed. Memo for being spoken is filed. Otherwise, it was posted for judgment. In that, the Lordship has inquired about the physical possession of the property.
then that's what I asked. Why did
Yes.
you say so? You should say, you should make any submissions consciously with instructions.
Yes. Now he is out of station, my Lordship. I am filing the CJM order along with he has been this physical possession has been taken on 3rd March.
Court on 23/4/2026 has disposed of the writ petition. In that, at paragraph number 3, this court has observed that when this court had specifically asked the learned counsel appearing from the respondent bank whether the possession of the property was taken, it is submitted that so far the possession was not taken by the respondent.
My Lordship.
As per the settled law, they can file a petition under section 14 of the Surface Act after the sale certificate is issued.
I am filing a
And
memo.
the
along
matter
with
is
the order.
moved and the same is listed and the caption for being spoken to. Learned counsel appearing for the respondent submits that the submission that is made, take that, the
And,
submission that is made on the day is not a correct submission. And in fact, the bank had
taken possession on
taken
3rd March.
possession on
3rd March
3rd March
26.
3rd March 2026.
And
also they have filed, and the order of
petitioner
order
has.
of the under section 14 is 25th
Yes,
October.
it is also, I am close there. At page
order-
number 6, my Lordship.
And the order passed by the magistrate in criminal miscellaneous number
77 of
2024 is dated 25th
Before the
October
Kodagu.
2024.
And on the next day, my Lordship, on 4th, he trespasses into the property and we have filed a police complaint also, that NCR is also filed along with this memo, my Lordship, at page number 5, NCR number 52 of 2026.
It is submitted that thereafter the petitioner has trespassed into the property. And in this regard, they have given a complaint on 5/3/2026 to the, which police station is this?
Ponampet, Medical.
The Ponampet, in the Ponampet police station. Just to make a note of this in the order at the bottom. Yes, and the copy shall be uploaded. Yes.
Right.
No representation for the appellant. This is matter for dismissal after vacation. It's fine.
This is a transfer. I seek some time to take steps because involvement of vehicle is challenged.
No. Steps to be taken in respect of
I'll
R4.
make out substituted
When he
submission.
died,
Many times it is a 14 matter. Mr. Rajgopal was appearing. After his demise, matter has been transferred to me.
but it has to be something.
But
you have to
I'll
do
take
it
immediately after vacation.
by
I'll
the-
make out substitute.
By 4th of June, if the steps are not taken in respect of the deceased, to bring the LRs of the deceased R4, the appeal against the respondent shall stand dismissed without further reference to the court. Yes.
Right.
6. Take that memo.
Filed memo for withdrawal minutes.
A memo is filed stating that the cause of action, the writ petition does not survive and is permitted to withdraw, accordingly dismissed as withdrawn. Yes, next.
case, my lord, joint memo has been filed and my lord, the annexure G may be quashed.
Is it
Both,
the toll matter?
please, my lord.
Is it that matter earlier?
No, this is different matter. This is, my lord, notice has been issued by, my lord, state SST commission. And both parties have settled their dispute before the trial court in OS number, my lord, 19 of
Where is
2000.
that memo?
That memo has been filed. That is dated 15th April 2026. my lord. In that page number 11 may kindly. be-
Joint memo is filed. All the
Yes.
parties are here.
Yes, my lord.
I am appearing for respondent number 2.
Respondent number,
Look at the cause title.
cost title, my lord, the first is
There are
state.
two petitioners, Ashok Jain and Shakuntala Jain.
Yes, both of them there.
He is Anand.
Yes.
The joint memo is filed before this court stating that
They have settled the matter.
the petitioners have filed the petition questioning the notice dated 21/9/2022 issued to the first respondent, making certain allegations against the petitioners by the second respondent. And both the petitioners and the second respondent have settled their disputes pertaining the property.
In OS number,
Post number 19 of 2023, dated
dated, my lord, 2/3/2026.
what is that?
2/3/2026.
2/3/2026, hence in view of the same, the respondent has no objection to quash the entire proceedings as per Annexure G. And the parties were also present before the court identified by the advocates. Considering the memo, the joint memo that's filed before the court, the writ petition is allowed by quashing the proceedings dated 21/9/2022. What is this proceedings?
This is, my lord, that there are certain property dispute. That, my lord, in the first respondent that they have filed complaint because, my lord, the state,
What is this 21/9/2022, let us see?
that is annexure G, my lord, notice has been issued on the basis of the complaint lodged because he's claiming, my lord, that
Who has issued the notice?
first respondent has
Who
issued.
is the first respondent?
First respondent is, my lord, state
Karnataka creates scheduled caste.
scheduled caste.
tribe commission. Is quashed. Accordingly, that in the light of the settlement, the writ petition is allowed.
Grateful.
Please.
Sir, party will be signed. Orders. Grateful.
My lords, I appear for the petitioner, my lords. My lords, respondent number 17. Last time I had made a submission that in the online portal of the Honorable High Court, it shows that item
The
served.
remote is adjourned. On the online portal, it says that it is directed the registry to put up the service.
My lords, I appear for R19 in this matter. We are awaiting instructions from the client, my lords. We are awaiting instructions from the client. I appear for R19. We have not been served with a copy of the petition, my lords. Let that be served.
1 minute.
Last time I had furnished the printout of the website, my lords, for verification.
1 minute. R13 and 14
I
are
appear for
served,
R13.
yes. R15 is also served. R16. R16 is not served.
My lords, as per the list, it is shown as R16,
So-
name is shown.
It just
Kingfisher
says, it doesn't say that whether it's served, just only mentioned as R16 Kingfisher. Hmm? Not served. Then 17? You are making the submission with regard to R17?
Yes, ma'am.
That it is delivered.
Yes, ma'am.
What did they do now? Is it delivered?
No, that they have
reference number.
Oh.
But RK 44, 70, 18, like this. It is not mentioned whether it is delivered or not.
Dr. Vijay Mallya.
It is R16.
In respect of R17, they are
It
saying
says out of station.
R17, my lords.
It says out of station.
My lords, it's a trust fund, my lords.
Huh?
It's a company. R17.
Unit Trust of India is also out of station. Respondent number 20. No, apart from placing this before the court, they have to make a note of it, what is happening, why they are not doing.
Simply they have just that.
You appear for whom?
I appear for R19 members.
19. So now who are left is 20,
And
20, 15 and 16.
My lords, 15 and 16
No,
is
no,
out.
no. 20, 17
20
and
and
16.
okay. I'll take first step 3 what in respect of them.
19
Because-
is appearing. So you please take steps instead of waiting for all this.
Yes, my lords.
The petition shall pay the process, the service of notice to, shall take out notice on respondent number 15, 16.
My lords, 15 is out, my lords. Dr. Vijay Mallya. It's
No,
shown
but it
as
doesn't
out.
say so. You look at it, it just says it is out of, as per the postal share.
Yes, my lords.
Process in respect of this R17, 18, 19, 20.
Lords, Dr. Vijay appearing as party person.
You're over, your matter is over, you're delegated to the DRT. Registry by mistake has put up notice issued to R19 and R21. Are they able to understand what is this note?
They are seeking process in respect of.
My lords,
Petition shall pay the process in respect of 15, respondent number 15, 16, 17 and 20. Then council shall reserve the copy of the writ petition on the council appearing for respondent number 19. The process shall be paid by tomorrow. This is matter, if the process is not paid, the writ petition against those respondent shall stand dismissed. This is matter immediately after vacation.
Yes.
Yes.
For the petitioners council, there are four, I'm sorry, respondents not present. 4 petitions. Sorry. That have been filed. The premise is simply this. There were some letters of credit that the bank issued to them. The margin was short and there was some security that they'd offered. Because the security was short, we initiated an OA, SARFACI proceedings and NCLT proceedings, all arising out of the same set of transactions. I must tell the court. Their whole contention in all these writ petitions is that there is no relationship of debt and default, and therefore the entire question of default doesn't arise. Consequently, I can't have invoked 13(2). I could not have initiated a Section 7 petition and before the NCLT. Similarly, the OA was bad. This is the sum and substance of what I'm saying. I'm possibly oversimplifying, but this is the sum and substance of it. This honorable court felt, and owing to the circular, the matter in the DRTs to transfer to the DRT Chennai, this honorable court felt by an order that let the DRT decide and then we can consider it. The DRT has now decided the matter. The OA has been disposed. But while doing so, there are certain observations which clearly hold that there is a relationship of banker and client between us, and consequently, in my respectful submission, the default has occurred and whatever consequences flow. There is one peculiarity though, which is that the honorable DRT has felt it fit to say that the quantification should be done by filing memo of calculation between the parties, and that process has not yet been completed. I must bring that to the court's notice. That process alone is pending. But it is my respectful submission that insofar as these petitions are concerned, the fact that there is an adjudication of the relationship of banker and client between us and consequently a debt and that default, etc., these petitions, that should suffice is my respectful submission, irrespective of what the quantum is. That is the submission I wanted to advance.
My submission, Lords. So far as the balance is
Come to
claimed,
the prayer. What is the prayer you're seeking for?
Lords, may I pass on this, my Lords? Today I'll making two submissions, my Lord. One, senior counsel, he has a personal inconvenience. Second, the DRT adjudication is listed on 1st of May. Let it be called, these matters be called immediately after vacation. So far as the quantification of balance, it will also ensure their concerns, and it will also give me a clarity that how to make a submission before this honorable court in these matters, though it stands on the different footings.
But my learned friend is right in saying it's on 1st May, but I may point out only one thing. He has to then, possibly let him take instructions are not coming in the way, but he has to then make a statement that he will stick on to this order. He can't, having not challenged the order of this honorable court, asking the DRT to decide, and the DRT having decided the relationship, my respectful submission is that the quantum becomes immaterial. Though we are not before the court for an enforcement of that amount. We are before the court to decide whether or not the jurisdictional question is
This
asked.
is matter immediately after vacation.
Great.
Look at the different order is there.
Deeply appreciated.
Yes.
Would a date kindly be fixed with the court?
This is a matter on 10th of June.
Great. Serial number 23 is also. I'm sorry, madam. I'm so sorry to interrupt the call. Serial number 23 may also be connected with this because that also is between the same.
Tag 23 also.
I'm so
along with this. And then that also interim order is there.
I appear for petitioner in this case, my lord. My lord, I have challenged the section 14 order, my lord. What has happened is in 8/4/2011, the magistrate has allowed the section 14 application filed by the bank. Subsequently, in between what happened in the OA, the mortgager's liability was discharged by in the OA. Subsequently, the bank challenged it before the DRT Chennai in 2010. That came to be allowed in 2023. So in 2023, we filed application in the CMIS, in the section 14 and the section 14, seeking the permission to appoint the commissioner, advocate commissioner, to take the possession of the property. The magistrate has rejected our application, the memo. That is why I am before this court.
Who appears as the respondent?
Appearing for respondent number 226, Milord.
Yes.
Milord, senior is held up in DRT, may be posted after vacation, Milord.
My lord, section 14, there is no necessity of hearing the other side, my lord.
Please come to the order.
Your lord. In 10.1, the auction purchaser has
I
filed.
have purchased the property in 2006, your lords. From 2006, I am not delivered the possession of the property by the bank.
How did, without taking possession of the property, how did the bank sell the property?
No, at that time they have sold it, my lord.
Huh?
At that time they have sold it in 2006.
No, at that time also serviceable.
It was there, it was there.
The act was there.
That was there, but they obtained the order. In between what happened, the borrower.
That's not right on the part of the bank to do all this.
Lordship.
Why do you sell the property without even having actual possession of the property?
I do admit that.
What title you will, without possession, what will you convey to them?
The lords may kindly go
And
at page
this is high
21.
time that bank should realize this and bank should stop doing it and don't create litigation.
Yes, ma'am.
Surface Act is not for the bank to create litigation and settle it. It is for them to recover the dues. Yes.
In fact, at page 21, there's a direction by this honorable court to deliver the possession of the property. In spite of it, they have not delivered. Your lords.
How to deliver, my lord?
The order
He has been
of this court.
discharged in the
Why
way.
did you sell it? Then give the money to him back, right from 2006, whatever is it, with interest.
They have not given any representation for refund of the money. At that time, they would have, I think the bank would have considered.
Certificate has been registered.
Registered, my lord. In
It can be
2000.
cancelled. Why not? And he will get the money at 18% interest.
My lord, if that memo is allowed, then I may be permitted.
Why should we do it now? A property which is sold in the year 2006, why should there be an order of this attachment in under section 14 now?
My lord, there was an order in OA The liability of
So
the,
whether it is, which is first?
surface was the first.
Which
surface
action
was-
is first? Taking
Auction
possession
is
is first or selling the property is first?
Selling the property was first.
Why did you do it? That's what I'm asking. This is matter immediately after vacation as partner.
Lords,
And
there's some
you
urgency.
please advance your arguments on what is this, how the bank has to proceed. They will sell all the properties and then keep the purchaser waiting for, eternally for 20 years, get the possession of the property, and you will file the applications and keep quiet.
That
What is the
20
procedure that has to be followed?
21 years now, I don't have the possession of the property.
That also will be
1.2
answered.
crores
This is
I have
matter on 2nd of June as partner.
Petition is not maintainable against Jana Bank.
The writ petition is filed. There is no representation on behalf of the petitioner. The writ petition is filed against Messrs. Jana Small Finance Bank Limited. In the light of the law laid down in Vishwabharati, the writ petition against so-and-so is not maintainable. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Before the appropriate remedy, the petitioner shall approach the tribunal within 30 days from the date of receipt of the copy of the order. Yes, section 14, section 4.
My lord, OA final order they have challenged. OA final order they have challenged, my lord. The property is already sold in 2021, my lord. Sales certificate.
No, the objections, you are filing the objections now.
My lord, the matter, the case is transferred to some other branch, my lord. We need to secure some more instructions.
This is matter after vacation.
Great.
Respond in this case, my lord.
Lordship, I filed
It is a
Wakalat
private
morning.
company, my lord. It is a private finance company.
Yes.
Lordship, I filed Wakal in the morning. Lordship, the petitioner is ready to deposit the entire amount.
But the problem is we can't.
But the
entertain
Lordship,
that.
the bank is not ready
Lord-
to hand over the original documents, Lordship. That is the problem. If the bank is ready to undertake, I'll deposit in 1 week,
The
my
writ
Lordship.
petition is filed against Tata Capital Housing Finance Limited. A writ petition against so-and-so same order. Petitioner shall have the benefit of section 14 of the. Huh? In every matter, wherever we say 30 days. Yes, 14.
For the petitioner, my lord, I undertake to submit the rest of 45,000 is remaining amount. Remaining amount of 45, the respondent advocate made a mention in the earlier occasion. I undertake to remit it to the bank. Entire amount has been remitted to the bank already. Only the 45,000 is remaining.
You are ready to pay that?
Yes, my lord. On that, the petition may be disposed of. On that undertaking.
Where is, who appears for the respondent? Saubhagya Anya for. They're ready to pay. They're ready to pay that amount.
No, 45,000.
I'll call it. I'll next after.
No, they're not paid as and they 45,000.
That's what they're saying. They're ready to pay.
Please. On that note, it may be disposed.
It can't be. You have to. When are you going to pay it? 45,000 it is. Please pay it. Get it DD tomorrow. We'll close it off. Is it 45,000?
Please.
Then counsel for the petition shall get the DD for an amount of rupees 45,000.
After vacation, my lord. I don't have instruction for tomorrow whether.
Then
the
after
party is
vacation.
Grateful.
Yes.
Time for the respondent in the
As agreed, my
connected
lords,
matter.
paying 50 lakhs. 20 lakhs I paid earlier. 12.5 RTGS has been done. For the other 17.5, I'm giving checks, my lords.
Also providing the account.
So you have, how much you paid earlier?
20 lakhs, my lords.
20 lakhs, now you're giving DD for 30 lakhs.
17.5 checks, my lords.
What is check?
2 checks for 17.5 lakhs. There is sufficient balance.
We will not.
No, there is sufficient balance. I'm providing the
So why
statement
you
as well.
can't take a DD?
I have RTGS 12.5 lakhs. There is 17.5. I'm giving the checks because there are several.
Why can't you transfer it?
No, the difficulty is, my lords, that account with respect to the Wanderers Brewery, that account is not functioning, my lords. The bank can encash it. We can't directly. That is the difficulty. Even the last time.
Get instructions on that from the bank.
Even the last time we gave the checks, my lords,
No.
20 lakhs, which is.
Take those 2 checks. Get
That
instructions
is in
from the
terms
bank.
of the first petition. There are 2 connected matters.
2 connected
Yes.
petitions.
15.
This is with respect to the first petition, my lords.
Who appears? Ignesh Shetty.
Kindly pass over, madam.
That's no, ask him to get instructions. Give those checks to her.
Please.
Yes. This is a password. Yes, next. What is this? I don't understand. Why, what is this IA 1/26 for correction?
For
When I have
correction,
already set aside
this,
the order.
The subsequent order dated 15/12/25.
In that view of the matter,
Yes, that.
judgment dated 6/11/2025 is recalled. When it
Recalled.
is recalled,
That
why
was-
should it make a mention?
That portion has to be reflected in the
No,
original.
no, not necessary. That will come when it is it is only a part of the order is, modified by the court. When the entire order itself is recalled, it is not required.
But that the judgment will be independent. That means
No, how can it be? I have already
This portion
recalled.
has to be reflected in that. That's
Not
all.
necessary. I verified it's not necessary.
Only
I number
request is this.
1/26 is filed seeking correction of the judgment. The judgment that is passed by this court is already recalled. So question of incorporating this in that judgment would not arise. Yes, accordingly dismissed. Next.
Lords, I appear for the respondent in serial number 17.
What is this IA 1/23 for withdrawal of the amount?
I appear for the respondent. As per the interim order, now deposited 15 lakhs rupees before the sound court.
We'll hear the matter. What is it?
And the Surface Act notice on 13.2 and 13.4 and the order under the this deputy commissioner, that is under challenge. 70,000 rupees they have loan they have availed. Now it is 1,32 lakhs. As per the interim order, they agreed to repay the loan.
Notices dated 6/7/2019.
In this case, as per the court order, I have deposited 15 lakhs. I have availed only the 30 lakhs of the loan amount. So predecessor of this court has ordered for the production
For that interim order of 2021, please argue on the merits of the matter.
production of the true and correct statement. They have not yet produced before this honorable court true and correct statement.
No, what is
So
that
I am
is-
ready to pay.
No, look at what is the prayer you have sought. We are not concerned with
I am-
other things.
I am seeking to quash the notices.
When was the 13th notice issued?
That is the notice dated 6/7/2019 issued by the respondent number 2.
Where is your reply to the notice?
Not reply.
Reply.
Now, they have issued the notice.
You have to reply to the notice. Without replying to the notice, why should you come to the court? That is what is contemplated under the act. Whatever your queries, whatever you say that notice is not made, you should give it to them, a reply. And
True, my
they-
lord, instead of respondent number 1, respondent number 2 has issued this notice.
Who is respondent number 1?
That is the
Who is
Mahila
respondent?
Cooperative Bank. Tumkur is the respondent number 1. And respondent number 2 is the Mahila Cooperative Bank, Sheshadripuram.
The head office,
Instead of
authorized
respondent
officer.
number 1, 2 has
Authorized
issued
officer
the
and head
notice.
office.
Yes, that is one ground. And other?
And also, the annexure C dated 6/9/2021 issued by the respondent number 2 and annexure D 110/21 And also the annexed E, order of the Deputy Commissioner dated 6/8/2020 passed by the, by the Deputy Commissioner. So,
What is the order of Deputy Commissioner?
That is under section 14(1), my lord. This is in a rural area, Tumkur.
because,
Deputy Commissioner is authorized
no, in
to
this,
pass order.
in this case, as per the, they have
Take
to
question.
go before the register for the society for the recovery of the.
Officer proceedings are maintainable. That is settled law.
So as per the previous court order, I have deposited 15 lakhs and remaining amount I will pay. I will pay to the bank, provided they have to give the true and correct statement, because I availed only the 30 lakhs of the loan
Have you
amount,
both
my
of you
lords.
settled? Court has nothing to do with that. Court is only concerned with what is the irregularity in the, with what they have done. Now, when 13(2), when a notice.
That is the irregularity they have committed.
Irregularity, when a notice is issued to you on 13(2), you should question all that, you ask them all, and under 13(2), you will not ask the court to ask them all the reply and come to the court. That is not the way. You reply whatever your remedy, or you please take it before the DRT. Please come. The present petition is filed, seeking the following reliefs. The facts of the case are: the petitioner has availed the loan from the respondent and has executed a mortgage. A notice was issued on 6/7/2019 under section 13(2) of the Act. In that it is stated that the mortgage loan amount is rupees 70 lakhs and rupees 69,40,995 was the balance as on 6/7/2019, including interest and capital amount. Therefore, with a period of 7 days, the outstanding amount, that is a mortgage amount of rupees 69,40,995 to pay to the respondent number 1 bank, failing which the action will be initiated against the petitioner under the Surface Act. It is stated that the respondent number 2 does not have the locus standi or power to issue the notice under Surface Act, since deposit of title is executed with the petitioner in favor of the respondent number 1, and in body of the contract, it is mentioned that the documents which are executed and all other documents pertaining to scheduled property will be in the custody of respondent number 1. On 6/9/2021, the respondent number 2 issued a notice for notice under section 13(4). And they have demanded rupees 71,14,798. It was issued with the condition that in case within 16 days the supposed outstanding amount is not paid, the property will be taken to the custody of the respondent number 2 bank. Then on 1/10/2021, the respondent number 2 issued a sale notice. On 6/8/2020, the Deputy Commissioner of Tumkur District has passed an order on section 14(1) of the Surface Act.
And we took possession also.
That on 17/3/2018, the petitioner has deposited 2 checks. The respondent 1 bank. The amount is realized and the amount is deposited in the petitioner's SB account. It is stated that the bank could not have adjusted the said amount. It is also stated that the entries and the calculations are not made properly. Erroneous calculations were made while calculating interest and principal. Some of the cash transactions by the petitioner has not been entered properly in the account statement with a malafide intention. Hence, agreed by the same, the petitioner is before this court. Land counsel appearing for the petitioner submits that the respondent bank has no authority to initiate the proceedings under the Surface Act. The calculations, the amounts that are mentioned, there is a discrepancy with regard to that. And regard to that, it is submitted that as per the interim order passed by the coordinate bench of this court, the petitioner has already paid, dated 21/2/2022.
Sorry, madam. I have deposited before this honorable court.
Had deposited before this court an amount of rupees 10 lakhs.
It's 15 lakhs.
15 lakhs.
Amount of rupees 15 lakhs.
And as per the interim order, we have redelivered the possession also. We have redelivered the possession. Pursuant to
The respondents have redelivered the.
Sorry, my lords, possession has not been redelivered. My friend
My
is,
lord, as per the interim order, we have
they have
redelivered.
not complied as per the interim order.
Land council with the petitioner submits that the position of the property.
I am
was
ready
not,
to pay the entire amount provided the true and correct statement is given.
The property is not redelivered. It is submitted that the petition is ready to pay the money provided correct statement is given to the, given by, if the correct statement is given by the respondent. It is
2/12,
Please pay,
please.
if the correct statement is given by the petitioner, by the respondent, it is submitted that the writ petition may be allowed by setting aside the proceedings initiated by the bank under the Surface Act. When counsel appearing for the respondent submits that, as per the interim order, they have delivered back the position and the amount of 10 lakh, 15 lakhs that is paid is.
They have not yet delivered the possession, my lord.
I have recorded your submission. I have to record his submission also. That the amount of 15 lakhs that is deposited by the petitioner is lying before this court. It is submitted that as on today, the outstanding amount is,
1 crore 32 lakhs.
outstanding amount is 1 crore 32 lakhs. It is submitted that by virtue of the interim order passed by this court,
That is not submitted before this honorable court, my lords.
passed by this court dated 21/2/2022, the respondent of a bank is not in a position to take steps,
Kindly time may be given so that if they have provided true and correct statement, I am ready to pay the entire amount, my
And
lords.
2/12/21, I have issued a statement along with the, I sent it by
No.
RPID that has been served on you.
It is submitted by the land counsel for the respondent bank
On 2/12/21.
on 2/12/2021 instead, yes.
So based on the,
Statement of accounts. And it is
based on the
submitted that
court's order, I have
petition is not-
deposited 15 lakhs remaining, I am ready to pay provided the time shall be given.
Having heard the counsels on either side, that is a material on record. The petitioner has questioned the notices issued, the proceedings that are initiated by the bank under Surface Act before this court by filing the writ petition in the year 2021. The Surface Act proceedings were initiated in the year 2019. When a notice was issued under section 13(2), the petitioner has not given any reply and kept quiet. Then they have issued the further proceedings under 13(4), and an order under section 14 was passed. By virtue of an interim order that is passed in the year 2021, the proceedings are stayed. It is a submission of the land counsel for the petitioner that he is ready to pay the amount provided the correct account is given to the petitioner. That cannot be a reason for this court to entertain this writ petition. If the petitioner wants a correct statement of accounts, when a notice is issued under 13(2), he would have replied to the same, and the bank is duty bound to give a reply under the provisions of the Surface Act. But for the best reasons known to the petitioner, he has not replied to the same. Right from 2021 till 2026, the entire proceedings in the Surface Act are stayed. The submission that the bank cannot initiate the Surface proceedings is the submission also has no legs to stand, as bank has the authority to initiate the proceedings under the Surface Act. The submission that if the correct statement is given, that he'll pay the entire amount, that is for the petitioner to approach the bank and take appropriate steps. In that view of the matter, this court do not find any reasons to interfere.
So time shall be granted, my lords, so that I can pay the entire amount, or else they will take
Accordingly,
the
writ petition
coercive
is-
steps.
The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. Accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy to the DRT within 30 days from the date of receipt of the copy of the order. Number 2, the petitioner is ready to, it is stated that the petitioner is ready to pay the amount. He shall approach the bank he shall approach the bank by 29th of April, and the bank shall give him the statement. If he is ready to pay the amount, he is at liberty to pay the same within 30 days from the date of receiving the statement. Yes.
In the meanwhile, the 15 lakhs rupees.
The 15 lakh amount, which is
For
deposited.
that, there is some office objection. He has to furnish the PAN card. He has to furnish the other. He has not furnished.
No.
That's why they are not able to release it.
My lords, it is furnished and also written and submitted to the registry.
The bank, the registry shall release the said DD
In favor of first respondent.
to the first respondent bank.
Then I will appropriate to the loan account because directly they can't transfer to the loan account.
Anyhow,
Please, ma'am.
this can be, you can show that.
Please,
If you are
please.
not received, not received.
Please.
My lord. My lord, I am sorry, my lord. Serial number 17, my lord, interim order extend, my lord.
17.
Julie,
Yes,
in 19, in compliance with my undertaking, I filed an affidavit.
where is the affidavit? The writ petition is filed, seeking the following prayer. On the last occasion in the matter came up, the AGA submits that they are no, they are ready to pay an amount of rupees 75,000 and can transfer to the account of the petitioner's counsel, provided an affidavit is filed before the court. And this court has, the counsel for the petitioner submitted that they'll file the affidavit during the course of the day. Today, the affidavit is placed before the court, in that he undertakes to transfer the compensation amount of rupees 75,000 to the petitioner immediately upon receipt of the same. The undertaking affidavit is taken on record. Accordingly, the writ petition is disposed of, directing the which respondent. Which respondent?
R2, your lordship.
R3. Directing the respondent to transfer the amount of 25,000.
75.
75,000. What is that? I was furnished any bank details?
Yes, your lordship. My affidavit.
As per the bank details furnished in the undertaking of the 4 weeks.
My lord,
Yes.
One
I have
request I have.
one submission, my lord.
There are three aspects of the relief that the HRC had given me. One was initiation of disciplinary proceedings against the erring officer who put me in illegal custody for 19 days. That is a matter between the state and the officer concerned. The second was compensation, which your leadership has kindly granted. And the third, on basis of the concession that the state government has made. And the third was a more salutary relief, which is that where there are situations involving non-bailable and non-cognizable offences with individuals who are foreign nationals or do not understand the local language, the state government must form guidelines, the state police must form guidelines on how police officers should behave with such individuals, so that a situation of the nature that occurred to this time does not occur to them.
Then we need to have their objections on this.
On that aspect of leadership, if they could.
Keep this writ petition pending. So and so submits that within the same order. The third relief, that is, the petitioner has there are three reliefs sought before the court.
Page 31, your leadership will see the operative part.
The first relief is the state government should issue appropriate guidelines to the police officers in the cases involving foreign nationals or related persons when they are arrested, so as to follow in letter and spirit the provisions of section 51, 52 and 50A of the Code of Criminal Procedure. Then the second relief is with regard to the amount. And the third is the state government should to take disciplinary action against the erring officer. As far as the third relief is concerned, you have already initiated the proceeding.
Initiated, my lord.
Third relief is concerned, it is submitted by the AGA that they have already initiated the proceedings. As far as 2 is concerned, as it is already addressed, whereby they are going to transfer the amount in the account of the council within 4 weeks from today. Then number 1, with regard to this, the state has to file
Then
their
he
objection.
needs to make an amendment. Now it is under BNSS.
The equivalent provisions of BNSS.
It's that you can file it. Whatever is the amended provision now, you take that name, the petitioner, the respondents shall file their objections, and the response to this prayer number 1. Basing on that, further orders will be passed.
Treat it as a part-heard, my lord.
Huh?
Treat it as a part-heard.
List is as part-heard
And
after vacation.
And one submission, the amount that which we are paying 75,000, we are liberty to recover it from the R3.
The state is at liberty in that only.
Yes, ma'am.
They shall pay, R2 shall pay. and they are at liberty to recover it from the erring officer.
And subject, what if the R3 initiates any proceedings against that commission order, if he succeeds getting an order in his favor, then the 75,000 what we are paying will be recovered, will be payable by the person who is receiving the amount. Because we are paying, man. We
They want
are
to
paying.
recover if the erring officer
If
succeeds
the
in disciplinary
R3
proceedings.
succeeds,
I don't
the
think that
appeal or
can be
writs,
countenanced.
then he has to.
It's an independent action. Already, that order is different. These proceedings are different. There can't be such an order. If you are entitled for something, then you initiate proceedings. Is parted after vacation. List the matter on 17 June. By the time the objection shall be
I'll
placed
place.
on.
I'm deeply obliged.
As my client's instruction, my lord, my loan accounts has been regularized, ma'am. As my
Account is
client's-
regularized. When counsel for the petitioner submits that, the account is regularized and nothing survives for consideration in this petition, accordingly dismissed as infractions. Yes,
Appearing for petitioner, my
memo
lord.
for withdrawal is filed.
The petition is filed challenging the passport authority, the show cause notice which has issued. We have filed the memo for withdrawal. Kindly dismiss the petition as withdrawn, my lord.
Memo is filed, saying to withdraw the petition, memo is taken on record and dismissed as withdrawn.
Much obliged.
Lords, in this matter, we are unable to locate the file, my lords. They can serve a copy.
When they file a vacate petition, we can't
Let's,
accept those kind of
It's
submissions.
genuine, my lords. If let them serve the copy, the matter may be taken up tomorrow. We'll address the
The
arguments.
respondents are private finance company. The respondents are private finance company.
Which is a,
L&T.
L&T and Tata Capital.
Tata Capital and
then
and
the
my lord,
petition has to go.
Let's.
and
let
another
me-
thing is that what has
I will-
been challenged,
I will take the copy now. Tomorrow, the
that
lordship.
the
may
essay
hear
order
the
what has
matter,
been
my
challenged was
lords.
dismissed in 2024 itself.
Tomorrow also, it is not, the
No.
fate of the case is not going to change. Tomorrow.
I'll
will-
take the copies.
Tomorrow I may not be here. In some
Even
other
if you are not there or if she is there, there are no arguments in that. L&T finance not maintainable, not maintainable.
Much only.
Much obliged.
Tomorrow.
In this case, my lord, my due was only 11 lakhs and odd. I sought for statement of objection before the DRT court. My lord, this court directed the DRT court to verify. There they gave a postal this thing
Is this
stating that.
matter on 28th,
Yes,
2020?
yes.
26. On that day, if there is no
Yes.
source scope for settlement, the writ petition shall be disposed of by relegating the parties to the
Yes, yes,
DRT.
yes.
So
There-
whether there is a scope for settlement or not, only one line argument.
That's what, my lord. Register report, they sent the statement stating that this is due is 2 crore 65 lakhs. Now, after my lordship directed to give the statement of, they given a statement of stating the 1 crore 77. 1 crore is the difference. 1 crore is the difference. And my due was only 11 lakhs and odd. That's why, my lord, and then now there is an OA order stating that is only 1 crore 57 lakhs. There is a difference. Let the DRT be directed to verify the correct account.
You ask the DRT to do it.
DRT has already been disposed of. They will have to
No,
approach
that's what they,
DRT.
but dismiss this matter without verifying this account.
Plus, if my lords were to kindly see my statement which has been filed, my lords. Kindly see.
OA order, my lord, there,
I have made it very clear on the
Yes, my
last
lord.
occasion. I'm not going to hear any arguments on it.
If my lords were to kindly see my statement, my lords. Initially, my lords, on a
my lord, let
contract.
the DRT look into the accounts, my lord. They have sent the register report to me. They have not filed any statement of account before the DRT court.
It has been
Without
filed, my
the-
lords.
yeah.
My fund is.
They
It
have
has
sent it
already
the
been
register report
filed.
to me. They, my lord, I filed an application to give the statement of account.
No.
The,
Please wait. Come
Yes.
to the DRT order, why it should be set aside.
my lord,
Come to the DRT order, why it should be set aside.
yes, my lord.
Point out.
My friend has contested
My
the
lord,
OA
before that,
also.
Annex A,
He
my
has
lord.
received the
Annex A,
statement.
the order passed by this court earlier.
Here. Page number.
Page number 25, my lord. Annex A. I filed a writ petition to get the statement of accounts. My lord, distribution number so is hereby allowed. Impugned order details are passed by the DRT one on MA number arising out of the same. is
So the
hereby-
statement went from how many years it gone? This is in the year 2024.
Well, that-
Same statement every
My
time.
lord, for 13-4 notice, for 1 crore 11 lakhs and then I deposited 1 crore. Balance was 11 crore and odd, which I'm prepared to pay, for which they give a statement of stating that 2 crore 65 lakhs is due. Then my lordship directed to give the statement of accounts. On the statement,
Earlier order is the dismiss for default order is set
Yes, ma'am.
aside. Please come to the present
yes,
order.
yes. Well, that's what, Milan. The page number 25, Milan.
I've seen it.
Just one more paragraph. The order dated 16 to dismiss so and so, he stands restored to the filer DRT. The DRT bank is hereby directed to provide an opportunity to the petitioner and respondent and dispose of the SI on merits in accordance with law. Parties are directed to be present before on 26th. The petitioner 9th is disposed of a reserved liberty in favor of the petitioner to ventilate his grievances before the DRT1 Bangalore by filing appropriate application, which shall be considered by the DRT Bangalore after providing an opportunity to the respondent and in accordance with law. This is the order earlier. Then I filed an application before the DRT. I paid on 26, stating that direct them to give the statement of accounts. For which the order passed by the DRT have kindly seen.
When the surface proceedings were initiated?
Hello? But kindly see the order passed by the DRT on my application. Page number 32.
30?
Page number 32. After the matter was referred to the DRT, I was given liberty to file an application. I filed an application. On that application, there is an order on 32. 32. Well, both the counsels are present. Counsel for the appellant to submit that as per the directions given by the Honorable High Court of Karnataka and written so and so, connected with so and so, appellant filed a IA seeking direction to the respondent bank to produce the statement of account from the date of NPA till today. The further submission that unless the statement of accounts provided by the respondent bank, the applicant is unable to argue the matter. Heard the learned counsel for the respondent bank of the IA as well as IL. In view of directions given by the Honorable High Court of Karnataka in above petition for speedy disposal of the case by this tribunal within a span of 3 months, IA filed by the appellant is disposed of with the direction.
Order is dated?
One.
This order is dated?
37/2024.
After that, have you provided him with the statement?
Please, Manoj.
Dated?
Page number 37, 2/8/2024.
2/8?
2024.
The last sentence is very important.
On the very same.
Seen that?
The DRT did not direct the bank to give. The DRT directed me to go to the bank again. I went to the bank. They sent this report and hope the bank will give the statement.
That is not the order which is questioned before the court. Why do you go to that?
Yes, thereafter, in such representation made by the appellant, we hope that the respondent bank shall provide the same immediately, preferably within a week time. Further liberty is granted to the appellant to argue the case on any day convenience to the concerned party before 30th with notice. 30th was the date fixed. 30th I go with the notice. By that time judgment is passed without giving opportunity. 30th morning I go there. 30th is the date fixed, next date of hearing. This was sent by the register port. I verified that this is a false statement of account. Before I start my argument, judgment is, it's not an open court judgment. Judgment was prepared. Earlier itself is a long judgment. It was provided. My last turn to the judgment at page number 39. Final order. Detail orders.
Heard on 37/2024. This is heard on 37/2024.
Liberty was given.
Yes, my lord, but the final judgment will also fail. This I am seeking direction to set.
What is this? What is the purpose of taking the bank statement and reserving the matter on the same day?
It is not. Kindly see, my lords, liberty was granted to him to appear before the DRT any day before 38 and address his argument. He doesn't appear before the tribunal. He makes an application on 2/8. On a very same day, statement has been given. Statement has been
same
given.
is not. It was sent by register post.
One nimsha.
So you have to let him also argue.
Yes, ma'am.
If my lords are to kindly see page number 33, my lords. Further, last para, my lords, liberty is granted to the appellant to argue his case in the case on any day convenient to the concerned party before 30th of.
When you have received.
He makes an application on 2/8.
The registered post.
It is not registered post. It is by way of email also.
I have the cover also. Registered post only it was sent.
Page number 37, my lords.
When you received.
When you
received.
I'll be.
Page number 37, my lords, is on.
After a week of this order, my lord, after a week of this order,
Please.
it was registered by.
With reference,
Received by
my lords.
register post.
Do you deny this page 37?
It is his own document, my lords. It is not the
Adjournment.
document.
37.
Page 27.
37,
37, what is the date of 37?
Yes, yes, yes.
August 2, 2024. Please, with reference to trailing mail, we are here with
My lord.
attaching the statement of accounts
Which one?
along with
Page
the
number
covering letter.
37, my
dated.
lord?
Hard copies of the
Email.
same will be sent by post.
It was sent by post. Next date was fixed on 30th. Before that, there was no dates. I appeared on 30th.
Oh, the court didn't say so. Read it properly again.
My lord?
Read that order again.
Yes, yes, yes. Yes.
Any day convenient before
Yes.
30th of
Further
August.
liberty is granted to the appellant to argue in the case on any day convenient to the concerned party before 30th. Before 30th, there is no date given. How can I go to the DRT court? A date should have been fixed for argument. 30th, I go to argue the matter by the time judgment is pronounced.
That you should have asked the court that day. Why date is not given?
That's why I come before this court. No
I
opportunity
have
was
not
given.
questioned this order.
My lord?
This order of the DRT is not questioned by you. This order dated 37/2024
Yes.
is not questioned.
But
What
30th
you are questioning is an order dated this 30th August 2024.
Yes, 30th August. 30th August, so the date was given. 30th the morning, I go there, the
Counsel,
judgment
you
is.
have to, when you are making submissions, you have to first understand what is the court asking you. I am asking this order dated 37/2024 is not questioned by you. If that is wrong with that.
He waits till the final orders are
That-
passed, thereafter he comes before this honorable court.
My lord.
When last time, my lords, when the
My lord,
coordinate bench went to
30th 7th, my lord, I appeared. I sought for the application.
Have you questioned this order is my question. Please give me one line.
Yes,
answer.
yes, my lord.
Have you questioned?
Which one? This question, my lord, why should I question? They have to give the statement of,
Yes,
the
yes,
order
I
is, they have to give the statement, if I go to the bank, they should give the statement of account.
You make your further submissions.
My lord,
I understood, make your further submissions if any. I understood your argument that no date is given, order is passed.
Yes, sir.
That's why you are before this.
Yes.
Yes, next.
Now, my lord, by this order, they sent the register post in the 2 crore 65 lakhs is the due. My lordship directed this court to give the statement of accounts. My lordship given a statement direction. Now they reduce it to 1 crore 77 lakhs. 1 crore is
The reason is also mentioned there, my lords, why it has been resumed.
My lord, they.
My lords, the DR, we were charging on a contractual obligation at a rate of 16%. When the DRT, my lords, on 30th of September 2025 passed an order to charge him at 10%. That is the reason why it has been
It has been
reduced.
deducted.
If my lords were to kindly see the memo which I have filed, my lords,
My lord, earlier they charged 16%. The
Contractual
not a
obligation.
melon for 11 lakhs due melon, they charge 60% also. It can't be to 2 crore 65 lakhs.
my lords, it is
For
not
4
11
years.
lakhs, my lords, there are
For
3
4
loans.
years.
My friend is suppressing all the
Then,
facts.
no,
There are
no,
3
you are
loans.
suppressing because this court when directed, they have reduced the 10%. Earlier, what you have given the statement upon.
The OA order has
at the
been
rate of
finalized.
16%.
He has not challenged this OA order.
OA, we had to send it for challenging. OA, we had to challenge it. We have a remedy before the DRAT regarding the OA
And
case.
even
Yes,
in-
my lord.
It was the order passed.
30th
Then,
of
my lord,
September 2025.
That is 30th September 2025. We have
2025.
sent it, my lord.
Madam.
Though there is a delay. We are moving regarding the OA order. OA order, my lord, there, the OA order, there it is 1 crore 55 lakhs. OA order.
Yes,
My lord, out of 1 crore 55 lakhs, I paid 1 crore in SA matter.
Yes.
yes,
The OA order, my lord, 1 crore 57 lakhs is the order.
yes.
1 crore which is deposited in SA, it is not deducted. Then my due will be only actually 57 lakhs. 1 crore which I deposited in SA proceedings, that is not deducted in OA. Anyway, there is a mistake. My colleague did not attend before the OA case, my lord. That matter we are taking the matter to the appellate authority. That I am not challenging. Now what the challenge is, one they say 2 crore 65 lakhs. When this court asked for it, it is reduced to 10% into 1 crore 77 lakhs. These are the differences why they are making, my lord. These banks, they can't make the statement like this. It's not a private bank. They should follow the RBI guidelines. Well, under the RBI guidelines, well, they can charge only at 9% under the RBI guidelines. This they are not followed it. And on 30th, well,
RBI has given a standard pattern of interest.
yes, yes, for is, well, when NPA is declared, well, interest cannot be added to that. from the date of NPA, my lord, interest cannot be added to that amount.
After
That is the
decree, we
guidelines
have
of
added-
RBI.
After the decree, we have added to the rate of decree. From the
My
date
lord,
of,
the
date of filing
interest
the
what they
petition.
have added in violation of RBI guidelines. RBI guidelines, after NPA, the NPA what they have fixed is 1 crore 11 lakhs rupees.
Interest is fixed in which proceedings?
My lord.
Interest is
And
fixed.
interest also, my lord, the.
You
note-
don't answer. Problem with you is you don't answer the court's query, you go to the next submission. I
No, no.
said, when is in which proceedings the interest is fixed by the tribunal? In the OA proceedings.
OA, my lord, OA proceedings, what has happened is.
Challenge
Yes.
till now.
Yes, yes.
So don't make submissions on
Yes, yes.
that. Yes.
In OA, they are declared for 1 crore 57 lakhs rupees, my lord. In that, what has happened is, because I was following this Surface Act, my lord, where the mistake to appear. There is a mistake on my colleagues who is not appeared. There is a decree which is an appealable order. We take the matter to an appellate authority regarding the OA.
Yes.
Before this court, my lord, Surface Act, how falsely they can mention as 2 crore 65 lakhs for the 11 lakhs due.
That submission you already made, I have recorded.
Yes, madam.
Yes.
Now, only my request is directly the DRT to look into the accounts properly and give the final figure. I'll pay. I want to settle.
Minutes, I have produced one judgment of 2025. This is an order passed under section 17. They have an appeal or remedy before the DRT under section 18. Writ petition is not maintained.
That I'll
One.
take an appeal. This OA matter, I'll take an appeal, madam. OA
Even,
order what is passed-
even this order also is not appeal, is an
No, no,
appealable.
This order, madam, this court directed me to give an opportunity. That opportunity was not given.
Yes.
That's why.
Third reserve, next.
I have produced the judgment, Milords, in last date.
Give it to the
I have
court.
produced the memo also.
You produced already?
I have produced,
Yes,
Milords,
next.
memo 2020,
Yes, yes.
2025.
Yes, yes.
PNB Housing Finance.
TNB Housing Finance.
I have produced the judgment, Milords, that under any order passed under section 17 is appealable under section 18.
I appear for the petitioner, my lord.
Yes.
But last date, there was a direction, my lords, for the bank to give us a statement of accounts that has not been done.
Who appears to the bank?
Let's, I'm producing the statement. Let's.
Give it to
They
him
were
at
asked to file affidavit.
List this matter on 15/4/20. Respondent bank shall furnish a statement of the loan account to the petitioner. This is matter on 15. By the time if an undertaking affidavit is filed before this court, payment of this court will consider in part, or else matter will be heard on minutes. Now they've given the statement.
Now they
I'll have it day after tomorrow. By the time you come up with an undertaking affidavit, or else I have to dismiss the writ petition. This is matter day after tomorrow.
It's Friday.
The petitioner has a,
Can I request for Friday, my lord?
huh?
Friday.
It's not a working, it's not a working day. Last working day it will come. Yes, it's this matter day after tomorrow. The bank has filed given the statement. You would have given it long back instead of waiting till now. Yes. On the day, if the undertaking affidavit is not on record, the writ petition will be dismissed. Yes, next. Day after tomorrow. Yes.
Appearing
Appearing
for
for
the
respondent
petitioner,
bank,
my
lord.
lordships.
Yes.
In this, there is a one point of contention. This court had ordered payment of 30%. We have done the payment. Not only that, my lordship, if I may take you to the memo of calculation for a loan of 12.72 crores, we have already paid 13.87 crores.
If by
against
virtue of an interim order, if you have deposited any amount, we will
Huh.
ask them to refund it. And you go before the authority where your remedy is.
Obliged, my lord. But and they have been calculating whatever we are paying, it's going to the interest, my
Then
lordships.
you can ask. Please come.
Lordship on small submission, lordship. They have
Tomorrow
not
is the
complied-
option is there, my lord. At least that stay may be granted till then, my lordships.
Yes, yes.
They have not complied any interim order,
They're not
lordship.
complied.
No,
No, it has
lordship, if they are complied, they have not produced any receipts which will validate their claim, lordship. And moreover, they have challenged the possession notice, lordship, and they have filed IA for asking sale notice, lordship.
The
My
petition is
lordships,
filed seeking the-
it has been complied, my lordships. Memo of
Record your submissions,
Huh.
Mr. Counsel.
obligement, obligement.
The,
Memo of calculation.
the writ petition is filed in the following prayer. The respondent is so and so. Against that, a writ petition is not maintainable. A coordinate bench of this court on 18/3/2025 directed the petitioner to pay 5% of the amount before 30/3/2025, another 5% of the amount on 15/4/2025, another 10% of the amount within 4 weeks. According to the land counsel for the petitioner, they have complied with the interim order. According to the land counsel for the respondent, the petitioner has not complied with the interim order. In the light of the law laid down in so and so, the writ petition against the respondent is not maintainable, which is not a nationalized fine. The writ petition is not maintainable. The remedy is before the DRT. In that view of the matter, this court is passing the following order. The interim order dated so and so. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. The petitioner shall have the benefit of section 14 of the Act. As there is an interim order operating from 18/3/2025, the same shall continue for a period of 30 days from the date of receipt of the copy of the writ petition. Next, if the petitioner places any document to show that he has deposited the amount, the same shall be refunded to the petitioner.
Obliged, much obliged. Madam.
Hearing for respondent.
20.
May please. The petition was withdrawn. All that I'm requesting is the benefit of section 14 minutes. The limitation was not excluded in the order. I just wanted that thing to be specified. The benefit of extension, of limitation under section 14 is not
That will
being,
be there. That is not there in
it
this
is not there in the order.
Then counsel the petitioners file a memo seeking permission to withdraw the writ petition. With the liberty of approach, memo is taken recording the writ petition is with the liberty to approach the DRT. When is this order passed?
It's in the month of November, Milords, 13th November.
Why should we give it now? What are you doing? It's unfair. Even if I give in the order, if I give it for 30 days.
No.
And you are, no, why will we go? What are you doing from the November to April?
It's an
It is
NOC.
unfair.
No, it's an
we can't
NOC brief. I got it day before yesterday. I saw that. When I tried to
That
move
is
it
not
before
about
the
you.
DRT, I could not see that exclusion available in the order, Milords.
That if at all.
No,
this
let
is
it
not-
be until the time, until the date, until the time spent before this court, Milords.
That is
That is until 13/11/2020.
13.
13/11/2025, from 26/5/2020.
Petitioner, this court has disposed of the petition basing on the memo.
Less
filed
30
by-
days at least, Milords. So that let me, less 30 days.
Memo filed by the petition that we can't, antedated, we can't get it like that. The petitioner has, the writ petition is disposed of, has withdrawn as per the memo filed. This order is passed on 13th November 2025. Now a memo is moved that the court has not granted the benefit of section 14 for section 14. And as such, they are not able to avail the remedy before the DRT. And also it is submitted that 30 days time as is granted in other cases may also be granted in this case. This court is not able to understand how the petitioner has come before the court after almost 6 months from the date the order is passed. However, in all the cases where the matters are pending before the court is granting the liberty under section 14 of the Limitation Act. Hence, a petitioner shall have the benefit of section 14 of the Limitation Act.
Great.
I disposed of.
Lordship, counsel and record is held up in other portal. Kindly pass over, Lordship.
Writ petition is not maintained.
Oh,
SMFG.
SMFG India Home Finance. Pass over, let him come in the afternoon.
And in this loan also has been regularized.
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 Then why? You should tell that.
Loan
Instead of
account
saying
also.
that it is a
Loan
Land counsel appearing for the respondent submits that the loan is the writ petition is filed against versus SMFG India Home Finance Limited, which is a private finance company. In the light of the law laid down in Vishwabharati's case, the writ petition is not maintainable. It is submitted by the land counsel for
Account
the
has been
respondent bank that the loan account is regularized. In that view of the matter, nothing survives. Without going into the other aspects, the writ petition is disposed of. Yes.
For the petitioner, my lords.
To the respondent.
No, in that way, because it is regularized. No liberty to the RTI. Yes, Pranina.
My lords, I would like to conclude this whole matter within just 3 submissions, my lord. First,
Now, what I remember on the last submissions you made, according to you, you're participated in the joint inspection
Please.
or whatever you call it.
please, my lords.
And you have just signed it blindly without looking at it.
Please, my lords.
It's
And
not the case that you're not aware. According to them, you're aware of it.
my case is still that I am not aware, my lords. Let's coming to my 3 submissions. My
Are you
first,
illiterate?
yes, my lords. I'm a 10th standard fail.
You can do this business, sir.
Yes,
the
please,
past
my lords.
20
It doesn't
years- for the
require
past
me
20
to
years
be
it's
an
been going
a literate person to learn the language of English to be able to. My lords, the respondents have filed annexure R10 and R11.
At least he does not understand other aspects, but he knows why he has gone for a joint inspection. That
Please, my
also he
lords.
doesn't know.
He
been
knows why he
explained to
was
him.
been in the joint inspection because he requested for the said joint inspection.
Yes.
That is not disputed, my lords. My lords, however, having said all of this still doesn't change the fact that the order that is blacklisted me must still bear reasons as to why I was blacklisted. The respondent has had multiple opportunities to place these irregularities at annexure R10 and R11 on record. At the time of issuing the show cause notice, at the time of the personal hearing that I requested, at the time of the joint inspection, at the time of the impugned proceedings also they could have annexed these R10 and R11. And my lords,
Look at the impugned
finally,
order. Come to the impugned order.
please.
Page number.
Page 167, my lords.
Fifty-seven.
167.
157.
Or 160.
Don't you feel that this?
One submission, Your Lordship. The documents that I've produced now are not at all new documents. They form a part of the vigilance report that was given to him.
No, when you pass an order blacklisting a person, shouldn't your order reflect what are the reasons, what are the amounts, what are all the deviations or whatever it is? It can't be so vague as it is.
Previously to this, Your Lordship, when he's given me a reply to the show cause notice, I've also given him the particulars of the vigilance report.
Accepting all that, accepting all that. This is this kind of blacklisting orders can't be so vague like this.
My only
You
submission
expected
is
everything with regard to all aspects, but precisely what is the reason why you're doing it? You could have mentioned you have raised invoice number so and so. That as per that, this is the excess amount you have claimed. So these are all the irregularities. Basing on that, we are blacklisting you.
all that is been given to him in the vigilance report that was given to him, and also been explained to him when he visited the
So for
joint
example, in a show
verification.
cause notice, you say something, that doesn't mean that in a final order, you don't have to say. That should be a speaking order.
That's true, Your Lordship, but my only contention is that the defense
That's
that
why what I do is, I leave it open, everything to you.
Yes.
I only say that these are the contentions of the petition and the respondent, and the impugned order, whatever that is filed by you, along with your objections, that I do not find place in the order. So it's open to the respondents, basing on the material, to pass a order afresh.
Please. Also, Your Lordship may see the prayer that they have sought.
Let's see that.
Page number 27.
20?
7 of the petition. They seek for mandamus to direct the proceedings as invalid.
So that I'll not do. I'll only set aside this order
Please,
in the
madam.
light of the fact that it is not a speaking order. And whatever now you have issued the show cause notice, he has submitted the reply basing on the very same documents. You please pass an order
My lords,
within a period of 15 days from today.
A month's time because they need some time.
a fresh show cause notice annexing,
It'll be redundant, your lordship. I've given him ample
First the
amount of time for opportunity to be heard.
Okay, please, my lords.
Only after that, the show
Let
cause
me
notice has
continue
been.
from there. Please
The
come.
annexures may be annexed with the proceedings, my lords. The said irregularities may be annexed with the proceedings is all my request.
So,
is.
That's what the order, now the order will speak.
Please.
The petition is filed, seeking the following prayer. Is a case of the petitioner that petitioner is engaged in the business of construction and development of petroleum retail outlets and allied infrastructure for the past 2 decades. The petitioner has participated in several tenders floated by respondent number 2. In the year 2022, respondent number 2 floated a tender at survey number for the work of development of a new site at survey number 27/1, Harapur village on National Highway 150A, Sindanur Taluk, Raichur district. Petition has emerged as a successful bidder and the work is allotted to the petitioner. It is a case that the petitioner has successfully completed the work adhering to the terms and conditions of the letter of acceptance, the notice inviting the tender, and the work order. The respondent number 2 has noted that the work was completed by 15/3/2023 within the time frame fixed by the respondents. And an administrative approval was granted on 11/7/2023. Before that, even with regard to the routine deviations, which ordinarily arise in the execution of the work of the nature, the respondent number 2 itself issued an administrative approval dated 11/7/2023, expressly approving the deviations in the work order that forms the subject matter of the writ petition. It is stated that only after the final inspection conducted by respondent number 2's final committee, which physically verified the work executed, checked and the measurements, and approved the release of amounts in favor of the petitioner. It is stated that contrary to clause 7.3 of the agreement, the security deposit amount remitted by the petitioner in favor of the respondent number 2 has not been released till date. It is stated that to the petitioner's surprise and shock, the respondent number 2, represented by respondent number 3, issued a show cause notice dated 29/7/2025, alleging that during a random verification of the work executed by the petitioner, certain irregularities or lapses were noticed in relation to the submission of inflated or wrong wells. The show cause notices alleges that an overall excess claim of an amount of rupees 11,62,000 was made by the petitioner and calls upon the petitioner to repay the said amount. The petitioner submitted a reply dated 5/8/2025, pointing out that the show cause notice did not disclose which particular item of works allegedly pertaining to the purported excess amount of rupees 11,62,000, and the same did not explain the manner in which the amount was arrived at. It is stated that the petitioner further requested that a joint re-inspection of the site be conducted and that the show cause notice be either dropped or in the alternative keep in abeyance until a proper site level verification and reconciliation exercise was undertaken. It is stated that a personal hearing was afforded to the petitioner on 16 and 2025, during which the petitioner reiterated the request already raised in its reply to the show cause notice. The site inspection was conducted on 26/12/2025, and minutes of the said joint visit were also recorded. It is stated that the said minutes do not contain a single observation or finding adverse to the petitioner. While the petitioner was awaiting for a further show cause notice, the respondents have issued the impugned proceedings, whereby the petitioner was placed on the holiday list and debarred from entering into any contract with respondent number 2 for a period of 3 years, namely from 31/12/2025 to 31/12/2028, which made the petitioner to come before the court. Then counsel appearing for the petitioner submits that the show cause notice that is issued is vague, and the petitioner has submitted a reply and asked them to furnish the details, which are not furnished to him. Even the impugned order of blacklisting the petitioner also does not contain the relevant details. When it is submitted that the petitioner, though has participated in the joint inspection, and as per only the fact that the joint inspection is conducted, he has signed the same, but he is not aware of the contents of the same. According to the counsel for the petitioner, no opportunity is given to the petitioner when they're imposing a penalty of this nature. They have to give the petitioner a reasonable opportunity, and an order of this nature cannot be passed by the respondents. The counsel appearing for the respondent submits that the respondents have filed before that. The respondents have filed their objections, and the counsel for the respondent submits that when as per the request made by the petitioner, a joint inspection was conducted. As per the joint inspection, the joint inspection report reveals that what are all the amounts that are
Escalated amounts.
what are all the discrepancies that are found, and what are the irregularities that are committed by the petitioner. And the petitioner has signed the same that is placed before the court, which clearly shows that a reasonable opportunity has been given to the petitioner. It is submitted that there is no illegality or irregularity with the order passed by the respondent. In response to that, counsel for the petitioner submits that the petitioner is an illiterate person and is not aware of he has signed only for the purpose of only as it is asked to sign it only in support that a joint inspection is done, and according to them, no irregularities are found. Next part. Having heard the counsel's only decide, peruse the material on record. This court has perused the order impugned, as rightly submitted by the land counsel appearing for the petitioner. The order discusses about many things, and only at one go, it simply says that an excess amount paid is 11,62,000. Except that the impugned order, there is no clarity and there are no details forthcoming in the order on how this amount of 11,62,000 they've arrived at. No doubt the respondents have placed objections before the court, wherein they have mentioned about how they have arrived at this excess payment, but the same is not reflecting in the order. The respondents, when they are passing an order of blacklisting the petitioner, they are duty bound to mention the same in the order, and the order must be a speaking order, and they cannot expect that the same shall be read from the joint inspection report. In that view of the matter, the petitioner, they issued the show cause notice. The petitioner has submitted his explanation to that. Now, in the light of the joint inspection report, why don't you give a show cause notice basing on that? That would be clear, and The same 30 days time you
Please,
can complete
please,
it.
I'll issue a fresh show cause notice,
The-
considering all the reasons that I've placed before this court.
Considering the fact that the
One
joint
small
inspection.
fact to bring into your lord's attention, the irregularities placed at Annexa R10 and R11 do not contain the date of the
The joint
document.
inspection report is already, the joint inspection is conducted. Basing on that, the respondent shall issue a fresh show cause notice within 10 days from the date of receipt of the copy of the order. And by clearly mentioning what all the details of the said irregularities as alleged by the respondents. To that, the petitioner shall submit his explanation within 10 days from the date of receipt of the copy of the show cause notice, and from what time from there on?
15 days, Your Lordship.
15 days from there on, the
Within
respond.
15 days.
Huh?
Within 15 days.
Within 15 days from the date of receipt of the reply to the show cause notice, the respondent shall pass appropriate orders. Accordingly, the order impugned is set aside.
Your Lordship, one submission. My contention that all these documents that I've produced form a part of the vigilance report that was given to him may be taken.
It is submitted that all the documents forms part of the vigilance report,
That
which
was-
is given, a copy of
Please.
which is given to the petitioner. In her contentions, you please record this. Yes. Yes, next. Yes. This petition is allowed.
And appear for the petition. Section 14 benefit, my lord, is what I am seeking. The matter, my lord, is disposed of, my lord, since it is against the private bank. 16th March, my lord. The petition, my lord, has been disposed of.
Where is that?
But on 16th of March 2026, my lord, the matter has been disposed of. By way of IA, my lord, I am seeking section 14 benefit.
The petitioner, this court has disposed of the writ petition on 16th March 2026, placing on the memo that's filed seeking permission to withdraw the writ petition. Today, the IA is moved seeking clarification of the order. It is submitted that in the said order, this court has not granted the benefit of section 14. Hence, accordingly, the IA 1 of 26 is allowed. The petition shall have the benefit of section 14 of the order. The same shall be clarified in the order, and the corrected copy, correcting the order, and the corrected copy shall be uploaded immediately. Yes.
Obliged.
Appear for petitioner, madam.
Yes.
And on the last date of hearing, there was a direction.
Correspondent number 1, madam.
Sir,
This matter, hand summons have been sought to us without a copy of writ petition and annexures to the writ petition.
I'll serve copy minutes. Last time there was a direction to minutes, serve hand summons with a direction to minute approach DRT in terms of section 17. Kindly peruse the last date order minutes.
Yes.
So already approached the DRT.
File an effective remedy before the DRT. Submits a petition is a third party.
Please.
Can approach against steps taken. However, considering the urgency has stated with the petitioner that the auction to be conducted shall not proceed with the auction. Is this matter? Yes. Now go to the DRT.
Yesterday we already filed the application before the DRT. Let them not to precipitate the matter till the consideration of interim prayer. Because of
Fine.
yesterday I filed in minutes. I will serve a copy.
The writ petition is filed in the following prayer. Initially, this court has granted a direction not to proceed with the auction. Auction was concluded.
No, madam.
As per the order passed by the court, the respondent bank has not conducted the auction. When counsel with the petition submits that, they have approached the DRT and filed an application yesterday. Considering that the petition has the benefit of an interim order, the respondent bank shall not take any coercive steps for a period of 30 days from today.
Please.
Accordingly, the writ petition is disposed of. As the petition is already available of alternative remedy. Yes, 32.
I appear for the respondent bank in this matter, my lords. Yesterday, I filed the wakalat on behalf of the bank, my lords, and received the petition copies. I may be permitted a short date, my lords, to file the objections, my lords.
We make a submission, my lords. My lords, 13-4 came to be issued. I approached DRT.
Now, why the court is, issuing notices, if you get instructions, he'll not get interim order. If you seek time, then the court has to consider his IA for the interim, the stay.
My lords, one submission, my lords, as per my instructions, my lords, yesterday, the thing is, they had approached the DRT And the DRT issued an conditional stay order, my lords, in order to, they were in, as per the conditional order, they had to pay 2 installments, my lords. First installment was paid, yes, my lords, first installments was paid within the due date. But second installment was not paid within the due date, my lords. They have paid after the due date, my lords. After the due date, when they have made the payment, they had 2 loan accounts, my lords. They have adjusted the amount to the 2 loan accounts, their own 2 loan accounts, my lords.
Lords, may kindly to
It
page
is the only
110.
issue, my lords.
Page 110.
Just give a short date, my lords.
Counsel for the respondent bank filed memo and submits that the loan account in question was upgraded by the applicant. The respondent bank is not proceeding with the Surface Act and prays for dismissal. Lords, may kindly come to page 21, the impugn notice.
90?
21. That's 0.5. After the due to non-payment of EMI, again your account has been classified as NPA on 13/10/2025. 10/9, my lords, they appear before the DRT. They say that my account is regularized. 13/10, they say my account is classified as NPA. My lords, DRT directs me to pay 18 lakhs.
Oh, it is 30, 13, 10, 20. What is question before this court now?
My lords, this notice, my lords. My lords, I was directed to pay 18 lakhs. I pay 18 lakhs. Because they adjust it to 2 different accounts and classify my account as
Let
NPA.
them, when you know this is, they're not going to take any steps now.
My lords,
Let
they have
them
issued fresh possession notice, my lords.
Because again, the account has been classified as NPA, my lords.
Start before the DRT, they made a submission that the account is regularized. And again, they issued a impugn notification stating that the account is declared as NPA. Then counsel FIU respondent submits that, they'll come up, they'll file their objection. Then if a reasonable time is granted, considering the same, they shall be, the respondent bank is directed not to take any coercive step. Let's this matter immediately after vacation.
Grateful, lords.
Kindly short pass over, my lord, senior.
What is this?
230. Yesterday, there was a direction note
But
to serve the
seriously,
copy on time.
senior in total number 21, my lord.
Yes, sir.
Fresh matter. Yes, pass over.
Great.
Please.
I appear for petition. I seek for short pass over.
Pass over.
What is that?
Is certified?
Please, Manoj.
Or you're appearing?
May it please the honorable court.
Disability.
Huh.
In fact, we have taken a decision to give 5% only for disability thing. Earlier, Manoj, it had given 15% under different categories. Segregated 5%.
There are different categories of disability.
4 categories, Manoj, scheduled caste, scheduled tribe, backward. Only for disabled
Take
people,
that.
Manoj, 5% we are sought to earmark, Manoj. And
Now, what is the date of these proceedings? 23/4.
please, Manoj.
So as per this, now this person is, he falls under which category? Disabled?
Disabled category, Manoj. So he is entitled for concession, Manoj, in terms of this order at page 12, Manoj.
Oh. So what is the relief that he is seeking in the writ petition?
He is seeking to implement section 37C of the Disabilities Act, Manoj.
So in the light of this, it can be disposed of.
Manoj.
I'll pass orders in his, let the petition be there in that.
Please.
Yes, sir. Pass over.
They might copy. I haven't received the copy.
Yes.
Petitioner's lordships. When correct statement is provided, the petitioner is ready to pay.
Jana Small Finance.
Jana Small Finance.
That's why he's moving the memo in all the petitions.
Yes, ma'am. If true and correct statement is provided, the petitioner is ready to pay the outstanding amount.
Positionals has been handed out. Positionals has been handed out, my lords.
Handed over to the
petitioner, my lords.
Yes.
As per court order.
2 lakhs was paid.
When is the order passed for this court?
My lords, on
Then
17/12/2020.
ready to clear the outstanding amount, then counsel to hand it over a demand draft number dated drawn in the favor of so and so, submitted it to some, but this is passed in the month of December.
Yes, sir.
Account has become, now the bank has taken possession, literally they are on the streets, consider the fact that so and so. Respondent point, consider submission of confirmation, there shall be stay of all respondent. Respondent shall redeliver the possession within 2 days from today, and bank shall not take any purchase step. What is the present stage now?
And it's total present outstanding.
Account is regularized.
No, my lords. No. 6,77,065 is outstanding.
6 lakhs?
77,065.
When will you pay that?
No, I
Only
don't think
two
that
things.
much is outstanding, ma'am. I don't think that much is outstanding.
There is a
There's
present
some-
outstanding after deducting of 2 lakhs, my lords.
Some error in the calculation.
Come up with an undertaking affidavit,
Yes,
take the statement, the respondent bank shall provide the details of the account details to the petitioner. Petitioner shall file an undertaking affidavit before this court. This writ petition is filed, this order is passed by this court on
17/12.
on 17/12/2025. Thereafter, all the writ petitions that are filed against bank which is not a nationalized bank and assessed reconstruction companies in the light of Vishabharati's judgment as a writ petition is not maintainable are dismissed, considering the fact that basing on an order passed by this court, already possession is redelivered and the petition is ready to pay the outstanding amount. This matter after vacation is parted. The interim order earlier granted shall continue.
Your ladyship, may I be permitted to make a submission? Serial number 35 was skipped. It was not called out. I appear in serial number 35.
Passover, it is already called.
It's passed over. Obliged.
Yes, yes.
For the respondent.
Petition here.
Huh?
35 serial number.
Passover, yes, handed over the notification or some order of the government whereby they are giving 5%, they already have passed orders. Disability, that is a writ petition.
It is different, the homeopathy,
Huh?
the practitioner. 35, sir. The serial
I think that is 34, you are not called 35.
35 not.
No, 35 was skipped, your ladyship.
Who asked for Passover 35?
Nobody had
Nobody
appeared
asked.
actually.
34 Passover, they asked for Passover.
My lords, when 35 was called out.
That is 34. Call 35.
Still number 35?
Please,
Appear for Union of India, your ladyship.
please. Petitioner is a practitioner, madam, the electropathy and homeopathy practitioner. And respondents, they are not allowing him to practice.
No, you cite, this matter came up yesterday.
Yes.
No, you cite, the medical council and the high court guidelines, they say that you shouldn't have the prefix of doctor. In the writ petition itself, you say that you are doctor.
No,
How are you entitled for any relief from the court?
Prefixing the doctor, I can be practitioner.
First of all, you have to answer to this. First condition in the judgment is you shouldn't. And in the
Madam.
17.
17.
Yes.
Annexure D. Registration number so and so, I hereby certify that Dr. Vasudev's son of so and so and Dr. so and so. Yes, certificate is issued, madam, for practicing as a doctor of homeopathy and the electropathy. And annexure C is also.
One more thing which I am not able to understand is how are you seeking a direction against a Panchayat Development Officer?
Panchayat Development
How
Officer.
is he
they
concerned
should-
with all this?
The other respondents are concerned, madam. They give the representation to the.
Which respondent? You tell the court which respondent you are seeking a
Respondent
direction.
Respondent number 1 to 7, 6 madam. 1 to 6.
What is Union of India doing? You have to say what is it they are doing.
There is a judgment, madam, the covered by judgment.
It's not about the judgment. You
I
are
just
seeking a
agree.
relief from the court. What these respondents are doing. Because somebody has made a respondents as parties, you can't make them a party unless and until you're agreed by their action.
Annexure A, they issued a general license, my lord. We are practicing in the Panchayati area.
Where is that?
Therefore, Annexure A, my lord.
Where is that?
That is page number 15, my lord. General license.
15 is general license.
Typed copy in Kannada, my lord.
That is true.
So we made a representation and considering the representation collected 1,000 rupees fee and issued general license in the Panchayati limits. And subsequent to that, that has not been renewed. And the respondents
Please come to your elements in the writ petition. I'm not able to understand.
Please.
Where did you say? What did you say in the writ petition?
Just I will read the annexure A and B, that is para number 1 and 2, my lord. That petitioner has made representation to the 7th respondent PDO dated 1/7/21 permitting him to run clinic in the same and style of electro-homeopathy, for which after considering the documentary evidence, the 7th respondent PDO has permitted and granted general license imposing certain terms and conditions run his clinic on 1/7/2021 and collected fee 1,000 from the petitioner. Same is valid up to 31/3/2022. The copy that is
Who
annexed
appears for the respondent?
respondent number 1, 7 minutes. PDO is 7. And as far as annexure B, my lord.
Yes.
Annexure B, para number 2, my
Who
lord.
appears for the first respondent? Where is he? You appear for which
I appear
respondent?
Union of India, Your Ladyship. Union of India is respondent
What is-
number 3. So of what I've received instructions to file objections, but subject to that, of what I can see, there is no aggrieved notice or any action that is challenged in the present writ petition. So what is not clear to me is who is coming in his way of doing what he wants to do. But that said, this electro-homeopathy is not a recognized form of medicine. So the Union of India has not approved of it, although there is a National Commission for Homeopathy, which regulates the medicine and practice of homeopathy. Electro-homeopathy doesn't come under that. So the Union of India had actually constituted a committee, and the committee could not place enough material on record to show that there is a scientific basis for the practice of this form of medicine as if it's a traditional form of or an alternative form of medicine. Therefore, it's not recognized and no institutes are permitted to conduct any courses or issue any certificates. But whoever was already practicing, there was some kind of leeway provided to them. That is what has come in all these judgments. But as the Honorable Court has pointed out, they are not recognized as doctors. So they are not entitled to affix or prefix any kind of a title as doctor. And what is not clear to me is the cause of action currently as to what he is complaining about.
Cause of action is the order which is granted in others' favor. Please
That
come
also
to
doesn't,
your writ petition and show you are agreed by whose with action of which respondent.
Para number
Para number?
Para number 12, my man.
Yes, please read.
The Government of India in its letter dated 14/2/2011, bearing number so and so, informed that through its order dated 5/5/2010, bearing number so and so, clarified there is no bar to electro-homeopathy practitioners to pursue practice or to impart education in the stream. That the respondent number 3, Union of India, 26/6/2011 passes another order number so and so in pursuant to the representation filed by the practitioners in pursuant to the order of Allahabad High Court, Court and Lucknow Bench WP number 3992 of 2004, wherein it is made ample clear that the order of the Government of India dated 25/11/2003 was misrepresented as if the Government of India has altogether prohibited the development of research of electro-homeopathy. However, the central government in the order dated 5/5/2010 clarifies its stand, gave clear sheet for practicing and imparting educations in the electro-homeopathy. Malad, there are several judgments, several writ petitions.
Don't go to all those judgments.
Please.
Please tell the court you are agreed by the action of which respondent, which you have questioned it before this court.
I am aggrieved by the 7th respondent since they issued a general license that was lapsed in the year 2022.
Where did you say so?
That is first para itself that is there. And
What is that?
13/3/2022,
What is that they have
Annexure
given?
A.
Let's see.
Thereafter, they are not renewed.
General license. What is
General
this
license.
general license?
That is valid only 31/3/2022, my lord. Thereafter, they have not renewed that license. And there are several writ petitions.
What
which
is the business of this panchayat officer in giving
that
the
is the
license to
clinic
them?
in the jurisdiction of
Who
the
appears for the
panchayat.
respondent?
Senior, respondent number
I am
3, Union of India.
Seventh respondent.
It appears notice has not been served on the seventh respondent, my lord.
And the writ petition, which is the relief in this manner, how is the petitioner entitled? Let there be 100 judgments in this regard.
In this regard, same judgments, my lord,
I will not
latest,
consider all
latest.
this. There are notice to the respondents. Yes, 3 also, R7, and look at it, other respondents, if anybody is appearing or not, responding to all, notice to all, yes.
My appearance may kindly be recorded, Your Ladyship.
Yes, yes. So and so for the Union of India.
Obliged.
Yes, next.
Petitioner. Then for the respondent, my lordship.
Counsel for
In the last
petitioner
date of
without
hearing.
declaring the account, without declaring the account as NPA, without issuing a notice under 13 to the respondent bank has proceeded to issue a notice under section 13.
I may be permitted to
Take that,
place
you
the
have given him a copy of it?
Sir,
Yes, what do you say on your submission?
Your Lordship, at page number 13 and 14, there are submitted documents. In that one, the acknowledgement, the postal one is returned as insufficient address returned to the sender. So that is the one thing, Your Lordship. And another
Not
content,
served on him.
my lord, page number 10 may kindly be seen.
Page number?
10. Because of that, we have taken the paper publication for the demand notice in Kannada and English both. Because he couldn't able to trace out the address he given. So we have taken the paper publication for the demand notice.
What it says? Page number 15, when you sent a notice, what it says?
The address he left.
No,
So-
no, no, Your
So we
Lordship.
don't have an other than demand notice itself, we have taken the paper publication.
Where are
and
you staying now? What is the address that is furnished in this writ petition?
We are there in the scheduled property only, scheduled property, Your Lordship.
Postal shara we received.
It's a house
C.
property, Your
Son of
Lordship.
so and so, Parvatipura, second cross, Hoskote. The second cross is not mentioned in this order,
Yes,
in
Your
this address, which is furnished to you, by you to the bank.
And the possession notice also, we have taken the paper publication, affixture, and the same postal acknowledgement we have received, Lordship, in that one. And the physical possession, section 14 order also taken, we have affixed.
So is the 13-4 notice?
The 13/4 notice is dated 9/7/2025 at the page number 12.
And another contention is, Your Lordship, that initially we have to, the applicant number 1 in the notice, he has obtained the loan. As a co-applicant, his wife made as a party, as a co-applicant to the agreement. Thereafter, the co-applicant obtained the OD from the bank. That is also included in the surface, Your Lordship.
What does it mean, co-applicant?
Sorry, Your Lordship.
So that shouldn't be added in this.
Yes, my lordship, it will not come under the Surface Act, my lordship. OD will not come under the Surface Act, and MSME scheme also they are included in this Surface Act, my lordship.
Explanation to it, the RBI guidelines, my lord, court is well aware, when it is not the facility wise we are classifying the NPA. Once it is the borrower wise, Lordship. So that document is there, Lordship is well aware, that is the reason, Lordship. So classification at the borrower and the co-borrower, any one of these makes it, so obviously the all accounts all falls under the NPA. That will be my submission related to that.
No, if they have to go before the RIAT.
Yes, Lordship, if they have.
No, the limitation will come. You have issued the possession notice on
Yes.
some date. No, they are not aware of because notice is served for whatever reason and you have taken out. Then how will they go to the DRT now? File your objection.
Yes.
In these circumstances. The land council appearing for the petitioner submits that they have not received the notice, either under 13.2, 13.4. According to the bank, they have issued the notice to the petitioner on the address furnished, as the same is returned as no such address. Hence, the bank had published it in the newspapers by way of substituted service. The 13.4 notice is issued on
13/4/97/2025.
9/7/2025. In these circumstances, this court deems it appropriate to direct the respondents to file their objection so that the contention that are raised by the petitioner can be looked into and decide the dispute between the parties. Yes, till such time, the respondent shall not take any coercive steps. Does this matter after vacation on 12th of June? By the
Lordship,
time,
direct some payments to be made with them. That is the thing. That will a humble
No,
submission.
Your
because
Lordship, another contention is that
the default is there.
we are ready for our account, whatever is there,
amount.
borrower
Borrower
account.
account, my lordship.
What is that amount?
Actually, we borrowed 44,32,000, Your
Huh?
Lordship. 44,32,000.
How much you are going to deposit now?
10% of my lordship.
No 10%, 5%. When you are accepting it, at least you should do it.
My lord, 1,57 lakh percent outstanding as on 21/2/2026.
20 lakhs will
My lordship,
accept.
considering on the all four accounts.
An amount of rupees on condition that the bank shall not take any coercive step on the condition that the petitioner shall deposit an amount of rupees 20 lakhs within 4 weeks from the date of receipt of the copy of the order. This is matter on same date. Yes.
Your Lordship, another 2 weeks maybe.
Huh?
Another 2 weeks
2
will
weeks,
be,
my lordship.
because
6
it's
weeks, within a period of 6 weeks.
much of.
Yes. Yes.
Lords, on 17/12/2025, this honorable court passed an order directing the auction purchaser to approach the DRAT. It is at page number 58.
Who are these respondents? Manish Kothari, Managing Director?
Manish Kothari is the auction purchaser.
You can't file a writ petition against Manish Kothari.
Now, my lords, what I have done is, I've sought the quashing of the proceedings before the civil court under Article 227. Manish Kothari is the person who has filed case against me, civil cause
How this
case
writ
against.
petition is numbered?
Lords?
How the writ is numbered? I think they are completely lost their mind. How a writ petition can be numbered against some Manish Kothari, that is WPDRT.
Well, Lord, what I have challenged is the order of the civil court. No, they have. I made it as WPCTC, but they made it as the GMDRT.
How can it be? It can't be numbered as DRT. The office can't, the writ petition is filed against a private party, questioning proceedings before the civil court. And a writ petition in the, as the GMDRT is not, it can't be listed as GMDRT. The official look into.
Maybe directed to change it to the GMCPC.
Yes.
In this case, Petitioner Malad has sold a portion of the property to the respondent number 2 Malad.
What is that?
Petitioner has sold portion of the property to the respondent number 1. And it's
What have you questioned in this writ petition?
I'm questioning the notice under Annexure H Malad. Annexure G Malad.
You are questioning a notice under section 13(4).
Annexure G notice.
On what ground?
Malad, on the ground Malad, the property is sold measuring 297.28 square feet.
Huh?
Whereas property is sold measuring, you are actually turn to Annexure A, shall deed.
Who are you?
I'm the owner of the property.
You question the notice under 13(4). On the ground?
On the ground, there is
13 for the
possession notice now. They have issued
Lordship, my
notice.
sir,
That
13 for
time the
notice. It is
property
not
was sold
13 for
to the-
notice. It is not a 13 for notice.
Right.
We have only bank has only given notice. Please hand over possession last.
And our possession, contrary to this property sold to the respondent number 2, excess property, my lord. You will actually, that is forthcoming in the Annexure G. You will actually credit into Annexure G, page number 50, my lord.
Who is respondent number 2?
Respondent number 2, whom they have sold the property, he
Borrower.
mortgaged the property deeds and obtained loan, my lord. Housing loan. But whereas the possession is noticed under section 14, and no notice is given for taking possession for measuring 351.91 square feet as against 297.28 square meters.
No election.
Property is sold.
1 minute. Where is your document which is mortgaged to the
Annexure
bank?
A, my lord.
Yes.
Annexure A measurement.
Page number?
Page number, in page number 31, schedule A property. Measurement 297.28
Where do you
square
get
meters.
it?
Page number 31, my lord.
Please come to 31.
297.28 square meters. property sold.
And now please come to the notice.
Yes.
Page number.
Now, page number 50.
First floor, property being on the first floor, having a super built-up area, 297.28 square meters.
Below my lot. Full complete. And that is totally measuring 351.91.
First floor measuring about 297.28.
Schedule B
Below my
property.
lot, below. Below the totally measuring 351, together with 1,000 square feet, undivided share.
It will be, come to page 32. That is also mortgage.
But schedule B property, it is not sold, my lord. Only built up area, they have to take possession, my lord. Only the flat, not this portion. Only the A schedule property. Not the entire property.
You're saying that this is a property mortgage to the bank.
Yes, ma'am.
A schedule and B schedule both are mortgage to the bank. You have not seen the
Yes, this is undivided, they can't take the undivided share, only the 297.28 square meters they can take. Possession, that built
a
up
super
area.
built up area on the
Yes,
first
ma'am.
floor constructed in the scheduled property together with 1,000 square feet of undivided share, right, title and interest in the southern A property together with common passage. Look at it, pass over.
Yesterday's matter, Ravi Shankar will appear. Yesterday's matter to file the valuation report. He told he'll appear on 2:30.
Yes, pass over.
Lord, 41 and 42 I am here for the petitioners council.
Yes.
Would your lordship kindly take the Recovery of Debts and Bankruptcy Act 1993, my lord, RDDB Act. Lord, what is in challenge here?
No, is it necessary to make the chairperson of the Debt Recovery Appellate Tribunal Chennai as a party to the as a respondent to the writ petition?
Lord, the thing is that there are other matters. What has happened is there was a notification issued by the Finance Ministry transferring cases in which the debt due is more than 100 crores from Bangalore to Chennai. So I had the Debt Recovery Tribunal in Bangalore, Lord. This tribunal has now shifted everything to Chennai. Is that an effective mean?
We'll ask them to find out.
Pardon, Lord?
We'll issue notice to respond.
Yes.
Union of India, who represents?
Pardon, Lord?
Union of India, who represents? Council.
My lord, earlier there are other writ petitions that are pending before this court. Earlier, Mr. Shanti Bhushan was asked to take notice.
Mr. Shanti Bhushan is there to take notice on behalf of the first respondent. And what about the two?
Two, my lord, I don't know who is the standing counsel, my lord.
The notice to respondent number, only two. This is matter after vacation.
And I have sought for stay, my lord. Lord, in other cases, there are connected matters, there are stay, my lord. Lord, let me tell you, lordship, what. Lord, it's a matter of.
That order.
Yeah.
But no, we have to at least understand and examine.
No, not only that. It's, no, my lord, it's not just this court. The Kerala High Court and the division bench of the Bombay High Court, the same notification covers everything. And now transfer petitions are pending in the Supreme Court for consolidating all these matters before various high courts. Now, your lordship sees the reason why your lordship may just.
Notification issued.
Pardon?
Notification is issued when?
14/10/2022.
That we will not state it now.
No, but I'm not asking for that to be stayed, the proceedings to be stayed against.
What, a notification is issued long back, you went to the tribunal long back.
No, 22, after the notification was issued, these petitions are filed much later. 23 and
File the petition.
23, 24, they are filed, my lord.
So 23, 24 petitions that are filed on the ground that some interim orders are granted. In 26, we can't stay the proceedings before the DRAT or whatever it is in Chennai. We can't list.
May I just request your lordships, my lord, in case it is precipitated, I may be given liberty to move for asking for stay. That's all. It should not be that it has been refused.
The senior counsel appearing for the petitioner submits that and use the orders passed by a coordinate bench of this court and other high courts. There shall be stay of all further proceedings before the third respondent. The notification that is challenged before this court is of the year 2021 or 22.
No, 14/10/22.
14/10/2022. And the petitions that are pending before the third respondent is of the year 23 and 24. 23 and 24. In these circumstances, this court is not inclined to grant any stay as is granted in the other cases. And after vacation, this court will consider the legality or otherwise of the said notification issued by the first respondent.
Obliged.
40?
Please, your lordship. Your lordship will recall yesterday that Indian Bank was there.
Yes, Mr. Muttanna, any instructions?
My lord, this is
41 and 42 same order.
40?
41 and 42.
41, 42 same
Both
order.
relate
This is regarding that surfacing notice which was backdated deliberately. When we made a complaint to the executive director of the bank. The zonal manager has been transferred out from here for doing this thing, for backdating the surfacing order.
My lord, this is the matter, my lord. There are 3 loans available by the borrower. Out of 3 loans, 2 loans, according to them, it is regular. 1 loan has become a defaulted. So now, as per the RBI guidelines, that RBI guidelines just identified that all these 3 loans have to be treated as NPA.
Backdating that.
Not backdating. There is no backdating, my lord. This was treated as the NPA on 7/3/26. The loan account was treated as they issued 13-2 notice. 7/3/26 was the date of NPA. Then when 7/3/26 when treating the NPA, he had another 2 accounts. So all the 3 accounts will become automatically NPA as per the RBI guidelines. I'll just read the RBI guidelines, my lord.
That I am aware of that.
Just my lord. Then there is no this and for this side customer is writing to the police that unauthorized against authorized officer that he has committed and all.
When is the first account declared as NPA, which date?
Only 1 account has been declared as NPA.
When?
That is 7/3/26.
17?
7.
7/3/2026 with the back date of 7/3/25. The notice which was sent to me is dated 7/3/2025, but in their records it is 7/3/2026 apparently. That is what he is saying. But if your lordship sees, I have shown the notice to you at page 71 of this thing. Kindly see for one moment, your lordship. See annexure G, page 71. This itself shows it's a bank, this is not some small time government office or anything.
So 71 shows 10/3/2025.
25. This notice they issue to me when out of a 3.16 crores my sanctioned loan, I have only taken 1.25. They did not release the rest.
No. Your account, you have 3 accounts.
Those are 2 Koramangala accounts.
1 account was declared as NPA. At least you are aware of that.
This letter which they have said, they have declared NPA for what reason? May I just tell your lordship? Firstly, backdated, so that I don't even get 60 days. Secondly, why they did this was that my sanction loan was 3.16 crores. I only availed of 1.25. My request was, kindly give me EMI for 1.25. I don't want the remaining amount. The zonal manager had a personal agenda on this matter, and he asked me to pay an EMI for entire 3.16. That's how this has become NPA. Otherwise, it would not have become an NPA. So this is all deliberately done, for which I had to go to the police station as well.
That's a different aspect.
Yes, ma'am.
What I want to know is,
yes,
You have 3 accounts.
Very, yes, ma'am.
One account has become NPA.
According to them, which is wrongfully done.
This NPA was when?
My lord,
This NPA, one account.
one account.
What is the date?
That is that as per the notice, the 7/3/26.
7/3/26. When did you send it to him? Where is that 7/3/2026?
That is 25 only. That he says 26, but it is 25.
Where do you get that?
Page 71. Kindly see page 71. Yesterday also, Milad, I pointed out.
It says 10/3/25. Look at 71.
Kindly, your lordship may kindly pass over, my lord. That will check that. It is the case then.
Much obliged.
Here for the petitioner, my lords, there is a section 13(2) notice issued by an asset restructuring company, my lords, and the objections under 13(4) are not considered, although filed within 15 days by the petitioner, my lords, and the notice is at page number 134, annexure N.
No, you're questioning what is the relief that you're seeking in the writ petition?
That no further action should be
Accept
taken
the
by
arrears of
the
interest principal due under loan account and to revise the said account from non-performing asset. Why should all we do it? Why should the court do this all exercise? Respondent number 5 and all other credit information bureaus to forthwith rectify and update.
Please, my lords. My lords, may I
Such a
explain,
petition
my lords?
objection. Who has given the notice under section 13 to which
My lords, that
respondent?
is the asset restructuring company, because
Which
the
is-
loan
where
was.
is it? Where is it?
That is at
Eight.
page number
So,
134.
if you are agreed by the notices or the surface proceedings.
Yes, my
That is
lords.
initiated by the asset reconstruction company, you have to go before the DRT.
My
You
lords,
can't
I
come
have,
before the
I
court.
am very grateful for that question, my lords. Please accept my judgment, my lords, which is the other one also. My lords, that can be done. My answer is only if 13(4) is initiated by the bank, which has not happened in this case. I will just
There can't be
submit a
any
judgment,
distinction
my
like
lords.
that. It is not about an alternative remedy.
No, my lords, I will submit a judgment on the exact point, my lords.
Yes, take it. Take that.
My lords, kindly take para number 16 and 17 of that judgment. my lords.
Why are you going to 2009 SCC? You have a latest judgment. Look at the latest judgment.
Please, my lords, I
For the latest judgment, give the citation. Look at it.
My lords, if I may, my
No,
lords,
no, not
please.
required.
My lords,
You
my
don't have to
only.
waste that time. I'll hear you in the afternoon. Look
Please,
at
my
the
lords.
judgment,
Please,
what the
my
court
lords.
officer gives.
Please, my lords.
Yes. Yes.
My lords, appearing for the petitioners,
Hmm.
we are seeking to quash the vacation notice dated
Come to the prayer. Vacation notice dated so and so.
21st.
Officers, why we should interfere with this notice?
My
What are the
lord?
reasons?
My lords, the demand notice and the possession notice weren't intimated to us, weren't delivered to us on time. Moreover, they've initiated proceedings at the magistrate court seeking for protection and to take over possession of the property. However, the order was passed in
What is the
March of
outstanding amount?
2024. Outstanding amount, my lords, it's a loan amount of 37 crores, 33 crores, but the full amount hasn't been disbursed. Moreover, talks of OTS have been going on since 2024. In fact, even in the second week of April, the banks and the petitioners are speaking orally. They have agreed to a total OTS of 17 crores, out of which 7 crores have been paid. Balance is 10 crores.
Yes.
However, my lord, following the magistrate order of March 2024, a vacation notice was issued in April 2026, and only a time of 8 days has been given to the petitioners. My lords, in the property there are tenants, commercial as well as residential, and 8 days is a really short period of time. We are seeking for a stay of the vacation notice as well as to quash the vacation notice, since OTS talks are in place.
The account turned NPA in 2023, and that is on 26/2023.
Then subsequently, magistrate order is 25/3/2024. Subsequently, they went to NCLT, took the benefit of moratorium for 2 years. Now those applications have been dismissed. Now there is no moratorium. So we are now issued a notice for taking possession. But they can go to DRT if they want, my lord. There is no grounds which are raised.
Please come. The
My lord,
President-
proceedings in DRTA are in progress as we speak.
DRT also, you've gone to DRT?
Canara Bank has initiated
We have
proceedings.
filed OA.
proceedings.
We have filed OA for it.
The writ petition is filed in the following prayer. Then counsel of the petitioner submits that the bank has issued the vacation notice. The OTA, the talks are going on with regard to the OTS proposal. Further, it is submitted that it's a commercial and residential property, and the respondents have failed to, they have not issued the notice on time, and there was no occasion for them to respond to the same. Hence, the proceedings may be state the land council appearing for the responding bank submits that the surface proceedings were initiated in the year 2023, and after that the petition has 2023, and in the year thereafter they approached the NCLT and had the benefit of the moratorium being in effect, and no proceedings could be initiated by the bank. And recently the NCLT has dismissed it
On 5/3/2026.
on 5/3/2026, dismissed the same. Thereafter, they had the order of thereafter the magistrate has passed the order and they've issued the vacation notice. It is submitted that looking at the substantial amount that is pending, and that the petitioners have an effective alternative remedy under section 17 of the Surface Act. The writ petition before this court is not maintainable. Next paragraph. Having got the counsels on either side, there is a submission on the court. The outstanding loan according to the bank is
33 crores, 27 lakhs, 45,000.
33 crores and odd. And the petitioner had a benefit of a moratorium for a period of 2 years. The petitioner, if he is agreed with the vacation notice that is issued by the respondents or any other surface proceedings that are initiated by the bank, appropriate remedy, and which is an effective alternative remedy before the DRT, but he cannot come before this court by filing the writ petition, considering the facts and circumstances of this case. Accordingly, the writ petition disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. Same section 14. The petitioner shall approach the DRT within 30 days from the date of receipt of the copy of the order.
Lordship, pray for alternative, my lord. In just a 4-week time period may be given, they will make necessary payments, whatever 10, 15 of percentage that the court deems fit. The petitioner will requesting for a conditional order, my lord. In this conditional order, if they do not make the payment on the next date of order.
36 crores, what is the 33 crores? What is the conditional order? And this court will not grant anything like 10%, 5%, no.
That 33 crore itself is
That's why
in a dispute.
you will get the same thing you agitate before the DRT, you will get a better order from there. Yes.
Pray for no adverse order in the meanwhile while we approach the DRT, because once they take possession.
30 days given time, they can't do anything till 30 days
Please.
from the date of receipt of the copy of the.
Please. Great.
May I please, Lord, appear for the petitioner, my lord. I am the purchaser, my lord.
Purchaser of the property.
Property, my lord. The e-auction was on 17/2/2026, my lord.
The quashing the communication dated 12/3/2026.
Please, my lord, it is on page number 17.
Which bank is this?
Bank of India, my lord.
Huh?
Bank of India.
Bank of India.
Please, my lord.
Where is Mr. Muttana? Who else appears for Bank of India? You appear? So Mr. So-and-so is directed to take notice on behalf of the bank, serve the papers. Tomorrow I'll take up.
My lord, I have sought for stay of forfeiture order, my
I will
lord.
not grant that. Tomorrow I'll hear.
Please, please.
The so-and-so is directed to take notice on behalf of the respondent bank. Then counsel for the petition, so the copy of the writ petition. Counsel for the respondent shall get instructions. Does this matter tomorrow?
Much obliged.
Yes, next. This 48, admit post of final hearing, call for the TCR. 49. Admit, no, since something TCR to be called. So 49, admit, TCR is already there. 49.1, also there is no TCR. Call for the TCR in 49.1, 50, admit final hearing TCR, and 51 only admit final hearing. 52, TCR is already there, so admit. What 52.1, what is a DM?
I appear for the respondent.
No, what is a DM? It is 52.1. It says MVDM means what?
They have not served the copy.
Categorized as MVDM. That I'm not able to understand. So this 52 listed tacities after vacation. We'll see what is this. We don't know. Till 51. Yes, next. Yes, yes. Yes, yes, yes. 53.
53. The petitioner, my lord, is that senior citizens matter. I'm just placing the translated copies.
Come to the cost item.
Yes, my lord.
Who is the applicant before the assistant commissioner?
That is my husband, my lord. Petitioner one's husband. He has wrongfully stated his age to be 66 at that time. However,
No.
my lord.
Second respondent is the applicant before the commissioner.
Yes, ma'am.
And what is the document executed by him?
There is no document, my lord. It's just an assertion. Records may be called for.
What is the relief that is sought before the assistant commissioner?
He wants maintenance from us. Petitioner one is his wife, 2 and 3 are the daughters, my lord. And he wants lifetime residence in the property owned by me, petitioner one. The title is also in my name. My first contention, my lord, Senior Citizens Act does not have a provision.
It will not have
against me as the wife, my lord.
But what about 2 and 3? You represent them also.
Yes, my lord. Yes. 2 and 3, my lord. We are married. We don't live with them, and we have no independent source of income, my lord. We are residents of Bangalore, so that is as so far as 2 and 3 is concerned, my lord. Secondly, my lord, there have been several complaints we have filed against the respondent regarding the harassment he has meted out on us, and several NCRs have been registered in that case. He is also known to be an alcoholic, my lord. Further, he has his own job. He is a head cook in some restaurant. So he has his own income.
What is the evidence on record?
We have adduced evidence, my lord, in our...
For the assistant commissioner?
Yes, my lord, in our evidence.
Where is the order of the assistant commissioner?
It is in the annexure, what we have placed, page 19. The translated copy is there, my lord. Sorry, my lord. Page...
28 is the Kannada version.
17, my lord.
Copy.
I just placed it. Page 17 is the order, my lord.
No, where is it in the translated copy? Please come.
Translated copy, page 17, my lord. Action E is the order. That is the order we are challenging.
Yes. Let's read that.
My lord.
Let us read it.
Yes, my lord. Shall I read? The complainant states that in the year 1988, he constructed a house on government land bearing survey number so-and-so, has been residing there with respondent 1, his wife, and 2 and 3, his children. Complainant worked in a hotel and maintained his wife and children. He provided education to respondent 2 and 3. Both are now married and employed in Bangalore. At the time of regularization of the land on which the complainant was residing, an application under section 94C was submitted in the name of his wife, and accordingly, government issued the title deed in her name. Further, complainant states that he has constructed a new house on the said site by spending approximately 15 lakhs from his earnings. However, for the past 8 months, all respondents have been harassing him and forcing him to vacate the house. In this regard, he has also lodged a complaint at the police station. My lord, at this stage, I want to say that we have filed 3 complaints against him.
We'll hear that. Please complete reading.
When respondent 2 was summoned to the police station, she stated that she would take proper care of the complainant in the future. However, on 7/4/2021, all the respondents together threw the complainant's belongings out of the house, locked the house and left. Complainant is suffering from age-related ailments and he is facing hardship due to lack of money for medicines and daily expenses.
no shelter for residents. Hence, he has requested proper inquiry be conducted and suitable orders be passed for his protection and livelihood.
No, in the petition, let's go to the petition. What are the specific reliefs he has sought?
Yes, my lord.
Page number?
51.
Page 3, my lord, of the translation. The petition.
There is a relief he sought.
Yes.
I'm now aged about suffering from blood pressure and diabetes.
Yes.
Spending 2,500 per month. I'm also suffering from a disc-related problem, and doctors have advised me not to do any further work.
Whatever I'd earned so far has been sent on children's education on constructing the house. I now have no money left. My
Oh,
children.
he doesn't even ask for anything.
It's nothing specific, my lord, except
No, it's for the
protection and.
assistant commissioner to do something for him.
Yes, my lord. Further, my lord, it deemed service. He has not
Kindly
even
say,
appeared, my lord.
Prayer para. I therefore humbly request this honorable authority kindly conduct an immediate and appropriate inquiry into this and pass suitable orders for my protection
But I'm saying
and for
now
my
the
livelihood.
assistant commissioner will decide what is his requirement. He will not ask for it. That's what it appears to be.
No, there is a prayer to that extent.
Where
Last
is
para.
that?
I therefore humbly request this honorable authority kindly conduct an.
That can't be the prayer. Prayer is, I want so and so from my children, so and so.
There it is, my lord. Later part. Appropriate inquiry into this matter and pass suitable orders for my protection and for my livelihood and issue necessary direction to that livelihood. The word used is livelihood.
Not the prayer.
That is a
Prayer is-
meager 2,000 rupees maintenance.
He should say what he wants. It's not about 2,500 or not. If somebody says, what I want is what will be granted, it is not for the assistant commissioner to assess what he wants. Then what did the assistant commissioner do?
Yes, my lord. That is page 18. My lords may see. It's a completely bald order, my lord. There is no reasoning whatsoever. Page 20, my lord. Sorry. So the rest of the order is a reproduction of all the evidence, my lord. Page 20, may I read?
Para 2B, similar. The complainant has sought maintenance from his children for his daily expenses and shelter for residents. As per the Tahsildar report, the respondents have jointly evicted the complainant from the house in which he was residing and have locked the same. Further, the complainant is presently not engaged in any work. It is also stated by Tahsildar that the financial condition of the respondent is reasonably sound. Based on these findings, the Assistant Commissioner is ordered to pay 2,000 rupees maintenance.
Yes.
And the order is against 2 and 3, not against 1,
Oh, my lord.
not against the wife.
I may be permitted. The first order is against the wife, my lord, for
Where is
allowing
that?
him to reside in my house. That my contention is cannot be passed because the petition is not even maintainable against me.
Did you get that?
My lord, in order, respondent number
The
2 and 3 are
petition of the
directed.
complaint is hereby allowed.
No,
Yes, my
first,
lord.
first one.
Respondent number 2 and 3 are
3 are
directed to
allow the
person.
complainant to reside in his lifetime in the house at Siddhapura village where he was previously residing. Siddhapura village is mine, the petitioner wants. So respondent 2 and 3 have no control over that.
Then what about the second one?
Second one, my lord, we have no independent source of income. How are we supposed to maintain him, my lord? Secondly, he is the one who has arrested us continuously, for which there are several complaints on record. So it is.
One is you did your engineering and you don't have any independent income.
I have
2,000
children, my lord.
rupees
I
you
am
can't
not.
give it to your father.
I am not working, my lord. It's not
2,000
maintainable
rupees.
against my husband, no, my lord. It's maintainable against me. That aside, my lord, he has not even come on record to contest this. He has been served, deemed service. He has not come on record all these years. Finally, my lord, I want to place one more order. We filed for maintenance against him. He's not paid us anything. Under 125 CRPC, 8,000 was ordered against us. in favor of us.
That is the mother has filed.
Petitioner 1 has filed. my
His
lord.
wife.
I'm just wanting to point out his conduct. Neither this he has paid, he has completely disappeared. We have no idea where he is, my lord. He has not come on record. Notice deemed service.
You will show the age of the respondent as 60 years before
I'll
the.
just place this, my lord.
No, no.
This is the year after, my lord. He turned 60 by then.
No,
I'm
no,
just placing his
this
election
is in
ID also.
2022.
No, my lord, the order,
Criminal miscellaneous is in 2022.
22, my lord. He has
You
turned
have filed the criminal miscellaneous. You show him as 60 years.
62 is his date of birth. That's why he's turned 60 by then. But the time of filing the petition before Senior Citizens Tribunal, he is only 59. It's
When
not
is this
main-
petition filed?
21, my
2022.
lord.
22.
Just want to place his election
6/7/2022.
Huh?
6/7/2022. Is
So that
9,
submission of
1960.
yours may not be considered.
No, my lord.
Even as far as the maintenance is concerned, even if he is not a senior citizen, being parent is sufficient.
Oh, my lord.
Yes.
You have to be a,
Look at the,
Senior citizen
look at
who-
section 4.
yes. May I read?
Yes.
Maintenance of parents and senior citizens. A senior citizen, including parent. My lord, it has to be a senior citizen. The parent has to be a senior
Come
citizen.
to the, how it is defined.
Who is
parent.
unable to.
Parent is defined under the act.
5. Kindly see 5.
Parent means father or mother, whether biological, adoptive or stepfather, mother as the case may be, whether or not the father or mother is a senior citizen. But my lord, section 4 says the senior citizen including parent, my lord.
No, no. 5A, my lord. Kindly see 5A.
Read that.
Any application for maintenance under section 4 may be made by a senior citizen or a parent, as the case may be.
So that is it.
I may be
So
permitted
that
to place
aspect, we
some,
don't have to go into that.
but we have no independent source of income. That is the reality, my lord. And if he is so interested, why has he not
So
come?
like, however bad father is, you be good.
But
This is
we-
matter after vacation. It's just a meager amount of 2,000. 2 daughters, 1,000. As far as
Take
a mother,
instruction
as far
anyway.
as a wife is concerned, we can pass order that the act is not applicable to her. But as far as maintenance is concerned, 2,000 rupees.
But he has abandoned us. He is
But
not.
You
we
don't
cannot
have to,
trace
in
him.
that case, you don't have to pay anything to him, isn't it?
No, but if there's an order of the court, then
No, no, he's not available according to.
not
where-
available. He's not
Then
come
you
on
know,
record. We have
to
no
whom you
idea
will
where
pay?
he is.
To whom you will pay. So on that ground, you may not pay.
Still, they will. I mean, there will be direction to deposit, no matter. That is
This
the
order will
reason.
not set aside. Even whether you have an independent income or not, 1,000 rupees. Yes.
Obliged.
Petitioner. These are the batch matters,
For
my
the
lords,
respondent.
where my lords had asked the respondent
Respondent
bank
number 3 in
counsel,
this
my
case.
lords, on a short point as to why did they, was there any, did they know about the interim order? So this is a case, my lords, where the DRT proceedings under section 17, my lords.
Who appears for the bank?
I am appearing for the bank. My lords, kindly it may be passed over, my lords, to 2:30. Senior will address the.
Yes, sir.
Directly.
Yes, 55.
My lords, our senior is in another court on his legs. Kindly pass over, my lords.
Yes, 56.
Lord, serial number 56, I appear for the petitioner, my lords.
For the respondent, kindly, after vacation, my lords, in this case, earlier, so many judges appeared in this matter. But the respondent number 3 is concerned, he is no more. Recently received the wakalat from the authority. Kindly after vacation, my lords.
My lord,
Which
since
matter?
56.
56.
56.
My lord, since the year
What is the
2000,
petition?
my lord, since the year
Let's see what is the
2016,
petition.
please, my lords, if I may, my lords. My lord, since the year 2016, the petitioners had dug bore wells in the district of Ramnagara. My lords, due to the drought situation therein, My lords, thereafter, when I raised those bills for around 125 borewells dug by me, the bills were not cleared. I approached this honorable court for consideration of my representation for clearing of those bills. This honorable court had directed them to consider. Now they have issued the impugned endorsement stating that since no work order was issued, we are not liable to pay any bills. However, my lords, there are certain admissions wherein there are internal communications of the departments where they said,
Immediately after vacancy, request to
Lords.
join counsel the respondent on 3rd of June.
please, my lords, much obliged.
In this case, Lord.
My
I have
lords,
filed
I
an
am here for the
application.
petitioner. I mean,
Filed an application. that may
my
be
lords, may I
kindly put up,
submit, my lords, I am the petitioner,
because
my
we cannot-
right,
Saying something.
my
I
right
hear
for a
you.
writ petition, I
This is
file, let
what
them
happened.
file, they filed
No,
an
I
IA
filed
for
an
dismissal is
application
what he wants to
yesterday.
submit.
That goes to the root
I
of
will
it.
submit all of that to my lords, let me
No,
be
no.
given a chance.
This is my
Every time
application.
this matter comes up, he wants to
Because
submit first.
He is authorized by a person
This
who
is
is
not,
number
this is
director of
not,
a company.
I'll address that. I'll address that
At
issue.
least I should make a
Let me address
submission.
that issue.
I'll hear him. What is that IA?
Lord, that IA which I have filed, Lord, can be taken up on the maintainability of the very petition. What has happened, Lord? Admittedly, this company, I have also produced the
Is that
complete.
IA? Have you served on him?
Yes, Lord.
When did you serve?
Yesterday.
You want to file any objections to that?
Page number 6 of that IA may kindly be taken.
I'm asking,
No,
you want?
I
Yes.
don't. I will
Let me-
submit
let me
before
look
my
at
lords.
it.
Page number 6 of that IA may kindly be taken.
Yes, sir.
Their entire argument itself is defeated by their own document.
Even my lord, I have a submission, my lord. The state has to file objections. It's seems to be some serious matters. I need around 4 weeks time to file objections. Kindly treat this matter as a part-head, my lord. I have no issues to that extent.
Why you want to
My lord,
burden me with everything part third, take
Only
part
thing
third?
that, no. We need around 4 weeks time, my lord.
Then we will want an interim order, my lords, in this case.
Huh?
We will request for an interim order.
No. He is kept
Because
quiet
every
for
time
3
they are
years.
coming and they are asking for
Not
time.
even qualified that as
All this is only possible if both of you let the court understand
Please,
and
If-
pass orders.
Can I-
Now, I asked him, what is this IA? Let him submit, you can submit, you can make your submission. Yes, what is this IA?
I filed an application on the maintainability. Lord. Here, I have filed my additional statement of objection also, everything. Now, however, I found on verification that from the Minister of Corporate Affairs website, Lord, the petitioner company which has been formed on 19/1/2011
Yes,
has filed its returns on lastly on 39/2019.
Hmm.
And thereafter, it has not filed its returns. Lord. Now, recently, the no objection has been issued by another friend, wherein one director by name, Srishal Rudrappa Nirani, has signed the wakalat. Now, in view of section 164(2), my lord, now the company which has not filed the returns, something like that, for the 3 consecutive years, the director stands disqualified. I would like to draw my lord's attention to section 164(2)(b), Lord. Companies Act. Companies Act. Section 164. Initially, this petition was filed on 4/8/2023. That time, one person who claims to be the authorized signatory, Mr. Prasanna Huligeri, had
let's
signed
read
the
this 164.
164. Disqualification for appointment of a director. A person shall not be eligible for appointment as a director of a company if, I would skip subsection 1, my lord.
Reading 160
164.
of the Companies Act.
Companies Act.
164 deals with registrars, etc. To be evident, to give evidence.
Companies Act.
2013.
This was
2013.
companies, 19,
Let's see. Put it on the iPad. Please.
in the wrong provision. 164, yes. Yes. Yes,
Yes, sir. 164.
will not be eligible for appointment as a director of a company.
Company.
He
If
is-
I would skip this one, my lord.
He is an
No,
undischarged.
subsection
insolvent.
2. Subsection 2 may kindly be seen.
Subsection 2, oh.
No person who is or has been a director of a company which has not filed financial statements or annual returns for any continuous period of 3 financial years, I would skip, or I would skip clause B, shall be eligible to be reappointed as a director of that company or appointed in other company for a period of 5 years from the date on which the said company fails to do so. Now, here, my lord, admittedly, as on 30th September 2019, they filed their last return, my lord, which this MCA records clearly speaks. Now, as on 30th 9 2022, this disqualification comes into place. Now, I'd like to draw my lord's attention to 160, the proviso to this, which has been inserted by virtue of 2018 amendment, my lord. Provided that where a person is appointed as a director of the company which is in default of clause A or clause B, he shall not incur the disqualification for a period of 6 months from the date of his appointment. What happens, my lord? He has the obligation to report to the ROC within that period. Here, the same has not been reported as per the records. Now, I would like to draw my lord's attention to 167.
Yes.
The office of a director shall become vacant in case he incurs any of the disqualifications specified in section 164. Now, as per the record, my lord, here, for the last 6 consecutive financial years, this company has not filed any returns. Now, the person who has been acting as a director, he cannot act as a director by virtue of rigor under section 164(2) and 167. Now, my respectful submission is that the no objection wakalat which has been filed, the person cannot act as a director at all. Because he is as per the annual reports which I am going to apply for a certified copy, which clearly says that he is appointed by rotation. So there has been failure to conduct even a general body meetings for last 6-7 years. So he ceases to be the director. He cannot represent. And the Honorable Apex Court, my lord, I would like to just say that if there is no proper authorization, the matter cannot be, he cannot represent and it cannot be prosecuted. And now why I am raising it as an officer of the court is that even as on the date of filing of this petition also, that person who has signed, he also did not have a proper authorization. Even our office objection clearly, the rate proceeding rules clearly mandate that there should be a company proper board resolutions.
Which paragraph?
I would like to draw my note. Para 8 to 14. Here, this was the authority under the erstwhile Act, my lord, sued by a company maintainability. I would directly come to after relying upon the other 2 judgments at para 13, my lord.
Yes.
Para 11, I would like to draw, my lord. The trial court analyzed the pleadings and evaluated the evidence produced by the party reported in authority letter issued by the Sri so and so, so and so. A perusal of aforesaid authority letter shows that Sri so and so, in his capacity as CEO of the company, had authorized Sri so and so to verify and file the present suit. Apart from this authority, the plaintiff company has not filed on record any board resolution authorizing so and so to sign, verify, and institute the present suit. The plaintiff has also not filed on record its memorandum and articles to show that so and so had been vested with the powers or had been given a general power of attorney on behalf of company to sign, verify, and institute the suit on behalf of the company. The present suit, therefore, has been filed merely on the strength of the authority letter. The trial court then referred to the judgment of Delhi High Court in Nibro Limited versus so and so. And as already stated, it has not been averred in the plaint nor sought to be proved that any resolution has been passed by the board of directors of the plaintiff company authorizing so and so to sign, verify, and institute the suit. It has also not been averred that the memorandum and articles of the association taking any right to so and so to verify and institute the suit on behalf of the plaintiff company. It is therefore follows that the plaint has been instituted by Sri so and so only on the authority of Sri so and so CEO of the plaintiff company. Such an authority is not recognized under law, and therefore I hold that the plaintiff.
We'll hear him on this side.
Please.
Yes.
Page number 6 of their I. Twelfth line from the top. If my lords come down there and see what the ROC's own website says about my company. Active compliance. It says active non-compliance. My lords, then in that box may come to the second last line which says company status. It says active. Now, my submissions to this is that if my company and my directors would not or should not have powers to authorize any XYZ on behalf of the company, then those sections can't operate in vacuum. That just because the sections are there doesn't mean that I cannot be the authorized representative of the company. If they want to disqualify me as a director or say that I don't have the powers to authorize anybody to fight on behalf of the company, a notice ought to have been issued to me. They have to decide on that notice. Principles of natural justice, plain and simple. I mean, there need not be any more lengthier arguments by me on this ground before my lords, because principles of natural justice ought to be fulfilled with. No notice has been brought on record. He's just assuming that there is the person who has authorized me does not have power. This assumption, on the basis of an assumption, this IA cannot be made. This IA has to be dismissed. That's my only submission. Can I now take my lords to the petition as to what the...
After 2:30.
Great, great.
In this case, my lord, I would like to submit. If another friend wants to go on that, I would like to place some authorities on this issue. It requires some
You
consideration.
can't seek adjournment.
I need an-
No,
I
no,
need
I am
the
not
interim
seeking
order
adjournment.
then.
No, I am not seeking.
In the afternoon.
Yes, my lord.
My lords, yes, great.
My Lord's grants indulgence works. Serial number 82. But serial number 82, I would like to withdraw the matter. Not the reason is this: they are not proceeding against me. Not I may be given. I'm withdrawing the petition. I may be given liberty to move in case they proceed against me.
That you file a memo, when the matter is called, it will be heard.
Please. Great.
My lordship. Serial number 20.
Sir.
Sir. Sir, serial numbers. Sir. Sir, serial number 70 and ಅರ್ಜನ್ ಆಗಿಲ್ಲಲ್ಲ? ಹಾ, ಹೌದು. ಏನ್ ಸರ್? ಮೇಡಮ್, ಸರ್.
Milord's serial number 1 today, the order was pronounced. I just came from Mumbai. I simply want the order copy as soon as possible. If I could get it today itself. Yes, my lord.
Today itself it will be given.
It will be uploaded. I get it there. Or?
Today itself.
My request is, my lordship, the memo for postings matter is very urgent in nature.
No, no, no. I'll not accept any mentions in the afternoon. Yes, please. Continuation matter.
Grateful, my lords.
Yes.
If it may please my lords, I'll just take my lords through the sequence of events. And thereafter,
Who are you? What is the relationship between you and the?
Look at the prayers of the petition, Lord, I would just, where he is challenging these two communications issued by the Kent Commissioner, which he has issued pursuant to the directions issued by this honorable court.
I'm
Those
sorry,
two communication,
my
which
lords.
one first communication, what the commissioner says is that you had requested, as per the directions by this court, that to grant me an extension of time to implement the project. I am not a competent authority. In view of the recent notification issued by the government order, it is a competent authority, this Secretary C&I, that he has challenged. Second one is, he has just.
Thus, can you limit it to the IA
merely
on
communicated-
maintainability? He is
merely
taking my
communicated
lords to
that
the whole petition.
Secretary and C&I communicated to him, Commissioner, saying that two government orders which he is relying upon.
Please argue on both the matters. I'll pass an order.
Milord, I want.
Both on IA, both on other petition, both.
No, Milord. What has happened is on that particular maintainability, because he
Whenever-
has not even produced the board resolution also.
When was the
Because-
writ petition filed?
4/8/2023.
When was the writ petition filed?
4/8/2023.
What are you doing till now?
Milord, I have already filed my objections and all.
When did
Now
you file the
recently,
IA?
I would answer that point. Because what has happened, Milord, for 2.5 years they kept quiet. Now recently, one person claiming himself to be the director appears by no objection. I verified. Thereafter, I came to know that he ceases to be the director. How can they go ahead with the matter, Milord? I have the authorities also on this point because I did my own this one. Because 164 and 167, in a plethora of judgment, this honorable court and the apex court has already dealt with this. Because it goes to the root of the matter, Milord. Because he cannot argue on the merits of the matter. Because the very authority on which he has filed wakalat, that person does not have any authority. I would like to, I may be permitted to address my argument as a reply. Because my learned friend has said that opportunity has to be given. That has been answered by this honorable court. I may be permitted to give a reply on that, my application, Lord. I would place, my Lord. My respectful request is.
Will not mix up the issues. Number one, you're arguing on maintainability in a writ petition filed in your 2023.
Yes, my Lord.
For the first time, when the other side is insisting for a hearing on some IA, you will file an IA saying that.
No. There is no IA pending, my Lord. There is no IA pending. He insisted for an interim order which was declined.
That's what I'm saying. In a writ petition of 2023, you file in 2026, you say that the writ petition is not maintainable.
Because what has happened recently, they have changed the advocate and the person who has signed the wakalat, he is not a director. This is my request, respectful submission.
As on that day, he didn't sign the.
No, he
wakalat.
didn't sign.
Who
Look
signed
at the
it?
wakalat. Somebody else. That's why I'm bringing it to the notice of this court, my Lord. That is what I have mentioned in my application also.
My lord,
In
my lord, with
application
all due
clearly
respect,
mentioned one
if I
Mr.
may,
Hulgeri, he claims he has
if I may, my
the
lords.
authorized signatory. There also the board resolution was not there.
no, to answer his question,
There also the board
to answer
resolution
the
was
queries
not there.
that have been
Let me
raised by
complete, let me
him,
complete. Have
my lords are
Because
not
what
the
has happened
proper fora for him to raise these issues. The registrar of companies is sitting there. I mean, he can raise these issues and he can say as to whether there is any competent person, there is something happening there or not.
If
Not
somebody
my
else
lords.
is,
My lords cannot sit and assess and gauge evidence here, which is what my learned friend is expecting my lords
I
to
have
do.
already placed.
With all due respect, with all due respect.
If you don't file your objections to the IA, which is filed by them, then what the court should infer?
No, my submissions will be taken, maybe taken on record, because my submissions are that, like I said, the sections cannot operate in vacuum. The sections will have to be made operable in terms of administrative settled law, which says,
Party before the court, when somebody says you are not competent to give a wakalat or contest this writ petition, you should say,
What-
yes, I am competent.
what evidence does he have except
What
for, he has placed on records, my lord, page number 6 of his IA. My lords, may kindly see what is page number 6. Does that constitute evidence for my lords to then come back to me?
We are not deciding about a third party, we are deciding about you.
Burden of proof, yes, absolutely. That is where I am.
You will not say anything.
No, I am only on the question of whether he has discharged.
You will not say anything on that. Are you not bound to say anything when somebody files an IA? You don't have to, you will just say that he has not placed any evidence. So I will not respond to it.
My lords, how, if I am expected to prove the unprovable, in the sense, unless the allegation is first proved, I cannot disprove that allegation.
The present, the IA is filed stating that the director
By name.
is disqualified. The petitioner before this court is disqualified from representing the company in the light of section 140.
164 and 1.
No, my lord.
164-2.
I have
164-2 and 167-1.
See?
164-2, subsection 2.
No, no.
164(2) of the
2A.
Companies Act. When counsel appearing for the petitioner submits that petitioner has not placed any material before the court in support of the same.
Respondent
except
11.
The respondent has not placed anything in support of his contention except a document which is placed at page number 6 of the IA that do not substantiate the case of the respondent in support of the prayer that is sought in the IA. The IA is filed even according to the counsel for the petitioner. The same is served on the petitioner yesterday. If the petitioner has any, he wants to submit apart from the submission that is made, he has to file his objections to the IA and also stating whether the company is active or not as on today.
I'm sorry, my lords, just page number 6. My lords, may just take a look at page number 6. His own.
Apart from the page number 6.
No, no,
the
if that.
petitioner has to say before the court whether he is qualified to.
My lord, just for a second. I'm very sorry. Just for a second, my lords, that page number 6 is a document produced by him from the website of the company law board. Now that website itself, that document itself says that I'm active. That itself says I'm active.
Whether as stated by the respondent, whether the petitioner has any disqualification or he can represent the company before this court. In that regard, the petitioner shall file his objections along with the documents, if any. This is matter.
My lords, just one small request, my lords.
1st of June.
My lords, tomorrow I will have it filed. I will have it filed tomorrow itself. If my lords can have this.
Time to decide it at this point.
No, but my lords, my request for an interim prayer. My lords may just at least hear me out on my petition, and then my lords can decide whether I am entitled to it or not.
File it first. You file your objection to the IA.
My lords have given a date saying that it should be listed on June, but my only request is that it be.
I don't have time to hear before the.
Day after at least, my lords.
No. Day after, not at all possible. Yes. This is matter.
My lords, I'm very sorry, my lords, that I'm pushing, my lords. I've just come on record very recently, and I was not there on the record. But now that I've seen this, one opportunity may be given, my lords, because I mean, at their instance, they have been given a month.
Court has no difficulty to hear you. Problem is you have not. No, you have, mentioned this matter at a very fag end of the vacation.
No, it is at their behest that it was posted after a month. It at their behest. I wanted an earlier date.
Anyway, I have not posted it, not before this post.
No, it was posted by my lords. It came up before my lords at my insistence when I moved a memo. I requested my lords to point it out. Then no so-and-so is.
Only one day it has come up. I was not able to hear him. He was appearing virtually.
No, that was the previous occasion. The occasion before that, there was a person from their office, Mr. Gautam, who was here present physically, and at whose behest it was listed on 23rd. Otherwise, I wanted an earlier date. I requested my lords. No, my lords, at least 30th, my lords. I just request my lords 30th because I will place it on record. I will place it on record. That's all. On the maintainability, it is not such a big deal that I will not have documents if he's a director.
23 matter, why should we hear it on the last?
The only grateful for this question, the only reason is because they have been making averments that they are constructing there, they have done this and that, but they have not done that. It is, they have obtained licenses.
Yes, this is the matter on 1st of June. Yes.
May I at least request it be before my lords, since my lords have at least heard this.
So
for-
many matters before me, all after that, without this roster also, all partner
it's,
matters.
it's,
will
it's, a,
be-
it's a, it's only a request because my lords have already heard this matter and are
Not
aware
heard
to a
anything.
certain extent,
Not heard anything.
to a certain extent. It's just a request. Part heard, my lords.
As of now, what I heard earlier, yes.
My lords, part heard before my lords on first.
No, yes.
Grateful, man.
I undertake to file wakal to respond number
In
4.
this case, my
Or
prayer
four.
is that the fixed deposit receipt is in the trial in the
First
MSCT,
move
my
the
lord.
memo.
It may given to the petitioner, my lord.
For
It has
what?
been matured and it is to be handed over to her. The
Director,
manager, since you go to the advocate and collect it, the advocate has cheated her. She has filed a complaint for the bar council. And now she says you go and collect the
that
DD
has
from
been,
him.
that
It's a duty of the
complaint
court
has
to
been
give the
rejected. That complaint has been rejected, my lord. She filed complaint against trial court advocate and high court advocate. Both they have been rejected by the bar council. We have no objection to hand over the fixed deposit to claimants, my lord.
I undertake to file wakala to R4. But
Your
very-
Lordship,
I
I
can't
can-
understand, what is
No,
the petition about?
the amount is mine. I don't know why the court is telling me to go and collect it from the advocate.
Huh? Then what is it?
Your Lordship, I kindly see the appeal.
Please tell the court what is the prayer, Mr. Counsel, so I'll be able to understand.
Please, my lord, may I take your lordships to?
He is seeking to set aside annexure
Prayer is,
B,
my lord, to direct the
B,
interim
page
prayer, what I'm
number
saying, direct
53.
the
page 53.
court to hand over the check to the DD to me.
Let me see that order.
Please, my lord.
Yes.
53, not order.
Direct the senior civil judge so and so to hand over the fixed deposits to me.
The counsel for the petitioner, since he is the one who represented the petitioner and got the enhanced compensation by filing MFA. What is this
Not
order?
53 from 53, order dated, my lord, the operative.
Enhanced compensation.
That's
Enhanced
page number
compensation.
19, my lord. The prayer is at page
Interested in fixed deposit
53.
memo, the
I have
applicant-
typed it, my lord.
The years with liberty to appellant claimants. The remaining amount.
And
of
at
rupees
next
is ordered
page,
to
the
be
petitioner
released
direct to
in the
appeal the counsel for the petitioners.
disbursement of the enhanced amount shall be in terms of the award. The first payment in the above petition has made an application.
Next page, my lord,
The
the
matter we put up today for further orders.
next page is the
for release of
consent,
amount.
page 54.
What is this order?
Not that order never, not, it is no way concerned to that, because the reason, the assumption with the trial court is that get the advocate before the
Why to
trial.
get the advocate?
Not required. If you file an affidavit, that is enough. my lord. Lordship can,
Petitions are directed to approach the council. Who is this? Who passed
that
this order?
the advocate before the trial court. I representing only fourth respondent.
I'm representing advocate before trial court, my lord.
Why should they represent the advocate?
I'm
Why
representing
should
the
they?
trial court.
Huh?
I'm representing the trial court advocate, ma'am.
That's what I'm saying. Why should why the court directed the petitioner to approach the council?
Not-
Because he has to identify, my lord. You have no objection, absolutely no objection to handing over the FD receipts to claimants.
The FD kept in deposit, my lord. To release the FD, the signature and identification of the advocate is necessary. That is the reason the trial court said, go and get the necessary counsel to
Okay,
only for
Apart from the
identification.
advocate, they will not have any kind of identification.
Other he has to issue NOC, my lord. Otherwise, the court he has to
I'm
file an
ready to
affidavit
issue
before the
NOC.
court. He has to appear before the court and file an affidavit saying that advocate is not willing to come for and identify the signature.
I
That
am
is
willing
enough.
to- I am.
If you file an affidavit with the trial court, my lord, that is enough.
Please come. All this is not
May I hear
required.
lordship attention to page 129, my lords, where they say they have filed an appeal. Your lordship, I kindly see the person was dead on that date. He comes and files appeal before the high court. This is the fraud the advocates have done. And my client is stuck up with not the money which is not being given to her.
Take that.
Your 129, your lordship, I kindly change it.
20.
What is this?
Yes, my lord, the person was dead already. And this is the order sheet of the MSC.
Certificate.
It's a death certificate of the person who has filed an appeal before the high court, which the advocate who is answering is replying, my lord. How could a dead person file an appeal before the high court? Your lordship, you can see the order of the tribunal. He files a memo that the third respondent has died, and that person comes and files an appeal for seeking enhancement without my notice. And my signature is forced.
And this is a serious thing, my lord, and they are playing with the FD should not be given to me. What should I do? I am a widow. I have lost my husband. I want to pay my son's fees. They are preventing the DD to be given to me from the court. Where should I go?
You never objected handing over the FDs to claimants, my lord.
Let them explain how did that person come and sign before the court?
I am representing trial court advocate. I don't know that all.
They don't want to file objections to the writ petition. For last 3 years I tried.
Have you filed your objections to this? This is this is not a simple matter.
Please, ma'am. I am representing trial court advocate.
That's what 2023 is the order. 2023 is a writ petition. Why you have not filed your objections till now?
And High Court advocate also is just
For
not
R4,
appeared yet.
it's out to me recently. For R4, it's out to me recently. I will undertake to file wakalat for respond number 4.
Who is R4?
R4, Milad.
Who represented claimants in
The advocate was represented before this.
He is also representing the
R3, trial court, he is representing trial court advocate.
I am trial court.
R3 is the trial court
What
advocate.
kind of mischief is being played with the lives of these people?
No, that with regard to that prayer is concerned, we have no any objection.
We'll find out, we'll conduct an inquiry into this. What is happening?
Please, I will do one thing. I will file wakalat to the respond number 4.
Yes.
And I will file my objection. Lordship can take the matter after vacation.
What we do is, we'll direct the trial court first of all to release the amount.
Please,
At the same time, we'll keep this matter pending and we'll conduct an inquiry. This is not the way.
We'll file objection, my lord.
Yes. The petition is agreed by the.
That FD may be kindly given to me.
That's what that we will do. The petition is agreed by an order passed by the tribunal, where the tribunal has directed the claimants to approach the counsel for the petitioners, since he is the one who represented the petitioners for releasing the fixed deposit amount. It is a case of the petitioner that a fraud is played by the counsel appearing to the respondent before the trial court, both on the court as well as the counsel. It is submitted that they have stated that an appeal is pending when the claimant died on 10/11/2017. It is submitted that right from 2023, the petitioners are not able to withdraw the amount in view of as the advocate is not cooperating with the petitioners. So this writ petition is filed in the year 2023 for the reasons best known to the respondents. Respondent number 3 and 4.
Not 4, I am representing here. Respond number 3 only, the direction was issued.
4 is High Court advocate.
Respond number 3, not against the respond number 4.
No, respond number 3 is the trial court advocate. Respond number 4 is High Court advocate.
Trial court is
the respondents 3 to 4. Anyhow, whoever is made party has
3
to
is
file
nothing to do with that, Milan. The direction was issued to get the R3 advocate, trial court advocate, not by R4.
He has made the parties 3 and 4.
Lordship.
Whatever it is, you file your objections.
Please,
You have nothing to do. You tell that by filing objections. Respondents number 3 and 4 shall file objections before this court. Basing on that, this court would conduct further inquiry into this matter, because under the Motor Vehicles Act, which is a beneficial legislation, the parties who are deprived of their who have lost their family members, or who are injured in the accidents, if they are not able to realize the fruits of the award, the purpose of the act itself is defeated. The respondent, the petitioner, shall immediately approach the trial court with all the relevant documents of identification, and the trial court shall pass appropriate orders within 1 week from the date of receipt of the copy of the order.
For R4, I'll take to file.
Mr. Narasimha takes notice on behalf of respondent.
Directions to deliver the DD to FD to me, my lords.
That's what I said. Go there.
Respondent 3 and 4 may permit file respond my objections.
Yes.
This is a notice issued under the Metrological Act.
Huh?
Notice issued under section 18 of the Metrological Act,
Huh.
where he has said to have given a reply.
Yes, yes,
Then we will,
Section 48, will that kindly see.
yes, give the act, metals,
That is,
legal metals.
though it's a notice, blood.
Let's see that.
Yes,
48.
compounding the offences.
Hmm.
Any offence punishable under section 25, 27 to 39, section 45 to 47, any rule made thereunder subsection 3 of so and so, either before or after the institution of the prosecution, be compounded on payment of credit to the government of such sum may be prescribed. He has committed an offence under section 18. Now we have issued a notice under section 48. 48 of the Metrology Act,
Yes.
which I have read out now. He said to have given a reply dated.
It's not a notice. You said that these are the offences.
Yes, my lord.
You want to compound it, you pay the compounding fees.
Otherwise, we will institute a private complaint.
What I asked you yesterday was, where is the adjudication by them under 48?
No.
Nothing. So you have to go before the court. Whenever they
Yes,
find
this
out,
notice, blood, I have given the reply annexure C.
there is nothing to consider here.
Yes.
That is what I am asking yesterday also.
Why have come before this honorable court, may kindly see, my lord. Therefore, if you are willing to get your
That
case
whatever
compounded.
you are telling before the court,
Yes,
when they institute the complaint, there you will be submitting it.
but this is, blood, within 15 days, you make compounded, failing which we will be presumed that you have no intention to get the compound.
Yes.
And
they will
according to
take-
the complaint.
They will take the
blood,
further
it is-
steps.
It is not a show cause notice, it
It
is
is
an
not a
order.
show cause notice. That's what I said. There is no provision.
So therefore,
of
my
show
lord, it
cause
has to be
notice
set
and
aside, let them pass,
No, no, no.
let
It's
them
not-
pass appropriate order.
You have to show from
Yes.
the provisions of the act that a provision says about so and so, there is non-compliance of the same, nothing. Now under 48, they can only pass an order for compounding of offense. If you are not interested for the compounding, they'll file a case. You have to go before the court.
They are not passed any order, how I compound.
No, they will do it. After that, before that, you have come before the court.
It's a premature, therefore, my lord, kindly direct. them
Whatever
to
they want to do,
dispose
pursuant
of,
to this,
direct
they
them
let them
to
do.
pass appropriate orders, after consideration of my reply.
No reply it is, that's what I'm saying.
This
There
is
no
a so
reply
called
in
notice.
this.
No. Against that, there will not be no reply. We will only institute the
Also
complaint.
understands.
Yes.
Please come. The presented petition is filed. Sing the following prayer. It is stated that the petitioner company is manufacturing Lithium brand by VVV and Sons Edible Oils Limited. In 1986 is sesame oil. The petitioner company sells its sesame oil in states in India. The petitioner company started producing Mantra groundnut oil and Hardil mustard oil in the year 2006 with good high quality edible oils. In the year 2001, the company started Dots Idiyam Appalam marketing. It is stated that the respondents issued notice under section 48 of the Legal Metrology Act 2009 for compounding on the ground that the officer of the respondent has alleged and found the petitioner had violated pre-packed packages upon inspection on 28/7/2023 at the trading premises of TVS Supply Chain Solutions Limited, number 86, Polarul Village, Oskote, Samatanahalli, Gram Panchayat. It is stated that as per the impure notice, if the petitioner do not pay the compounding fees, they are liable for the offences under section 36 of the Legal Metrology Act 2009. It is stated that the petitioner has replied to the notice dated 28/2023. In detail, the petitioner has given their product net weight in terms of mass in both front side and back side, referring to Legal Metrology Rules 2011. But the same was not considered by the respondents. since the petition has come before this court. The learned counsel appearing for the petitioner has argued, has made submissions in line with the government in the writ petition, and submits that the impugned notice needs to be set aside, and an opportunity may be given to the petitioner. Next para. Then AGA submits that this is a notice issued under section 48 of the Act, which deals of the Legal Metrology Act 2009, which deals with compounding of offences. They have stated that if this is a compounding fees and if the petition is not agreeable for the same, the appropriate proceedings would be initiated. It is submitted that the Act do not contemplate any show cause notice, and also there is nothing to be determined or decided by the authorities. The petitioner can make his defense before the appropriate court and not before the authorities, as authorities are not vested with any of those powers as per the Legal Metrology Act 2009. Next, and the writ petition is liable to be dismissed. A coordinate bench of this court on 12/2/2024 granted an interim order which is extended from time to time. Having heard the counsels on either side, there is a material on record. This court on the last occasion the matter came up has asked and counsel the petitioner to show one provision under the Legal Metrology Act which speaks about a show cause, a notice, an order, or a reply to a show cause notice to be issued before passing an order and under issuing a communication under section 48 of the Act. A perusal of section 48 makes it clear that whenever a notice is given and whenever a notice is given under 48, the petitioner, the party who is ready for the compounding of offences, they can pay the compounding the amount compounding the offence, or else as per the Act which says about
Institution of private complaint and Rule 7A of the Karnataka Metrological Rules.
Rule
7A. Rule 7A. Karnataka Metrology Rules, my lord. Karnataka Legal Metrology Rules of 2011, Rule 7A.
1 minute. Rule 7A.
7A.
Now, what are these rules called? Legal metrology?
Karnataka Legal Metrology Rules of 2011. Karnataka.
What it says?
It says, my lord, cognizance of offence, notwithstanding anything contained in the code criminal procedure so and so.
for Rule 78. Deals with cognizance of the Karnataka legal metrology rules 2011. Deals with cognizance of offences notwithstanding anything in code of criminal procedure. It says that the no court shall take cognizance of offences punishable under the Act made thereunder except upon a complaint in writing made by the controller and made by any other legal metrology officer authorized on behalf of the controller. Any person aggrieved or recognized consumer association, whether the person aggrieved is a member of the association or not, and no court inferior to that of a metropolitan magistrate or judicial magistrate of the first class for try the offences punishable under the Act and rules made thereunder. Thereunder. In view of the same, if when the respondents have issued the impugned notice, if the petitioner is not interested to pay the compound fees and he wants to contest the matter, the respondents would thereafter take further steps, and when they file a complaint, the petitioner would get an opportunity for the court to defend his case. In that view of the matter, this court do not find any reasons to interfere with the impugned proceedings dated the proceedings issued under section 48 of the Act accordingly. The writ petition is dismissed.
I'm sorry to interrupt you, Lordship. I come from out of station. I passed over matter at some point for your Lordship. 43.
Yes.
43, whenever you.
Is 43? Who appears in 43? Yes, Mr. Muttana.
My lord, I ascertained from the bank that is only typographical error, not it is 25, it is 26 only. That they will confirm because they have not sent that some.
It is only 26, not 25.
No, it is not 25. That is what they say, and they have got some postal, that letter sent by registered post and also some acknowledgement must be there. That those things, my lord, that this matter which is there before his honorable court is very serious.
When a 13-2 notice which is issued in the year 25 according to them, according to you in the year 26, a typographical mistake.
That is what they say, my lord, that I
So
inquired.
we will adjourn it after vacation.
Yes, my lord, that is.
Whatever you want to do.
Yes, my lord.
Don't do anything. And after that, whatever you want to, you can.
May I make a respectful submission? Fair suggestion. I approached the ED of the bank. The ED immediately transferred the zonal manager because he was wreaking personal vendetta against me and also seeking some illegal gratification for which I filed a police complaint. Today, the zonal manager is not there. Let the ED and zonal manager decide my matter before the next date of hearing if they feel that it is to be sorted out. Because an NPA, even by RBI circular, is 90 days. There is no payment from my side. On 6th of March itself, in this yesterday memo I filed, 4,85,000 was deposited by me. I am not an NPA at all. This is all vendetta, personal vendetta.
Let them deal with all that.
Yes, your lordship may direct if they want to resolve the matter with me, they can do it. In view of all these.
That's for you and the bank. That's what I leave it open.
Your lordship may say that. Your lordship may say that in case they want to correct any errors that may have been committed, and they would like to sit and discuss with the petitioner herein.
Where is that 13-2 notice? Page number?
Page number 72. 13-2 is page 72.
Then senior counsel appearing for the petitioner submits that a notice under section 13-2, which is dated 10/3/2025, is issued on the petitioner in the month in 2026 March. It is submitted that this is a antedated notice and the submission of the senior counsel that there was no occasion for the bank to declare the account of the petitioner as an NPA, and no opportunity is given to the petitioner to put forth his case, as the impugned 13-2 notice is dated 10/3/2025. Learned the counsel appearing for the respondent bank on instruction submits that the notice is dated 10/3/2026 but not 2025. considering the fact, the time stipulated, considering the time stipulated for a response under section 13(2), and the fact that the notice discloses that it is 10/3/2025. The respondent shall not take any coercive steps till the next date of hearing. The respondent bank, to this notice dated 13/2, this dated, this 10/3/2025 notice, which according to them is dated 10/3/2026, the petitioner shall submit his reply to this notice within, what is the time, 30 days?
60 days.
Huh?
60 days.
Within 60 days, why 60 days? Within 30 days you give that, so that if there is any scope,
Very well.
whatever your contentions, you
Very
can
well.
put forth before them,
Right.
within 30 days from today. Within 30 days from today.
From today.
The petitioner shall submit his reply to the notice, which is dated as 10/3/2025.
Much obliged. I'm grateful to you. Lord.
We'll start the meeting. Where's next?
Let's account closed now. Account closed.
Land counsel appearing to the respondent bank submits that the account is closed and announcing the surveys for consideration accordingly. The writ petition is dismissed as instructions. The said submission is taken on record. A61. Yes, Mr. Muttanna.
Also, one judgment, my lords, of the Bombay High Court. I'll distinguish that. But the question, my lords, in this matter, what has been challenged before your lordships, my lord, is an order passed by the Honorable Special Court under section 5(2), for which, my lord, there is an appellate remedy under section 16. So my humble submission would be, my lord, keeping all contentions open, because a question of fact, my lord, I'll be able to demonstrate that. But when, my lords, there's a statutory appeal remedy available, my submission is, my lord, 226 or 225 petition may not be entertainable, my lords.
You mean to say that they have to go before the special court?
No, before the division bench of this honorable court, my lord.
Oh, my
Under
lord,
section
special-
16, under section 16 of the act, my lords, what is challenged before your lordships, my lord, is a section 5(2) order passed by the honorable special and designate court under the provisions of KPIDFE Act, my lord. Section 16 of the act, my lords, provides that any person aggrieved.
See, where is that order?
Please, my lord. My lords, will permit me to take, my lords, to the prayer, my lords. Because prayer, my lords, is at page number 26, my lord.
Attachment seizure dated by the.
Lord's prayer, wherefore at 26, my lord, wherefore issue a writ in the nature of certiorari or any other.
I've seen.
Please,
My lord, this property was sold in the month of February 25. And this honorable order, Supreme Court order, that honorable Supreme Court order came in May 25. After selling the property was handed over to him and he paid the entire amount and property is over. Now, my lord, this honorable Supreme Court says once the property is sold and if it's no irregularities, that property should not be, that action should not be
Assume
cancelled.
that you have a case on merits, Mr. Muttanna.
Merits, but my
Now you are questioning an order that is passed by the special court.
no special court also, my lord, 1 minute, my lord.
Again, is special court is wrong. Special court is wrong. You will go before the court, which will decide it. Which is that court? A division bench of this court. You go before that court. What is the difficulty?
No, before going to the court, my lord, so long as the honorable Supreme Court decision is there, same order will come. Now, problem, my lord, now after this order, my lord, the Bombay High Court, this matter, same matter, the similar matter came before the, but it is not
Accept
division
it
bench.
on
single judge.
merits, you have a matter. That doesn't mean that everything will be decided by this court. Why not division bench? Why are you waiting for
No,
that?
my lord, even there, my lord, when this attachment was ordered, that registered mortgage was there. And that notice has to have given to the bank. And why the
Muttanna,
bank
you
was,
know
that
what
nature
I'm
justice has
looking
not
at
been
your-
complied with.
Yes. How those appeals will be numbered as?
MFA, my lord.
MFA.
Every day, my lord, more than 4 to 5 appeals are being, section 16, my
The
lord.
petition is filed, seeing the following prayer. When counsel appearing for the bank submits that the special court was not right in passing an order where the properties are attached much prior to the order passed by the apex court.
Yes, ma'am.
And he also relies on a judgment of the Bombay High Court in case of.
Lords, in the case of my lords, Asarek India Limited.
Take that copy.
Take this.
He relies on the judgment of the Bombay High Court in case of ASREC, within brackets India Limited, was the state of Maharashtra and others, reported in 2026 SCC Online Bombay 2067. Underlying on this judgment, it is submitted that the order passed by the special court is contrary to law and the same needs to be set aside. Then counsel appearing for which respondent you are?
Competent authority.
Two, my lords.
Then
Number two,
counsel
please.
appearing for the respondent to submits that when an order is passed under section 5(2),
5 clause 2 of the act.
5(2) of the Karnataka Protection of Interest of Depositors in Financial Establishment Act 2004, an appeal lies under section 16 to the High Court, which comes before the division bench of this court.
Depending upon the jurisdiction, my lord. If it's 15 lakhs, my lord, single judge, my lord.
Oh, anyhow, it has to file an appeal. That is a miscellaneous first appeal before this court, and a writ petition is not maintainable. In response to that, plan counsel for the bank submits that they have a case on merits, and this order has to be set aside. Next para, having heard the counsels on either side, there is a material on record. The petitioner is questioning an order passed by the special court under 5(2). Whether there is an illegality or the petitioner has a good case on merits in the light of the order passed by the Bombay High Court in the judgment referred to in the preceding paragraph, still the petitioner cannot bypass the remedy that is available under the Act, that is section 16, where the appeal has to go before a miscellaneous first appeal has to be filed before the High Court. In that view of the matter, this petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the appropriate remedy as per section 16 of the KPDA Act. The petitioner shall have the benefit of section 14.
Obliged.
Yes, next.
Appearing for petitioners, Your Lordship. I am appearing for the respondent by Lord. In this, we had given a OTS settlement. As per that, they had filed the affidavit. As per the undertaking, they have not made the payment, my Lord. And now the OTS has been recalled. They have to sit and work out with the bank.
Lordship, as per order dated.
This is matter after
7.
vacation. In the meantime, the party shall work out if there is any scope for settlement.
Your Lordship, one submission, Your Lordship. The amount has been paid, Your Lordship. However, there was delay of 15 days. For those delay.
No, last time you submitted that it is not paid.
No, it is not paid, my Lord. Full amount is not
We
paid.
have a check of paying the amount, Your Lordship.
We'll see after vacation. Yes,
Six.
sir, 64.
I am appealing for the petition, Lordship, on the last date of vacation, Lordship.
Not maintainable. Jana.
Lordship, I am filing undertaking affidavit, Lordship, on the last date of vacation, Lordship. After hearing the matter, Lordship, Your Lordship, it directed to petitioners to file undertaking affidavit before this honorable court by stating that, my Lordship, the amount will be cleared within 6 months.
When did I
Lord.
say so?
Lordship,
Which date?
on the last date, my Lord, orally instructed, Lordship, to file
Yes, sir. Now,
undertaking
morning,
affidavit.
Today, in the list, there are about 2-3 matters pertaining to this Jana Small Finance Bank.
Please, ma'am.
It's not maintainable before this court. The petition is not maintainable. I have disposed of those 2 matters.
In writ petition number 6960, my Lordship, already deposited 2 lakhs, my Lordship, as per the orders of this honorable court.
They will return it.
Already sales certificate has been issued, my lord. Sales certificate has been
Then
issued.
return the money to them.
Yes, ma'am.
The writ petition is filed. Both writ petitions seeking the following prayer. Where is the interim order? In which case, the next matter.
6960, my Lordship.
I
have deposited, the court had ordered to pay 10%, my Lord, but the petitioner deposited 2 lakhs, my Lordship. Accordingly, on 26/2025, I filed memo.
The petition, an order was passed in WP number 6960 of 2025 dated 26/3/2025, wherein the petitioner was directed to pay 10% of the amount within 6 weeks. Then the second petition, that is WP number 28835 of 2025 is filed before the court, wherein it is stated about wherein this court has observed about an interim order that is granted by a coordinate bench. Hence directed the matter to be listed along with WP number 6960 of 2025. And till such time the bank shall not take any coercive steps. The petition submitted as per the order passed in WP number 6960 of 2025, the petitioner has deposited the amount. Land council appearing for the respondent bank submits that they've already given possession of the property to the auction purchaser. Next para. Considering the judgment of the Honorable Apex Court in so and so, in both that Shobha and both the judgments. So and so the petition against the private finance company, that is Jana Small Finance, what is it? Jana Small Finance Bank, the petition is not maintainable. Hence, the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the tribunal. And the petitioner has deposited whatever the amount that is deposited as per the order dated 26/3/2025 shall be refunded to the petitioner within a period of 2 weeks from the date of receipt of the copy of the order. The petitioner shall approach the DRT within 30 days, 30 days from the date of receipt of the copy of the order. And till such time, the respondent shall not take any coercive steps, as already petition has a benefit of the interim order, section 40. Yes.
On behalf of petitioner counsel, his wife is under medical treatment outstation. Hence, it may kindly be adjourned. Other side.
Does this matter after vacation?
Please.
Look at it if there is interim order extended. The 66.
13-4 notice was challenged before the tribunal. Interim order was granted and the conditions were imposed. Accordingly, I have complied with the conditions. In the midst of the appeal, they withdrew the notice, 13-4 notice, with the liberty to initiate fresh proceedings. Once again, I challenge the 13-4 notice. Then the conditional order passed. I have made a request, since I have already deposited in the previous occasion, what was directed by the tribunal. So I have sought extension of time at least to make the deposit on second occasion also. Without considering that application, the interim order is vacated. As against which I am
Why should repeatedly your time should be extended?
No, first time I am seeking extension of time. The first order was complained before the tribunal.
Let's look at the order.
Page number 21.
Page number
21.
Let's read it.
Counsel for the appellant is present and filed memo for service of notice to the respondent bank and not complied interim order passed by this tribunal. None represented for the result bank due to non-compliance of interim order is vacated. Bank did not appear at all.
Where is it? At page number 21.
21.
You don't find it?
Page number page 21. 13/3/26 order.
13. Counsel for the applicant is present and filed memo for proof of service of notice to respond not complied the interim order.
Yeah.
When was the interim order?
Interim order was passed on 27/1/26.
27/1.
Page number 20.
26.
Yes.
The matter came up on 27/2.
Yes.
What was the time granted on 27/1/2026?
That is reflected in page number 51, interim order.
51.
And order portion is in page number 53. About 20.
The operations implement order postal notice dated so issued with that.
No, let's see 53. What it says shall be payable on or before 27/3/2026.
The reason because I sought for extension of time is not, I had the ailment, several diseases.
So they have time.
No. My lord, kindly go through the order in page number 53.
Read it.
The operation of the implement order, sir, one second. 7/1/2026 issued by the respondent bank hereby state, subject to the condition, the applicant shall pay a sum of rupees 75,79,746 being the approximate 25% of the claim amount within 2 months in 2 equal installments. The first installment of rupees 37,89,873 shall be payable on or before 27/2/2026, and the next installment on 27/3/2026. My lord, next, if the petitioner applicant fails to comply with the payment of any one of the above installment under 4A or any one of the above conditions, this order would stand automatically vacated, in which event the respondent is liberty to proceed further in accordance with law. My lord, I will take my lord to order sheet in page number.
The earlier order passed to the tribunal
My lord, permitted to submit earlier order also, I will submit my lord in this matter.
13-4 notice, which was under challenge, and
The permit I will
midst of the
submit.
appeal, they withdrew it to meet their whims and fancies. Again, they invoke 13-4, which was under challenge. What happens to deposits?
My lord, in this case, my lord,
Not
20
that I have not complied with the earlier order.
is not letting me to.
After he submits, then I'll again ask you, it's okay, let him submit. It's,
My lord, 2022, we should have initiated the measures. My lord, that measures has been challenged. My lord, we have withdrawn the measures since there was a defective notice issued under section 13 of the Surface Act. My lord, in that 10 lakhs is something he has paid. From 2026 to 2022 to 2026, not even a single paisa has been paid by the petitioner to the bank. The outstanding is 3 crore 3 lakhs. The outstanding is 3 crore 3 lakhs. Once again, we have reinitiated the measures, my lord, as contemplated under section 13.2 and 13.4 of the Surface Act. That has been challenged before the Debt Recovery Tribunal in essay number 53.
when did you initiate a second time?
The second notice was initiated on 26/9/2025. Thereafter.
This is the interim order in that?
Yes, my lord. Possession notice is dated 7/1/2026.
7/1?
2026. This possession notice has been challenged in essay number 53.
This 53 order is that?
That 53 order is challenging the possession notice issued on 7/1/2026. My lord, the Debt Recovery Tribunal has passed an interim order, ex parte interim order. 3 crore 3 lakhs is there. You pay 25% of the amount in 2 equal installment, which is at 37,89,873 on or before 27/2/2026. The another installment is on or before 27/3/2026. My lord, this matter, my lord, I will take my lord to ink page number 21, which he has read. Ink page number 21. My lord, on 27/2/2026.
1 minute. Yes.
27/2/2026, they advanced the matter.
Yes.
I am permitted to read that order, 27/2, which he was supposed to pay first installment, that was the cutoff date. The counsel for the applicant is present, filed IA, none represented, heard counsel. Counsel for the applicant is directed to reissue notice, so and so, so and so. Here, my lord, except the advancement applications, my lord, no application for extension of time has been filed, as indicated in the order sheet. My lord, again, my lord, on 13/3.
It's a wrong submission. I have made an application.
One second, sir, I am permitted to in this matter.
It is
On 13/3/2026, again, application has been filed for advancement. There, my lord, only IA number 871, it is for advancement. The counsel for the applicant is present and file memo of proof of service notice to the respondent bank and not complied the interim order passed by this tribunal. None represented so and so, so and so. Due to non-compliance of the interim order is vacated. The matter has been posted on 22/6/2026. My lord, even otherwise, my lord, they have not paid the first installment. For payment of the second installment, time is there up to 27/3/2026, which they have not complied with. My lord, 53, again, my lord, I will take my lord to ink page number 55. 55, their application, they are claiming that this application for advance, with the where extension of the time has been filed, but there is no IA number. I will take my lord to that IA number. This application was claims to be filed on 27/2/2026. 57, ink page number 57. Ink page number 57.
Yes.
My lord, kindly read the prayer, my lord, in the application. For the reasons shown in the accompanying affidavit, the applicant above named humbly pray that this honorable court may be pleased to extend the time granted 6 weeks to pay the first installment of rupees 37,89,873 to be paid on or before 27/2/2026 and the second installment 37. My lord, 6 weeks is over.
You already had now. You already have the extension of for the first, second.
I have not had liver cirrhosis and I have produced the medical certificates and I have requested the tribunal. I am not denying the liability. It is the second time you are.
Whatever, even if assuming that the court would have granted extension to you, that also would elapse by this time.
I will pay it. No, they have invoked section 14. I admitted in the hospital.
For 22/26, you don't pay anything. 26, you have an interim order. Again, for that also you.
Admittedly, there were defects in 34 notice, which was under challenge for the first time. There was an interim order passed.
Normally, you will not pay any amounts because it is defective.
I have paid. I have whatever the directed by the tribunal. I have paid. On the earlier occasion, 10 lakhs I have deposited.
Where is the money?
I have placed it on record.
No, where is the money? That, the whatever, both the installments.
No, earlier order I have complained, not.
I'm saying you're seeking extension of time, you
Yes.
sought,
Yes.
which was dismissed. Even as per that, what you sought was 6 months, 6 weeks time. The 6 weeks time is elapsed by this time,
No,
even
what
if
I-
it is
no, what I
granted.
would
If
do-
you're ready with the DD right now, we'll consider.
We'll pay payment, we'll make payment, my lord. We'll
You do
make
show
payment.
it to
We'll
the court.
grant us some time.
No time. I'll not grant any time. If you're ready, I'll set aside that order and you can. It is not that an order passed by the DRT in the month of March. No, it is coming up before this court in the month, end of April.
Kindly call it immediately after vacation.
No, I will not grant any
I'll make
protection.
some deposit. Thursday,
No,
according.
no.
Kindly post it on Thursday.
Yes, this is matter on Thursday. By the time, if the amount as per the order of the tribunal, both first installment and second installment, the money is ready, then the order will be set aside. Or else the petition will be dismissed. Yes, next.
For the petitioner, my lord.
Yes.
There was an OTS settlement. Your lordship might kindly go through page number 32.
Impugned letter dated 9/3/26.
The OTS was cancelled, my lord. What happened, my lord? 6 crore 90 lakhs ought to have paid. That is under page number 32. Within 90 days. Then also, after 90 days, I have to pay 8.9% interest. Now I have paid the entire OTS amount.
What about interest?
Interest also have 50 lakhs I have deposited. The interest would come only 26 lakhs. This is the amount. Delayed payment.
But what are your instructions?
Lordship, there is a new policy wherein they have said OTS has to be within particular date. After that, it doesn't, it has to be cancelled. I should be getting that copy of that petition might be by next.
No, what is the difference in time? By what time he is supposed to pay?
He is supposed to pay within 90 days. Your Lordship, may kindly see page
But
number
when did
32. Within 90 days, he's supposed to pay. But what has happened is he has not paid within 90 days, but he has.
When did he pay? After that?
He
How much
paid
time?
within 1 year.
1 year?
Eight months, my lord. Within 8 months you have paid.
Then why should we interfere?
No, with the
No, what is the
OTS.
purpose of OTS? scheme?
OTS also indicates that within 1 year, if you pay after 90 days.
Let us see that.
Yes, ma'am. Pay 32 minutes.
33.
33 men. Any delay beyond 90 days. Any delay beyond 90 days from the date of acknowledgement of OTS shall attract a simple interest of 1 year MCLR presenting 8.9 on a diminishing value. 1 year. I have paid. Entire amount is paid.
Then what is the purpose of this
Yes, my
one-time
lord.
settlement?
Some difficulty is there, otherwise nobody would come for a OTS, my lord. I have paid,
But if
extra amount has also paid, my
We
lord.
won't.
50 lakhs.
The court will not understand it that way.
Yes, my lord, I understand
No,
the
if,
court's.
if you pay one-time settlement after a year,
Yes.
why
No,
is
that
it
was
called-
accepted, that was
Why
accepted.
is it called one-time settlement?
There's a one-time settlement, up to 90 days, there was no interest, my lord. After 90 days, I have paid interest up to even more than interest I have paid. Now 50 lakhs I have deposited with the bank because 26 lakhs would be the interest.
What is this clause?
It is in,
We read it at page 33. What it means? I'm not able to understand.
it says,
Any delay beyond 90 days, he read it. What
yes,
is
your
it
Lordship,
usually
if there is an acceptance, if
Huh?
there is an acceptance, if the bank offers another extension, then with interest he has to pay.
It says so many things that in the. in
That
the-
is what the last, unless and until there's an extension of the bank.
Where do you get it?
That last line, madam, this is section 30, page number 32, last line. The remaining amount of OTS should be paid to the borrower within 90 days from the date of conveying the approval of OTS, failing which the settlement shall deemed to be cancelled unless and until there is an extension by the bank. If there's an extension, it's permitted.
Then your lordship,
Then why did you take the money? Why did you accept the money?
35 member. Entire amount is accepted.
He's due for the amount, so the amount in any ways.
No, that's not fair on the part of the bank. If you're not accepting, you should have said that we're not accepting.
Only thing is there is a new
The
notification.
money, you will take the money and then say it is not acceptable to you. If it is not acceptable, don't
The
accept.
latest notification came in September, Your Lordship. It says from October 1st, it is not applicable.
When did he pay the last amount?
7/8/25. 7/8/25.
Then it is
Yeah,
before-
but the
before
delayed
September.
period interest was a little,
No, you are saying it has come up in the month of September. You
Yes,
paid
Your
it in the month of August. Then how that subsequent notification of the RBI will apply?
That is what I just want to know, see the notification, because they said they'll be sending it.
When counsel for the petitioner submits that the petitioner has paid the entire amount under the OTS. And the respondents, what are they doing now?
Delayed amount also, it is paid on 31.
What are they doing now? Interim prayer, what is?
Interim
not?
prayer is not to precipitate the matter.
The respondents are taking, having taken the amount, they're taking the coercive steps. Then counsel for the respondent bank submits that. The petition has not paid within 90 days. And the amount is, and as per the new circular, which is issued in 2025 September.
Yes, Your Lordship.
September, if there is a delayed payment, the same, if it is the OTS is not paid within the time, the bank cannot extend time.
Bank can extend time, but here in this case, they have not
So
extended.
what is the new circular?
New circular says, the circular is not sent to me, Your Lordship. That is the problem.
As per
I'm
the
waiting
new
for the.
circular, they couldn't, they have not, they are not in a position to accept the petitioner's case. The same shall be, the respondent shall file their objections, considering the fact that the entire amount is paid with the petitioner.
Even
The
50 lakhs
respondent
extra
shall not-
was paid. Madam.
Shall not, along with the interest, the respondent shall not take any coercive steps. This is matter on 10th of June.
Much
Not
obliged.
10, listed on 16th of June.
Much
Yes.
PM lots for the.
My lords, in this matter, we have given NOC, my lords, kindly
How
unable.
many times, how many advocates will give an NOC?
No, like, they are, yeah, no, we have given NOC, so we just wanted the name to be deleted, my lord.
We will do it, argue.
Lords,
Yes.
last occasion, Lords, had submitted with regard to, Lords, the 5 legal points, Lords, on which,
No, let me look at, I don't remember what had happened on the last occasion.
Lords, last occasion, Lords, I made a submission. So far as, Lords,
But
13.
first, let me look at the prayers so that I'll be able to.
Synopsis that I have submitted. Synopsis copy is served upon him.
No, not yet. Synopsis, they have not yet given.
So you are questioning the section 2, 1 of the act, which defines non-performing asset.
Lords, with regard to that, Lords, an application is filed. Lords, not pressing, Lords, with regard to that.
Where is that IA?
Lords, that
That
IA is also filed, Lords, and it appears it is.
That's already answered by this honorable court upholding the validity. So.
No, that's why they are not pressing it.
That's why we are
Actually,
not pressing it.
Not required.
We are
An
not
IA
pressing.
is filed,
Then otherwise-
stating that the petitioners are not pressing the relief that is at, the prayer at A. Accordingly, the same, the memo is allowed. Yes, yes, next. B. Then what is the next one?
Lords, so far as, Lords, the other prayers are with regard to, Lords, the 13(2) notices and, Lords, issue of sale certificate, then, Lords, the issue of notification, bringing the property, Lords, for auction.
Once this
Lords,
goes, once
yes.
this prayer goes, all other will go to DRT.
Lords, with regard to this particular prayer, Lords, this issue is concerned. Lords, this is slightly on, Lords, a different issue altogether. Lords, the entire case, Lords, is based on 5 legal issues, Lords. I am not pressing, Lords, with regard to, I am not going into the facts, Lords, facts of the case.
No, first what you have to convince the
Yes.
court is,
Yes,
whatever the reliefs apart from A,
yes,
other reliefs which you are seeking.
yes, Lords.
Why
Lord-
you should come before this court?
Lord-
Why not DRT?
I'm sorry, no,
Lord,
B
sir,
also
the-
goes.
Huh?
If you give up A, then prayer B also goes.
Yes, B also goes, A and
Also
B
goes,
both.
A and B goes. That leaves only C, but
Yes,
C
A,
is.
B both goes.
No, Lords,
Mega.
B, Lords,
A and
only
B.
with regard to
Yes,
a
C.
portion, Lords, will go,
It will go.
not the prayer in its entirety.
It's a consequential prayer you're seeking
No,
to prayer
Lords,
A.
what happens, Lords, is that, Lord, I just point out, Lords, then thereafter, Lords, your Lordships
Yes.
could, Lords, consider that. Lords, I am only, Lords, submitting that my, Lords, firm or, Lords, the borrower is a MSME, Lords, firm. Lord, it is also recognized. The loan was released, Lords. May I just point out, Lords, with reference to the synopsis itself, Lords, because it will be convenient for the.
Yes.
Lords, the loan, Lords, was released on 23/9/2016, Lords. Even before that, Lords, 29/5/2015, your Lordships are aware, Lords, that central government's notification giving certain benefits under that notification to the MSME. Lords, thereafter, the bank, Lords, declares the loan account as NPA. Lords, that is on 22/2021. Next page, Lords, page number 2, last date.
30, some correction is there, 33/2021.
Lords, 33/2021. Yes. Before that, Lord, after that, then, Lords, there is a notice issued under section, Lords, 13.
That is dated 7/4/2021.
Yes, Lords. 7/4/2021. That is
Reply
one
is dated
notice. And
6/5.
another notice, Lords, for which, Lords, I have replied on 6/5/2021.
Just look at your reply.
Yes.
Where is it?
Lords, that is document number 4, Lords, which is placed along with IA. Lords, that is on 7/4/2026.
Separately you have, or along with the repetition.
No, it's come for the first
Lords,
time.
we
now.
filed
it by way of
Come for the first time now.
No. Though,
Document
Lords, we
come
have
for the first
pleaded,
time.
that particular document, Lords, was not placed and we have placed it along with the IA.
Yes,
I'll show, Lords, the pleadings also.
yes, where is that?
Lords, document number 4, page 12. On 6/5/2021, Lords, we have written to, Lords, the chief manager, clearly stating that ours is a MSME company. And thereafter, Lords,
There
they
is
are,
the endorsement that this is.
Lords,
received
this
by the-
endorsement, Lords, is seal signature is there. No, I'll point out.
No, I'm just pointing out, this is a denied document. We've not received it. We've not given this endorsement.
So in all these matters, what I feel is, no, you have granted, it is an MSME account. And you have given the loan, you know that it is an MSME account. So why should somebody come and tell you that it is an MSME account?
There is a requirement in the law, my lord.
No, that is, that judgment.
That judgment your lordship has seen anyway, that they
I've
must
seen
make a
that,
request
I've
at that
seen
point in
that
time.
part, but I'm saying you have the guidelines, you have the judgment, you are following the RBI guidelines. And with regard to the MSME accounts, what is the procedure to be followed? When there are guidelines laid down, why should somebody come and tell you?
That's what Supreme Court seemed to
No,
say.
no, but that we will, in the facts and the case, that was the thing. But what will happen to the Reserve Bank guidelines? You're supposed to follow that.
It is optional, my lord. It's up to the MSME. If they want to opt for it, they must opt for it. If they don't want to opt for it, it's up to them. If they say, I don't want to do it, then they can ignore it. If they want, they must make an
So
application.
let's see the guidelines. Where are
Lords,
the
guidelines, Lords, last occasion I have placed on record.
Yes.
Lords, in fact, it is along with the petition itself.
Give me this.
No, once you know and you ask them something and they have to come and file the verifiable documents and all.
Page number 40.
Of what?
Lords, page number 40 of repetition 25944.
Is the other repetition.
Another repetition.
Para 1(3), may I just? You have, that is the 2015 one, 29 May
Yes,
2016.
yes. Page 40, Lords.
I have it at, where is it? The writ also. Lord, may
Lords,
see para.
serial number 1.
Okay.
It says, my lords, identification of banks or creditors. My lords, get it, my lords? Identification of banks or creditors before a loan account of a micro, small and medium enterprise turns into a non-performing asset NPA, banks or creditors are required to identify incipient stress in the account by creating 3 subcategories under the special mention account SME category as given in the table below. But next is serial number 2. Identification by the enterprise, any micro, small or medium enterprise may voluntarily initiate proceedings under this framework if enterprise reasonably apprehends failure of its business or its inability or likely inability to pay debts, and before the accumulated losses of the enterprise equals to half or more of its entire net worth. Lords, this is a provision, lords, which is created enabling the MSMEs. Then, my lords, 4, my lords. I skip, my lords, 3. 3, my lords, I will also read it. The application for initiation of the proceedings under this framework shall be verified by an affidavit of authorized person. Then, my lords, 4. When such a request is received by a lender, the account should be processed as SMEA and the committee under this framework should be formed immediately.
Let us read it again.
Please.
The first identification.
Identification by banks or creditors before a loan account of a micro, small and medium enterprise turns into a non-performing asset. Banks or creditors are required to identify incipient stress in the account by creating 3 subcategories under the special mention account SMEA
So,
category.
before declaring an account as an
Yes.
NPA, this exercise must be done by the
Yes.
bank. Is it what the,
Yes.
when once it is, then the committee is constituted, who whoever is the borrower, he'll come with, as per the judgment of the apex court, with all the verifiable document with an affidavit. Does it so say so?
Yeah.
I have a slightly different reading of it. No, let my learned friend finish. I'll point out to you.
That's the only issue in these matters.
Which is what I want to now point out to you, lordships. This is the first part, is identification. Then please come to para 4 on the next page.
Yes.
What is required? Application to the committee for a corrective action plan.
No, that comes later after first.
Yes. No, of
You
course
have
not. One is
to-
identification, then it's application, because how it is identified, because there are 2 identifications, not identification by the bank, but nothing much happens on that basis. The second is identification by the enterprise. The identification process not is one, of course, by the bank that may identify for its own internal purposes. But 4 provides any eligible, you must be eligible, stressed micro, small or medium enterprise or a bank or creditor which has provided credit facilities may file an application to the committee in the manner specified by the bank for a decision on a corrective action plan and the terms thereof, provided that if a micro, small, so and so. Then lot 4. The eligibility criteria on the ground of filing the application and time limits within which such application shall be made will be in accordance with the regulations prescribed by Reserve Bank of India, and only such applications which meet the eligibility criteria and grounds will be admitted by the committee. When an application is filed by a micro, small or medium enterprise, such application shall be filed in a form prescribed by the bank in consultation with the Reserve Bank of India, accompanied by details of all liabilities of the
By both
enterprise.
the bank and the
Yes,
borrower also.
these are enabling provisions.
5 and 6.
I would say, my lords,
They are not.
I would say-
constituent.
One minute, we'll just
It does
hear
not.
him and I'll come back.
It's anyway. We are only interpreting this. Nothing against each other. These are, in a humble submission, enabling provisions. Bank also can do it, but bank is not obliged to do it. But if a person concerned wants to do it, then he must make an application, and there is a mechanism to do it. And he must make an application to the committee, and then, my lord, it triggers the mechanism. It can't be in a scenario of this kind where they come after several years and before your lordships and say, oh, actually I'm an MSME, therefore I should be given the benefit automatically. It is not automatic. And that your lordships have seen, I'm sure, the Supreme Court judgment and then Kerala High Court, which has followed it, which specifically says that the actual initiation has to be from the borrower. And the borrower must come and say, I have a corrective plan. It is not simply saying I'm making an application. I have a corrective plan.
According to you, that will arise at the time of 13-2.
13-2, that 13-2 is a trigger, my lord, for them to come and say, now my net worth is completely eroded. I have a corrective plan. I'm an MSME.
So, before declaring the account of any MSME as
Yes.
NPA, according to you, there is no other procedure is contemplated.
And if I may trouble your lordships, look at the judgment again of the Supreme Court. It may help, my lord. May I request, my lord, look at the judgment? Yes, bro.
My lords, before that, my lords, may just put it, my lords, so far as the interpretation on this particular provision itself, because my lords, that would help, my lords.
Just finish reading it, then.
We'll
No,
just
this
complete
provision
it.
itself.
We'll just complete. Yes, well, I'll hear you again.
In pronouncements, lots of people have seen pronouncements.
Page number?
I have filed, a compilation.
Yes, sir, that's what is given to me.
No, one
Yeah,
judgments
lots
compilation.
in,
It starts on constitutionality.
No.
There is,
Lots that we have placed it on record, lots
Yeah,
at
I'll
page
just-
number 62 in our compilation.
Page
to
number?
the.
Page 62, my lords.
The copy is here.
Which copy?
Pronouncements.
No, no,
I'll give it in a-
my pages, I'll have page numbers, no.
We don't have a copy of that.
No, could it?
No, I don't think this is. the one.
I'd,
that.
I'll give another copy. Well marked.
So we're relying on other judgments also. So it'll be, everything is there in this. I'll give you a copy.
You have all the judgments?
Yeah. No, no, no. What we are relying on.
Give me 5 minutes. 5 minutes. to finish.
Yes, 206.
Can I request my lord to kindly come to para 10, my lord, of the judgment at page 211.
300?
211 in that compilation. Would your lordship see at para 10, as stated, the whole controversy in the instant appeals centers around the notification dated so-and-so issued by the central government in exercise of powers conferred by section 9 of MSMED. Said notification contains instructions for framework for revival and rehabilitation of MSMEs. Relevant part thereof with regard to identification are reproduced under the notification, not as extracted. I won't trouble your lordship with the notification. Then please see para 11 on the next page.
Even para 3 and 6, my lords, would be necessary.
Wait, I'll read it. RBI, in order to make the said framework contained in the notification dated 29/5/2015 compatible with the existing regulatory guidelines on income recognition, asset classification and provisioning pertaining to advances issued to the banks by RBI, had made certain changes in the framework in consultation with central government and issued revised framework with operating instructions, wide communication dated 17/3/2016. It is pertinent to note that in exercise of powers conferred by section 21 and 35A of the Banking Regulation Act, the Reserve Bank of India, after having been satisfied it was necessary and expedient in the public interest to do so, had issued the master direction called the Reserve Bank of India lending to so-and-so directions 2016, wide notification dated so-and-so. Said directions have been made applicable to every scheduled commercial bank, excluding regional rural banks, licensed to operate in India by Reserve Bank. Amongst the directions, direction 4 contained in chapter 4 pertain to above common guidelines are as follow. While advising all scheduled banks to follow the guidelines pertaining to MSMEs, it was directed in direction 4.8 is under. I won't trouble my lord by reading the entire thing. Then para 14, in view of the above, it is absolutely clear. Instructions for framework for revival of and rehabilitation of micro, small and medium enterprises as notified by central government by notification dated so-and-so. In exercise of the powers conferred under section 9 of the MSMED as revised by Reserve Bank of notification so-and-so, having statutory force, last line, having statutory force are binding on all scheduled commercial banks licensed to operate in India by the Reserve Bank of India as stated in said directions. It cannot be gainsaid. Banking Regulation Act basically seeks to regulate banking business and mandates a statutory, comprehensive and formal structure of banking regulation and supervision in India. Then section 2135A is again pointed out. Then your lordship may kindly come to para 17. What is contemplated in the framework for revival and rehabilitation contained in the instructions directions stated here and above is required to be followed prior to classification of the borrower's account as non-performing assets. Said instructions contained in the notification as part of measures taken for facilitating promotion and development of MSMEs issued by central government in exercise of powers conferred under section 9, followed by directions issued by RBI and exercise of powers conferred under 21 and 35A of the Banking Regulation Act. Banking companies, though may be secure creditors, as per definition contained in section 2ZD of the SARFAESI, are bound to follow the same before classifying account as NPA. We may hasten to add that under the framework for revival and rehabilitation, banks or creditors are required to identify the incipient stress in the account of the micro, small and medium enterprises before the accounts turn into non-performing assets.
What does it mean? That I'm not able to understand.
Yes,
what does that sentence mean? That is, something is something the bank has to do.
Yes, yes.
What is it they have to do?
This are required to identify the incipient stress in the account. The stress being felt in the account meaning necessarily that they're not paying. They're not repaying the account. Therefore, it is classified as 3 parts: standard, substandard, and so and so, which is found in the lordship will see.
In this case, was it done?
I think
No.
Lord,
No, that won't be done.
Won't be done.
You have to ask him the specific instructions on
Yes,
this, because they will not do it.
May not have done it.
They will not
May not have
do
done
it.
it. But let us see, my lord, if that has ultimately a bearing on this issue by creating 3 subcategories under special mention account category. However, while creating such subcategories, banks must have some authenticated and verifiable material with them as produced by the MSME concerned to show that the loan account is a micro, small and medium enterprise classified and registered as such. The said framework also enables the micro, small or medium enterprise.
With great respect to the judgment of the Supreme Court, they will have it. Nobody has to tell them that it is a MSME account. That is there with them. They have given the loan for an MSME
Of course,
account.
that they will know. There's no
That
question.
they will know. What they want is for other purposes, whether that is under stress, what are the other factors, that would be placed before them by way of a verifiable documents.
Yes, ma'am. Now, in all of these cases, what happens, my lord, is there is a requirement that you must divide into 3 categories. That SMA.
What I felt is, looking at all these matters, there has to be specific guidelines to the bank. What they are supposed to do, not interpreting something or the saying that you didn't come, I gave 13 to notice, you didn't give reply. And some in cases, not only in this case, in other case also, the same bank says their acknowledgement will be, then we have not received it. Who will answer to that? So, at least banks have to be fair.
Yes, yes. No,
They are not like any other litigant.
No, and nationalized banks, they can't, of course, act not like a Shylock trying to take money out. But it's a different story altogether in this case.
Way we don't permit the litigant, the borrower to take advantage of it. At the same time, the bank is all the more required to be more fair in their.
Especially when they're exercising powers under surface,
Absolutely.
they have to be extremely transparent in their dealings. There's no question about it. And banks will not have to ensure that everything that they do is above board.
No, courts
which is
are
because
also
they get so much of power.
Conscious that all the amounts are like it's all the public money.
Public money.
But at the same time, because it's public money, there is without any rule or rhyme. You just say that I will do it this way, and it is right. Also not. It's not also can't be sustained.
Can't be. That can't be. I completely bow down, Lord, on
What I
that
say
question.
is all these MSME cases, one matter I've already reserved. So these MSME, what is the procedure? What is the Reserve Bank of India is saying? Let's not only rely on this Pronouncements case. Pronouncements case is not an exhaustive one with regard to what the bank has to do. It is just one line about what it is. So let them come up with what is that, what is the procedure. So let Reserve Bank of India say what is the bank supposed to do. Then we'll dispose of the matter saying that this is what you are supposed to do. You do it. If you don't do it, it is like your action cannot be sustained.
Of course,
Reserve Bank of India is a party in this.
Yes, in the first one.
There is the Reserve Bank of India. Who represents? Who is the advocate appearing for them? Why all the time the Reserve Bank India advocates are not representing before the court? I'm finding it on in several cases. What is the name you said?
I'm appearing for respondent 1 and 2, my lords, on behalf of Mrs. Nayanthara PG. My lords, we were only concerned with the constitution validity, which they've, I just noticed it, which they had withdrawn. And there was a judgment which had covered it already, my lords.
I'll take up this matter immediately after vacation. By the time I want the Reserve Bank of India to file detailed objections before this court with regard to what is the procedure to be followed in respect of this MSMEs, right from the time, like as per the circular, what is it they are saying?
Very well, my lords. We'll file our objections right after vacation.
I was just looking at the SMA account and classification.
Is it classified?
It's classified as SMA 1.
When was it done?
Page 33, my lord, of the writ petition.
Date?
No.
This is 2007.
Page 31, my lords, is the communication where they say that, my lords, MSME. It is their communication.
No. When was it as per the circular?
No.
As per the
They
circular.
have,
As per the circular, my lords, they have not.
No. There should be a date for that.
Yes.
No, it is a larger issue.
In one of the decision, my lords, rendered by this honorable court, by my lords, in a writ petition which is disposed of on 15th of December 2025. Pronouncements case, my lords, is considered, but however, my lords, not with reference to, my lords, this notification in detail, my lords. That is while
when did we
considering
declare
section 13(2), my lords, that was also referred to. That was also a case of MSME.
The depth of it will be understood, the more cases are coming up before the court.
Lords, I
As
would,
on
my lords, so far as
1/6,
Yes.
at page 35, my lord will see the,
35 of what?
of the writ petition
Which it
in
petition?
25944.
Uh,
What will
35.
find, this is as of 29/6/2020.
Where do you get that?
In immediately name of borrower, my lord, on top.
that is before declaring
Yes,
as
yes.
NPA.
Name of the borrower.
Has to be before
versus-
declaring as NPA only.
Uh,
Before declaring NPA, my lord,
Hmm.
you have to classify in under 3 categories.
Yes.
Therefore, your lordship will find on the next page,
Hmm.
at page 37, SMA status of the account with other banks, FIs, etc. as on 29/2/2020 is SMA 1. And your lordship found that? I'm sorry. Other information, compliance of scheme guidelines. Serial number 8, my lord.
Serial number
8 at page 37.
Yes. 8.
Other information.
Other information.
Whether CIBIL generated, current IRAC status, SMA status of the account with our bank as on 29/2/2020 is SMA 1. Then Lord, current IRAC status.
This is on 29/2/2020.
Yes, yes.
When was the NPA?
NPA, my lords, was declared
2021,
33/2021.
March 2021. Therefore, it is correct. Correctly
8th
done.
of March.
Therefore, my lord, SMA 1 is principal interest due between 31 to 60 days.
So once a 13(2) notice is issued, when he replies, then it's a duty of the bank to constitute the company.
No. Then, my lord, the application has to be in the form that is prescribed.
That's what they have to.
If
say
they
this
make their
and-
application in that particular form,
And apart from that,
Yeah.
and when a 13(2) is replied, they have to consider it and they give their response within time.
yes, yes. If a 13(2) notice is replies, if a 13(3)
3A.
reply has to be given, I have to then consider and respond to it. But in this case, my lord, that particular document which has come up for the first time in an annexure, in my humble submission, is clearly something which is created now.
There is one more, my lords. There is one more document, my lords. We have also kept, my lords, the postal receipt and as well as, my lords, the acknowledgement. Lords, because though we have raised, my lords,
Possible they
that
have
plea.
taken
No.
seal on it.
No, they
let's
have
see
taken
that.
the seal, and this one, my lords, is
It can't
we have
be.
sent it through for the second
They
notice.
mean to say, one they have given physically, other two RPID or whatever.
Yes.
In all earlier rounds, this document never
All
came.
surprises for.
Suddenly,
bank.
this document turns out of nowhere.
But the document, the genuineness of the document cannot be denied.
Why?
No. Ultimately, my lords, they will have to come on record. They have not denied even in their objections when I produced it.
My lord, we have
Last
got a
occasion.
complete check done. I have a report now received, and I'll file an affidavit with this as to what
So what
exactly
is
has
it?
happened.
Fine.
Lords, page 5, my lords, is the, lords, this 15/7/2020.
No, just now you're passed on.
Yes, my lords.
Document number 3. What is
Document
that?
number 3, my lords, is the RPAD, my lords, acknowledgement.
To whom it is sent?
Lords, this is sent to, my lords, Canara Bank, my lords, in the receipt. Your lordships will get it.
What is SRC Transports is yours?
Yes, that is petition.
That,
Petitioner.
Subramanian,
The acknowledgement has come
I
back to us.
Bank,
want to
yes.
rely on that.
When is it received? On 6/5/2021.
Please see the date. Please be careful. I mean, your client may have given you something. 15/7/21 is the date of the letter. 6/5/21 is this is for
There
the
is one
other
more,
seven-
one more communication is made. Lords, that I'll.
Document put it on the-
Lords, there are two demand letters, lords, that is under section 13(3).
So
13(2).
this endorsement you are referring to 6/5/21
Yes.
pertaining to which
Lords,
demand?
that is,
Notice dated 7/4/21.
notice dated 7/4/2021, lords, for which I am referring to this,
7/4?
2021. That is annexure E, page 53, lords.
For that it is 6/5/21.
Yes, lord. Then, lords, there is one more notice, that is on, lords, 5/7/2021.
For that your the seal
Yes,
you are
Yes,
relying on.
yes. That is on 15/7/2021.
I want your lordship to.
It can be verified from the postal thing also.
No, lordship may kindly see the documents which are placed before your lordships. Along with the interlocutory application, lord, there's one document which has, please see that seal, my lord, which,
Correct.
There must be some convenience compilation, otherwise it's
yes,
very
I
difficult
think
for
for
the
all,
court.
that's it. think notice period.
IA number, sir?
What are
IA number in 7426. They filed it, I think, on 7426.
74 is annexure E.
ಅಲ್ಲಲ್ಲ ನೀವು ಹಾಕಿರೋ
That is document number 4.
Okay,
Yes, it is
6521.
here at document number 4.
Document number 4.
Document number 4, the seal there.
Yes.
Canara Bank, Magdi Road branch manager, something like this.
Yes.
Then if your lordship sees what they've handed over now, please see the seal in this. Sir,
That is the bank's seal. I don't have any.
no, one will come to it, sir. Please don't
Yeah, yeah.
hurry me up a little bit.
What it say?
No,
It
this
is a
is some
round
other
seal.
seal. Now, this is some other seal. Now, most importantly, please see the demand notice that is issued by the bank. It is not issued by the Magdi Road branch. It is not issued by this chief manager at all. The notice has come, if my lord kindly takes, is from the regional office, Bangalore West, at page number, my lord, 57.
No, which branch has lent loan to them?
Loan is given, my lord, but then the notice which is
Magdi
issued
branch.
is ultimately comes from
Same
the
branch.
Pagadi branch.
Magdi Road branch.
Mm.
The demand notice, however, comes from a different office.
Demand notice is also by Milords Magdi Road branch.
Where do you get that?
Page 55 Milords.
Of the writ petition?
Yes, Milords. Page 53 it starts. Page 55 Milords.
No, no.
Canara Bank.
65 is the same.
At page 59,
Canara Bank, Magdi Road branch.
Magdi Road branch.
I think we better have this matter after vacation. By the time the RBI also will file their
Very well.
objections. And you please place the convenient compilation before
Very
the
well,
court.
Milords. From
Instead
our
of
side,
looking at
whatever
all
we have
this,
placed, Milords, we will put it in a paper.
The RBI shall file their objections by the next
My
day.
lords, just one correction, my lords. The RBI is represented by another advocate, not Mrs. Nayantara. Why only for the union in this matter? This was
What pays for
originally
RBI?
asked.
What is the advocate's name?
Kings and
Kings, King and Park.
King and
In this case, they are not appearing anymore.
RBI is not a party?
RBI is a party.
Appear for RBI in this matter, my lords.
You appear?
Yes, my lords.
Online counsel appearing for by the next date of
ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ RBI ಇಲ್ಲ.
RBI shall file the
In which case is RBI?
objections before this court. What is the procedure to be followed by the bank, step by step, from the day, from even before the account is declared as a NPA, and what is to be done by the bank, and what steps are, and what is to be done by the borrower, that is the MSME. A detailed objection shall be placed before the court, so that as
I think
there are several matters
Please
coming
make
up
no
before
party
this
in
court
this liquid.
with regard to this
25944.
classification of account of an MSME. To put a quietus to all that, the RBI shall file a detailed objections before the court. This is matter as part.
Lord, I must point out, in this writ petition, RBI is not a party. In
In
25944,
another case,
In your one in 25,
in 25944, where this issue has been raised, they are not a party.
may I seek indulgence, Milords, on oral application, Milords. Your Lordship may kindly permit.
the RBI, this court considering this, the court is so moto impeding the RBI. Sanjana, you are the counsel.
Yes, my lords. In 19289, I am the counsel for.
Sanjana and is directed to take notice on behalf of the RBI, and the petitioner, counsel the petitioner shall carry out the necessary amendments.
Please.
This is matter as part heard on 8th of June. Tomorrow earlier granted is extended.
There
Lord,
is
I'll
an
take the judgments back and
There is an
file
interim
a
order, Milords.
Yes,
to compile it.
take it.
The interim order, Milords, may.
8th of June. Give those judgments to them.
Interim order, Milords, in both the cases. Grateful.
Challenging the annexure endorsement issued by the respondent number 4. Well, the petitioner has purchased 1 acre 36 guntas in survey number 73.
But see it after vacation. This is matter after vacation.
Great.
Yes, 70.
Petition, kindly pass, or senior counsel is engaged in some other court. No? Kindly pass. 70 for the petition.
Tomorrow. This is matter tomorrow. Yes, next. 71 mention is made in the morning. Huh? 71, somebody made a mention on behalf of you. No? 72, yes. What is 71?
71, my lords, auction cancellation. Now, Your Honor's directed RBI to be present. While they took the entire money from the borrower and they cancelled the auction.
May I make a submission? I bid for RBI. My lord, I have received instructions.
In the earlier matter also, you are the, no, so there are so many counsels for RBI.
So many. I have received instructions just yesterday, my lord. Kindly permit me a week's time to place it on.
When counsel appearing.
My lord, I have some submissions.
Why RBI objections are not required?
My lord, let them make it, my lord. What had happened in this matter, my lord, last occasion, this honorable court directed RBI, my lord, to supervise this matter, or my lord, take a necessary, my lord, directions, instructions and make submissions. In fact, this issue, my lord, now recently, honorable FX court held, my lord, where, my lord, the very, my lord, same exact, my lord, verbatical case, my lord, decided by the honorable FX court, saying that, my lord, till, my lord, the sale is not completed, then.
I've seen that, the judgment, you have shown it to me. It can't be applied like that.
No.
I've seen that.
If my lord's permit.
Already you have passed it on. I've seen that. It is more went on of facts and circumstances of the case without considering the earlier judgments.
My sale was confirmed. They issued sale confirmation in my.
No. RBI counter is required. The land counsel appearing for the RBI submits that he has received the objections. Will be filing the same before the court and seeks time. List this matter also on the same day on 8th of June.
My lord, small submission, my lord. Respondent 2, my lord. Borrower. See, in similar case, 1/4 of 2026, Supreme Court passed an order. Similar case. There is no intervention of RBI in this case also.
No, that is what he also said. We'll hear it.
If sale is not completed within 3 months, then it shall be set aside.
Sale is not completed because there was an interim order by the.
We have to pass a reasoned order on that. Yes, next.
My lord, interim order may be.
Interim order.
Previous matter, Your Lordship. I'm told the other side wanted a Passover and
More I said.
tomorrow. Is it possible after vacation, Your Lordship? No urgency in this, and it is anyway further hearing, Your Lordship. We shall continue.
Lord, we are not having any objection to post it after vacation, but what I meant, Lord, on 21st, the matter was listed, Lord. And on the same day, Lord, at 10:30, they have taken time. And yesterday, day before yesterday, Lord, the police, the respondent, she sent the police
Tomorrow
to
I'll take
Mumbai.
up. No arguments. Tomorrow I'll take up.
Tomorrow
Yes.
difficulty for me, Your Lordship. That's the thing. Your Lordship, and another thing is that their counsel had called up the briefing counsel because the police had gone there in the execution matter, and I believe he's already absconding. He's not around. So therefore, there is no arrest, nothing. And there is no hard problem for him to even run away with.
No, even if the matter is heard, I will not be passing any order in your favor. I told that already.
That
I'll
is
not
why
be
if it can
granting
be
any
taken
interim
up
order.
after vacation.
I'll finally hear it.
We are ready to argue the matter on merit.
Then the court should
Then
also
today
have
they
time.
should have been there, no Lordship. If they say it's so urgent, they should have been there. They are not there. Can be taken up after vacation.
Taken time,
No, we didn't take time. I'm sorry.
And today also. we are
Tomorrow,
ready.
my difficulty, Your Lordship. That is why. Today I ensured that I would be there so that.
But we have to consider their difficulty also because they're seeking an interim order. Or
Your
final
Lordship,
order,
this
whatever.
anyway has to be disposed of.
I'll dispose of on tomorrow. This is not tomorrow. Yes, please.
Day after, may I seek Your Lordship?
Day after may not be possible, last working day.
Lordship,
Because
because
it takes a lot
tomorrow,
of time.
tomorrow I kept another part heard and kept today free for this.
Tomorrow list is, I'm having very few matters. This matter will reach tomorrow.
Beginning, please.
Yes, 73.
71 may be listed as, it is already part of, for further hearing, it may be listed.
It's already under for part.
Great.
70, I beg to appear on behalf of my lord petition in this matter.
Yes.
Representing for KV Lok Sabha, respondent. Ma'am.
Mr. Vignesh Shetty will have it after vacation. No urgency for this matter. Yes, vacation.
My lordship, one submission, we have filed one interim application order because they are constructing in the property.
In my
So
petition.
that interim order may
This
kindly be.
petition, I will not pass any order on your yes, next.
Appearing for petition, my lord. My lord, petitioner's land is utilized for laying of gas pipeline. That petition was dismissed for delay of 3 days in filing the application before the district court.
Let's see, where is the order?
My lord will get at page number 40. Award was, para number 10, my lord. Award was passed on 4/8/2011. Compensation was received on 7/8/2011. My lord will get at page number 41. Application was filed on 11/11/2011.
Yes, what do you say?
My lords, it is covered by the judgments also, my lords, and section 5 of the Petroleum Act. They have to file a appeal in 90 days. They have not filed an appeal in 90 days. There is no power for condonation of delay also in this matter. That has been decided by the trial court.
Issue is pending before the Honorable Supreme
Number
Court.
40.
That issue is pending before the Honorable Supreme Court in several cases.
This issue is not pending, my
Whatever
lords.
is the order of what is holding the field as of now will be followed.
Delay has been condoned in several cases, my lord.
No, I don't think so.
Several
Malad.
cases,
I
I will
don't
place
think so.
the,
One judgment.
yes, I will place the judgment on record. It may be called after vacation.
This is matter of-
There are other several cases.
You
There
know,
are other list of cases pending before this Honorable Court.
delete from the caption for dismissal.
Yes, please.
Preparing for petition, my lord, we are like to file a retirement memo. The petition, we are trying to contact the petitioner, we are not able to.
The red petition is filed, the accounts for the petition. What does it contain? Let us know.
Retirement memo. And the
Have you
second,
sent a notice?
we will send, my lord. And the second page is like, we did try to call to the petitioner.
Huh?
We did try to call to the petitioner, my lord, but they are not responding to
What
our
is that?
calls. That's a screenshot, my lord, of we trying to call to the petitioner number 2.
So no, that we can't take. You have to send him whatever is the address, you know. With
Okay.
that you have to send a
We'll do-
notice, then
we'll
only
do
you
it
can file
in
a
the
memo
next
of retirement. The red petition is filed against Tumku Grain Merchant Cooperative Bank Limited in the light of the law laid down in so and so. The red petition against so and so is not maintainable. Accordingly, the red petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. Same section 14. The petition shall approach the tribunal within 30 days from the date of receipt of the copy of the order. Any interim order is there? Look at it. Huh? No interim order. Yes. This next 76.
My lords, I appear for the petition on this matter, my lords. My lords, the brief issue in this matter is that I had taken 2 separate loans for purchasing 2 separate apartments. Now, one apartment was a monthly project, my lords, wherein it was a subvention scheme. The subvention scheme has been challenged before the Honorable High Court and the writ petition has been pending. The other apartment which I had purchased was a prestige apartment. Insofar as the prestige apartment loan account, I'm ready to pay the entire amount, my lords, but the bank is not accepting, stating that I have to clear both the land accounts, even though there is a dispute in respect of the monthly account, my lords. So I had given a representation to the bank.
File your objection.
My lord, I don't have a copy in this case.
I'll serve a copy.
Don't have a copy.
Counsel the petition for the copy of the writ petition on the counsel of the respondent. Business matter after vacation.
My lords, in the meantime, if they can give me a detailed statement as to what the amount is due as of today, I'm ready to pay the entire.
Detailed statement to the respondents, to the petitioners. The account statement to the petitioner. This is matter after vacation. Delete from the caption disposal. Is 77.
I'm grateful.
Petitioner in this case.
Yes.
Filed application, the respondent number 4 is died, man. The filed guardian application also filed, man.
Who died?
Respondent number 4, man.
Who is respondent number 4? For his order, when he died?
Died on the.
When he died? To say that already the LRs on record.
Man, they have a guardian application minus, man. The petition number 1 and 2 guardians application filed guardian applications also filed, man. Filed on 27/4.
Now you're saying that respondent died. And
Please.
already the LRs of the respondent are on record. That is what is the memo.
Please, man.
It is stated that R3 is no more. He died on 19/1/2026. And LRs of the R3 are already on record. Who are LRs of R3?
The petitioner, man, petition number 1, 2 for me.
Huh? They must be respondents. Look at it.
Petition number 1, 2, 3, man. I have the Suma is my daughter, man. The wife.
Third respondent is Muniswamy Gowda.
Shama got died, man.
The petitioner number 2
one also,
mentally disordered. Is the only son.
please, the Vinay Kumar, not this one. Suma is not the wife of Vinay Kumar.
Now, where did you say so in your memo that the third respondent is succeeded? He has only one LR.
Excuse me.
Where did you say so? This is matter after vacation. Delete from the caption dismissal. Yes, next.
Interim order of action. Interim order of
Order
action.
granted.
Lordship, appearing for the respondent number 2 in this matter. It's listed for dismissal today, Lordship. Actually, this writ petition wouldn't survive because, Your Lordship, they are seeking for Deputy Commissioner to enforce the RERA order. The RERA order is subject to challenge in another writ petition, Lordship, as it's already has been stayed.
Take that. The writ petition is filed, seeking the following prayer.
Lordship, ink page number 1 and 2, Your
By
Lordship.
virtue of this order, the petitioner is seeking execution of the order dated 1/10/2019, passed by RERA. There is no representation on behalf of the petitioner on the last occasion. The matter is posted today under the caption dismissal. Today also there is no representation. Land counsel appearing for the respondents of this act. The order passed by the
RERA, Your Lordship.
RERA is assailed before this court by filing CMP number 109 of 2024 and
Not CMP, Your Lordship, the writ petition 17842.
Where is that?
Ink page number 1, Your Lordship.
WP number 2. What is the
WP
number?
number 17842.
17842
of 2022, Your Lordship.
WP number 17842 of 2022.
Thereafter,
And a
the
coordinate
dispute,
bench of this court.
by order dated 13/2/2023, Your Lordship.
And they shall be granted stay of the order of the RERA by order dated 9/13/2023. Then
Subsequently, Your Lordship, there's a dispute between the petitioner and respondent number 2 is before the arbitrator because the RERA order is stayed which is passed without jurisdiction. The dispute lies before the arbitrator, no, Your Lordship. So we are contesting the arbitration, no. So maybe
what
that
will happen to this order?
the writ petition, Your Lordship, that it has to reach finality, Your Lordship. As of now, it is.
What is the finality when it is according to you it is not maintainable for this court?
The order passed by RERA, Lordship, as per Supreme Court is without jurisdiction because.
So this is non-it's in the eye of law, no, this order.
Yes, Your Lordship.
Hmm.
So therefore, they have consented for arbitration also.
So and so it is submitted that as against the RERA order, the petition, the respondents have to go, the petitions have to, the respondents have to go before the arbitrator and the parties are pursuing the same. Considering the fact that the petition, there is no representation on behalf of the petitioner on the last occasion today also, that he is not interested to pursue the matter, accordingly dismissed. Yes, 79.
Much, Your
This is a matter that relates to release of subsidies.
Huh?
Because this is a matter that relates to release of subsidies, Manoj. What I do, Manoj, is I create, Manoj, cultures for fish seeds, which is called Pangasius suchi. Manoj, I am in that business of producing fish seeds. Manoj, a work order is issued. Thereafter, Manoj, I conduct works and I ask for release of subsidies. That is not released. Manoj, I approach this honorable court, Manoj, and an order is passed, a detailed order is passed. Manoj, Lakshmi, have a look at page 20. Lakshmi, have a look at page 20. Manoj, in that order, Manoj, subsidies are told to be released. Manoj, this order, Manoj, was passed in 2011. And till now, Manoj, subsidies are not released. I have been approaching them. I have been issuing
Are your
representations.
objections to this?
I already filed my statement of objection. Our only contention is, as on the date of making his application, he was not a registered institution. The norms or the bylaws under which the notification was called in, only a registered person, after the notification is floated and after the petitioner makes an application,
he gets himself registered into the, gets the registration certificate here.
File your reply to that.
Lords, I have
No
the
rejoinder
registration
has been
certificate. Their
filed.
only contention in the objections, Lords, is that I'm not registered.
You're supposed to file your rejoinder to that.
Lords, I'll file the rejoinder. Your Lordship have it day after.
This is smarter after vacation. The respondent has already filed their objections. The petitioner seeks time to file rejoinder. This is smarter on 17th of June. Delete from the caption description. Yes, next.
Great.
Give that. The petition is filed. Question seeking the following relief. This petition is of the year 2023. So far, notice is not issued to the respondent as the petitioner has failed to pay the process. An interim order was granted on 9/2/2023 and that is extended on 27/4. Why she has extended the interim order when there is no representation? SMC. Tell her, why is she doing it? The matter is directed as there is no representation on 27/4/2026. The matter is directed to be listed today and the caption discussed today also. There is no representation on behalf of the petitioner. The petitioner cannot maintain this petition against an order passed under Section 14 if he is agreed by any of the steps that are taken by the bank. His remedy is before the DRT accordingly disposed of, giving liberty to the petitioner to avail the appropriate remedy. In this 30 days, he warned that he has a protection of an interim order that should also be there till such time. Section 14.
It has become
81, my
infractious,
lord.
your lords.
81. Housing loan, I have cleared the entire amount. According to me, I have cleared the entire amount.
Give that.
4 lakhs was the amount.
Your question, the notice, sale notice.
Sale notice. It
Sale
become
notice.
infractious, your lords.
Sale conducted.
No.
No, not conducted.
Then what else remains?
No, what remains is only discharge the loan of housing loan.
That is
Housing
not
loan-
what you, no. Your question, the sale notice, sale was not done. Now, this petition,
Become
nothing else can be
infractious.
decided in this petition.
I am permitted to approach this DRT to file
Any
appeal.
steps are taken.
Till then not to precipitate the
Provided,
matter.
no. Provided it is in accordance with law, you will have only you don't have an interim order till now.
Till now.
Then why will this court will grant protection to you?
No, further protection is required because I have repaid the entire.
Has he paid the amount as per
No,
the?
he has not paid yet.
No, you paid in one submission. That's correct. It's not correct
That amount
submission.
is not paid,
I
sir.
paid pursuant to the order passed by this honorable court. I paid 3,25,000. I paid that amount.
What is the outstanding amount?
The outstanding amount, according to the bank, is the housing loan is 4 lakhs. 4 lakhs I repaid the amount. The interest amount also, if it is comes to the interest amount also paid. In respect of business loan, my lord, that demand is 9 lakhs 15,000 rupees. So even that also I paid, my lord.
No, so there's dues,
No,
overdues in the account.
Housing loan,
An interim order was granted on 27/9.
Please, your lords, there's still overdues about 8 lakhs dues are, 8 lakhs are there. Let them approach the
that
bank.
is,
I don't come in
that is
the
the
way.
housing.
Please.
That is in respect of
Business loans, dues are
business
there.
loan, my lord.
The
Business
petitioner
loan.
filed seeking the following prayer. When counsel appearing for the respondent back submits that the auction dated 17/9/2024 was not concluded, hence this petition has become infructuous. When counsel for the petitioner submits that the petitioner is ready to settle the dispute between settle the dispute with the bank. And it is also submitted that a liberty will be granted to the petitioner to avail the remedy before the DRT. Expert. The having other counsel on either side, presumption on record. Considering the fact that the auction was not conducted, nothing remains to be considered in this petition. Accordingly, this court is passing the following order. The petition is disposed of given liberty to avail the appropriate remedy, if any, before the DRT. Petition shall have the benefit of Section 40. The petition shall be filed within 30 days. And as the petitioner has a protection of an interim order that shall continue till such time.
Within a period of any time.
30 days from the date of receipt of the copy of the order. Yes, 82.
82, my lord, I appeal for petition. Can you be permitted to withdraw the petition?
Give the memo. Memo is well seeking to withdraw the petition. Memo is taken on record. Dismissed as withdrawn. 83.
For the respondent, madam. Full amount paying by way of DD.
Yes. I'll have this matter tomorrow. And I'll close it tomorrow. Plain counsel for the petitioner has paid the entire amount as per the auction dated
27.2 euro.
in amount of rupees
39,75,000.
39,75,000, and the DDs are handed over to the land council appearing for the respondent bank. Then council for the respondent bank shall get specific instructions. This is matter tomorrow.
You are directed to accept the money.
It is directed to accept the money, accept the DD, and get instructions whether it is a full and final settlement as per the
auction. Action.
Yes. This is matter tomorrow. Yes.
Second list, first matter.
Huh?
Second list, first matter.
What happened to the first matter?
Table number 5, my lord. 1 minute.
See, who said tomorrow? I said not this matter. Tomorrow is the earlier matter. Yes.
Lordship, on the last occasion, we have filed IAM, my lord, to implead the LRs of the deceased petitioner, my lord. That application may be allowed, my lord.
You have filed?
The deceased petitioner, my lord.
Where is that?
I filed, that is put up on the file.
I'm not even given a copy of the application.
He is not impleaded as party. He is not impleaded till date as party.
You are not impleaded as a party.
But I filed my application for impleading on my base. My writ petition was allowed. Therefore, not this writ petition
So
was
first
restored.
we will do that. Then he will file his objection. Then your
But can I just make one request, Lord? Lord, if my lords would see the, can I just make one request?
Yes.
Lord, this writ petition is filed. Lord, seeking for a writ of mandamus.
Anything we can decide only once the
Very
others are on record.
Very
The IA number.
IA number is mine is IA number 1 of 26.
IA number. That's what are all these IAs?
1 of
What is
2026.
What is IA for bringing the LRs on record? IA number 1/26 is filed. That is, he's impleading our
It was my impleading.
That is not about their LR petition.
22/4, man.
You have to condone you have to comply with the office objections on 2/26.
What happens, my lord? In this case, my lord, they are asking for delay in application, my lord. Actually, technically, there is no delay because petitioner died after the before the restoration of the petition, my lord. Matter was pending. Then he was very much alive. It was disposed of. Then after several years.
26 is fine to condone the delay. Office of objections shall be complied with. You can write an office note.
Yes.
The note, then it will come.
Yes.
Yes, next.
Apply. To vacation.
No, how can he be included without that? Yes, 3. Huh?
I have to file objections in this matter.
This
Lord.
is matter
Receive the
after
instructions.
vacation. Yes, 5.
After vacation.
Petition. The petitioner has filed this petition, my lord. The petitioner has filed this petition, my lord, seeking directions, mandamus, writ of mandamus, not to interfere with the petitioner's business without due process of law, my lord.
What is petitioner's business?
The petitioner is doing the business, a spa business, my lord.
Huh?
Spa business,
Spa.
spa and beauty parlor business.
Spa and saloon.
Spa and saloon.
In terms of this order, it may be disposed of, my lord. There is no interference, my lord. My instructions are there is no interference.
Petition is filed in the following prayer. Land counsel the petitioner's officer. The
Similar
respondent
matters are
interfering with the petitioner's business. That is where the petition is running a spa and saloon. Let it, HCGP had placed before the court that on order passed by a coordinate bench of this court in Sanjeev K.R. Deroy was the state of Karnataka in WP number 20572 of 2022, dated 6th October 2023.
Paragraph 3
The
may be.
coordinate bench of this court has observed that if the petition is carrying out on the legitimate business in terms of the trade license, there is no cause for the respondents to unnecessarily interfere in the business of the petitioner, business. If any credible information is received by the police that any unlawful activity is carried on in the premises, then with necessary proof, the petitioner may be confronted. Action can also be taken by the police in accordance with law. However, in the guise of there being complaints received by the police, they cannot go on harassing the petitioner. If necessary, the respondent police can also require the petitioner to give the footage of the CCTV camera to establish any unlawful or doubtful activity being carried on by the petitioner. It is submitted that in the light of the said order, the writ petition may be disposed of. Accordingly, the writ petition is disposed of in the light of the order dated passed in WP number 20572 of 2022. The order copy of the order copy should be annexed to this writ petition.
This petition has become
Get some
infructuous.
instructions from the party. Your Lordship kindly.
It has become infructuous.
How many times you want instructions? What is this writ petition? Yes.
Lord, the license was suspended and period is also over, my lord, on from 21/6/2023 to 20/12/2023. my lord.
Quash the letter dated issued by respondent number 3. Who is respondent number 3?
Respondent Inspector of Police, my
Inspector
lord.
of Police. What is that letter?
Lord, drunk and drive, my lord, he has paid the fine amount. Thereafter, my lord, his DL is suspended for a period of 6 months. That is also over, my lord. That is from 21/6/23 to 20/12/23.
If phone number is missed, I couldn't contact him, my lord, therefore.
After vacation, part heard.
Yes.
Yes, at the request of the council of police. Yes, next.
Transfer notes, it has been RTGS notes. The 50 lakhs is complete notes. I've paid 30 lakhs today by way of RTGS notes.
Yes.
I'll take, I don't know, my lord, I'll just take in.
I'm producing copies of the receipts.
Wow. Why will he make such a submission before the court? Morning he gave the DDs, I mean, check. I said, why check? Why can't you transfer the money? So that's how it is. Land counsel appearing for the petition submits that by way of RTGS, he has transferred 30 lakh rupees. And now the entire amount of 50 lakhs as undertaken before this court by order dated
17/3 months.
17?
9 crore 50 lakhs still outstanding.
Hmm?
9 crore odd still outstanding.
1 minute. No, we are on a that something has to be decided. That day you are saying that some amount to be, then that was the order.
Please.
Have you filed your objections?
I filed, my lord.
Order dated 18/3/2026. Yes.
My lords, the possession may be restored, my lords, kindly. Possession has been taken over. I've paid 50 lakhs, my lords.
Sale notice assailed before this honorable court where, my lord, I put the property for, my lord, more than 10.
No, is it the case that where 13 do
Same issue, my
Please,
lord, MSME, my lord, initially, my lord, I pointed out there is no seal. Subsequently, my lord, they produced before my lord, some seal copy which you disputed. My lord, apart from that, this is a very same issue, my lord, they taken before the NCLT, they accepted their default. No, in fact,
First of all, 13 to notice if you if they give a reply, are you not supposed to reply to that?
No,
That
no,
is
challenge
if
13
you are
to
not, if you are not, then it has to go.
No. Here, my lord, that is not the case here. My lord. Here, their entire case is, my lord, whatever, my lord, they are apart from, my lord, kindly recollect, my lord, which you have argued this matter for some time. In fact, senior counsel. I classified the account as NPA. They came before this honorable court. They undertook before this honorable court, I am going to pay the entire money. Pursuant to that, based on the undertaking before this honorable court, my friend is appearing in that writ petition. This honorable court shown certain indulgence. Then, my lord, they are not complied even
Not a single
rupee paid. Therefore, my lord, this honorable court vacated interim order. Thereafter, they gone before the NCLT. 3 years, my lord, they enjoyed the interim order in view of section 99 of the IP. And my lord, we appeared before the NCLT. We pointed out, my lord, it's only to, my lord, circumvent my surface proceedings. Therefore, they're gone before the NCLT. Then, my lord, finally NCLT dismissed the petition. Now, my lord, after my lord, lot of order flowed into the picture 13.2, 13.4 sale notice. In fact, I took the position of the property, and my lord, 11 crore odd is 10 crore odd is outstanding. My lord, they coming before the honorable court. I'll undertake to pay 50 lakh. What is, my lord? They have to pay, either they have to pay the entire money, or my lord, it is in respect of MSME. My lord, they already gone before the NCLT. In NCLT, they admitted their default. They admitted that they're gone for even, my lord, they sought for IBC.
No, my lord.
I'll point out from the record.
No, what are you doing from all these
My lord,
years?
with respect to
Suddenly
that,
you
my lord.
realize that you are an MSME.
My lord, I have given representation for both the demand notices. First demand notice as well as given the reply.
When was your reply?
My lord, my lord, there are two demand notices.
Give the dates.
Please, my lord. My lord, the first demand notice was 1/7/2023, my lords.
Other was
1/7/2023. For which, my lords, I have replied on 10th August 2023.
10th August?
2023.
After 10th August 2023, what are the writ petitions that you have filed?
My lords, one writ petition, my lords, challenging the said demand notice.
What is that writ petition?
Please.
My lords, it's 10808, my lords, which is
Kindly see the order passed by this honorable court. Interim order granted by this honorable court for a moment. They're undertaking. They're accepted, my lord. There's a default.
In 15.1 months.
Next, give that writ petition.
I've placed along with them.
In fact, I also produced it.
We'll hear it tomorrow. Tomorrow there are less matters. Tomorrow. I'll hear it finally tomorrow.
Please, my lords.
30.
My lord, I have one request, my lord. In a similar, my lord, in one-time settlement, my lord, which we rejected, they filed one more writ petition. It is pending for consideration before. That may be connected, my lord. Have it tomorrow, my lord. It can be heard. The writ petition number, my lord.
I want to say this.
WP number 3837 of 2026. Similarly.
This is, lords, the present offer is 15 crores. Earlier offer was for a lesser amount, which we are not pressing because that does not survive on account of a
Time to get
higher offer.
instructions.
Let them say what is.
Instructions like what is the offer and what is not acceptable and what is acceptable to the bank.
My lord, now, my lord, 150 crore house. Kindly come to the sale notice, which is, my lord, assailed before this honorable court.
Not all that.
No, my lord.
We are not compelling you to do anything. I'm just asking you what is acceptable to the bank.
No, my
If
lord.
nothing is acceptable to the bank, that also you can tell.
No, my lord.
They can tell it, and I know that I don't have. Lords,
Kindly
what
see the
happened? I just
prayer.
wanted to say this, lords, that 2014, one of the properties which was given as a part of the mortgage, the government raised a dispute that this is a part of Gomala land. Bank wrote a letter to me saying that this property now.
The land means?
Gomala means it's a part of the government's property. Lords, Gomala essentially means the lands which is reserved for cattle grazing, which will be a property belonging to the government. So then they asked me that we will have to change the property. 2014, they gave a letter saying that we are exchanging this property in lieu of this mortgage. Now that property, my lords, is also held by them, which they have already said that we are exchanging the mortgage. So that property stands discharged. In the teeth of that letter, they cannot proceed against the other property because they wanted that this property has to be substituted. Now they want to hold both the properties and they want to bring it for auction. Doesn't matter. My lords, that part of it I'll contest. I'm not going on the merits of the matter because they orally indicated that 15 crores taking into account the valuations of the properties and whatever is the recoverables, they said 15 crores is the amount with which you can give it, then it will be sent to competent authority. They also said that it is subject to competent authority's approval. The OTS letter is accepted. Now competent authority says we don't accept it. You increase your offer. Lords, I don't know where to increase it because the valuation of the property according to them is 10.08 crores. If we go strictly by the guidelines which they are being following, Lords, the OTS cannot be less than the value of the secured assets as per their valuation.
Yesterday you were submitting it without conducting the first auction, they can't go for the OTS.
Lords, how many matters they have done this? I can place it because
that is one aspect. My lord, kindly come to the sale notice for a moment, annexure A. That whether that, my lord, that prayer is for a moment, my lord, it's maintained before the honorable court. My lord, kindly, my lord, page number, my lord, annexure A, page number is missing. 26, I believe, my lord. It is assailed before this honorable court. I put the property for auction. It's the first time auction I am putting, my lord. For recovery of rupees 188 crore 72 lakh. 188 crore
is outstanding.
Outstanding.
They give 15 lakh.
15 crore. I said improve it.
And you gave it 180 crores. And the property.
Property,
property mortgage is worth 15 crores.
There may be other property. Otherwise, I'll go against. Under section 13, I have right to
go. He is aware of it. Doesn't want to say. They gave us an OTS offer of 10 crores in 2022. They fixed that.
180 crores.
Yes, because the value of the secured asset was less. The manner in which they have calculated is something which is very magnanimous of the bank in respect of these figures.
Banks are magnanimous.
Yes. Now, 2022, they gave a schedule.
Also, my lord.
Lords, 2022, they gave a schedule. Lords, my hands were short. We requested them give at least one property so that we will sell that property and we can close this.
When was the loan obtained?
Lords, loan is obtained in the year 2013. So
what was given on the, what was sanctioned?
Sanctioned loan is, Lords, it is 13 crores. I have made the payments, my lords, because up to 2021, I think we have made the payments.
It has become now 180 crores.
Now they say they have become 118 crores. Doesn't matter, my lords, because they are way of calculation. Doesn't matter. But 2022, they gave me an offer of one-time settlement at 10 crores. They gave a schedule for payment. I did not adhere to that payment. Lords, then I came before this honorable court.
In this matter, there is nothing to be interfered. Only thing is whether you are open for an OTS or not. If you're not, then if you are the one ultimately has to accept the money. So you are the one who have to give the court saying that this is the amount you pay, or else we'll proceed with further proceedings. But that only I've asked you to get instructions.
But the difficulty is this for the bank, my lord. If something like, my lord, if some 10 crore or 12 crore, I have to place it for the competent authority. For that, my lord, there are certain yardsticks that which I have to follow. My lord, that's what, my lord. In fact, my lord, that manager which is handling, he also got transferred. Some new manager came. He said, I need some time to look into all those things. Otherwise, my lord, I would have secured an instruction on that effect. My lord, all I am saying.
Lord, they have a fixed deposit of 4 crores, 2 crores and 2 crores each. And they also have another deposit. Of 1 crore 31 lakhs. Essentially, 4 crores is the fixed deposit which is given because we took a bank guarantee for which we gave the fixed deposit. Bank guarantee is already lapsed. 4 crores was already held by them. That's what we did when they gave it in the year 2022. We requested them, you adjust this. If they had adjusted that 4 crores, I would have complied with the requirements under 2022 one-time settlement itself. Not in one-time settlement, if they accepted 10 crores in one-time settlement in 2022, they said that since you have not complied with the conditions, we are not adjusting the fixed deposit amount. We are going to give you fresh revised offer. So we kept on revising the offer. They only indicated 15 crores. We can close it because that's the maximum valuation of the property at which this property could be sold. So this is where we stand, my lords. Now they say that no, it is not acceptable. You will have to increase the offer, and then they bring the property to sale for 10 crores. I'm offering 15 crores. That property, the one more property, they cannot hold it for sale because they have given a letter saying that the property which is taken now is in lieu of this.
No, they'll put the property to auction. They'll test it whether it will fetch 20 crores or 30 crores. Then if it is not, then they'll give you, they will accept your offer.
Lords, I wanted to say this.
It appears to be the
no, I understand, but the manner in which the bank conducts the auctions, lords, I very rarely come across cases. There are cases. I don't say that there are no cases. Very rarely we come across cases where more than the fixed price or the reserve price, which is fixed 10-15% also, it will not go. It will not go beyond that. My lords, this is essentially, my lords, earlier what used to happen was, the court used to tell me, all right, then you, according to you, you say it is 4 crores. They are selling at 2 crores. You bring a party for 4 crores. This is what the court used to say. My lords, I had an answer for it. If this pen I can sell it for 4 rupees, if they take it into their hands and say that they will sell it for 1 rupee, is anybody coming to me and saying that I'll buy it at 4 rupees? They are more than happy to negotiate with him for 1 rupee. That's essentially what happened. This is what was reiterated, my lords, by the Supreme Court, saying that valuation is a very serious issue. So, lords, the reason why I'm telling this is, when it comes to the question of the properties, they are now computing that there are 2 properties, whereas there is only 1 property. Let them say, on the basis of the valuation, this is what is required to be paid. We'll pay it and close it. More than what they are going to secure by virtue of this property, they will definitely get it by means of one-time settlement.
Please come. Then the senior counsel appearing for the petitioner submits that. They're ready, they've come up with a one-time settlement offer of 15 crores. And the same is rejected by the bank.
Please, Madam.
Stating that they may increase the
Offer.
Offer is less.
It
Since
is
outstanding is more.
submitted that if the respondent comes up with an offer themselves, the petitioners are ready to, whether the petitioners, it is not for the petitioners to come up with an offer, but for the bank to say what would be the amount. It is further submitted that as far as the valuation of the property is concerned, they fix the same at 10 crores, whereas the petitioner has come up with a one-time OTS offer of 15 crores. It is submitted that if the bank may be directed to come up with the offer, so that the petitioner is ready to settle the matter. List this matter immediately after vacation. That's on 3rd of June. By the time the respondent bank shall come up with objections.
Sale is taking place. Let them not confirm. I don't say that they should not. If ultimately, my lords, I'm
Not a small deal.
I am aware, my lords. I'm not saying the sale should not take place in lines with what your lordship said, my lords. Oh, can I say this, my lords?
You can't grant an interim
My
order.
lords, in lines with what your lordship said, if the offers which is received by them is in excess of 15 crores, 16 crores, whatever be the amount, probably my writ petition becomes infructuous.
I'll say if the respondents can go ahead with the auction.
Yes.
If the offer is less than 15 crores, the auction shall not be held.
For that, my answer is this, Milord.
No, that is in the interest of the bank. I'm saying something.
That is the case. He can come and redeem that. Some option Milord may give in view of the recent Supreme Court judgment. He can come and redeem the property, and remaining money I am entitled to recover under Section 1310 from him. His other property I'll attach it, or I'll send him to the jail.
Whatever it is.
Please,
Whatever
Milord.
it is.
If I may permit it to go ahead with the auction. If he wanted to redeem
Less
it,
than 15 crores, don't sell it.
no,
Less
Milord,
than
10
15
crore I
crores.
put the property for auction.
That's what I'm saying. You conduct the auction.
There is a, Milord, I'll just
Don't
point out.
confirm it.
I'll just point out.
Don't confirm
There
it.
is a difference between redemption and closure. Redemption means he's paying, Milord, somebody is bringing somebody, he paying 10 crore rupees, he will redeem. Remaining money he is liable to pay. In respect of one-time settlement is something different. I have to, Milord, all the loan, Milord, I have to.
That we will anyhow decide. We are not saying that.
Milord, in respect of confirmation of sale, also, Milord, I'll just point, that is the case, Milord, I'll point out his contact. Milord, kindly come to the, Milord, earlier rounds of litigation filed by him. Kindly come to, Milord, page number 3 years, 201 for a moment, Milord, earlier rounds, 3 writ petition they filed.
Please understand, when is the auction you're going to hold?
Auction, Milord, at 8/5/2026.
8/5?
2026.
So you conduct the auction, by the time they pay the amount and all, it would take some time. On the reopening day, we'll take it.
Confirmation, nobody will come, Milord. Otherwise, Milord, from 2021, this account is NPA. Milord, it may go for another 2 years, Milord. They will not make any attempt to pay the money.
Notice, the respondent shall file their objection.
Great.
Yes.
Lord, see, if the property is sold, nothing remains in this writ petition.
What we can do today that.
Kindly have a look at, can I just persuade me, lords? Lords, may kindly have a look at page 193.
More or less the prayer that is sought before this.
So I kindly have a look at page 193. I'll not say anything more than that, because this is not something where I've come before lordships. Earlier, they gave the one-time settlement offer, which I could not because of.
But that is not a reason for this court to interfere.
Lords, I'm only, lords, every effort is being made only to ensure that we can save the property. And Lord, there is something left for me. 13 crores was done, and then from 2021, this is some an NPA from 2021.
Only you have sought is with regard to the one-time settlement. With regard to that, actually.
Lords, I am not saying that the auction should not go on. can I at least make this statement, my lords? Let the auction be made subject to the outcome of this
But
writ
what will
petition.
happen is, if the court passes such an order as rightly submitted by him, nobody will come forward.
Lords,
with the-
Lords, what your lordship said, if the auction sale takes place for less than 15 crores, they should not confirm the sale. I'm not saying auction sale should not go on. Your lordships may also not put an embargo, my lords, that they should not confirm the sale. Lordships is putting only a threshold bar, my lords, because I am offering 15 crore rupees as one-time settlement. It becomes equitable in taking into interest both the bank as well as the petitioner.
What will happen is, even on that day
Lords, if
also,
somebody comes at 12 crores, my lords, I am offering 15 crores, that's the only property available with them.
matter comes up on after the reopening day, I mean, not the third or third, that day, if they have confirmed the auction in favor of somebody for an amount of rupees 12 crores, we'll take note of it.
Lords, that's the reason why I said, my lords,
No,
this,
but at the same
lords, if
time,
your lordships do, my lords, I'm sure, my lords, if the same roster continues, I can definitely prevail upon your lordships to say that this is what transpired in the court.
I'll
Not
take it as a part.
grateful.
List
Very
it
well,
as
my lords.
part.
Lordships.
Point number 1 is for the petitioner, my lords.
Yes. We can take it up after vacation.
My lords, they are not complied with section 37, my lords. They only
We'll say no urgency.
interim order may be extended.
After vacation, interim order earlier granted.
Any
is
date
extended.
may be given. Date may be
This is
given.
a matter on 5th of June.
Much.
Yes.
Right. The only difference, my lord, you will also kindly turn to page number 27, my lord. With regard to the measurement, my lord. 297 square meters. After page number 27, para 3, my lord. Whereas the vendor is in peaceful possession, your lordship. Page number 27. Whereas the vendor is in funds of legality, he has agreed to sell 297.
Then which paragraph?
Para 2, my lord. Page 27, para 2. And whereas the vendor is in funds of legal necessity, he has agreed to sell 297.28 the super built area, major portion of the towards east and the western side, tiny portion measuring 54.54 square meters of super built area retained by the vendor, constructed in the square area.
Your case
Now,
your case will understand tomorrow. This is not tomorrow. Yes.
This is a little peculiar case, my lords, where,
We'll hear it tomorrow.
lords, very well, my lords, it can wait for tomorrow.
Yes.
Petitioners, my lords. I've seen that judgment, my lords. Two small submissions. One, I'm a home buyer. The loan is granted under subvention scheme, which is obviously struck down by the government of India. Your lordships are aware. Number two, there's no 13(4) action, my lords. So, of course, the entire case
No,
relates
if
to.
not, then there is no remedy for you.
My lords, there are orders of this honorable court, if I may just pass, where the banks have taken investigative action in
Is there any
respect of
tripartite
loan
agreement?
accounts, my lords.
Is there any tripartite agreement?
Yes, my lords, there is a tripartite
That's
agreement, my
tomorrow.
lords.
Yes, next. Tomorrow. Yes. 50?
Lord, I am appealing for the respondent in this matter, my lord. My lord, in this matter, my lord, there were two queries were raised, my lord. And then, my lord, in this, there is an injunction how we could initiate the proceedings. One, my lord, why we didn't make the builder as a party to the OA proceedings. My lord, the injunction, my lord, I'll just go by their pleadings, my lord. First, they'll go before the RERA, they'll opt for a exit option. They want to exercise exit option, they say there, and they obtain an order. Huh?
We'll have it after vacation.
Please,
This is matter after vacation, interim order earlier granted is extended. Yes. Give a date on 9th of June. Yes, next. 50?
This is a matter where lordship has directed to file objections.
Matter pertains to the payment of tasdeeq, my lords.
My lord.
Payment of tasdeeq.
Yes.
Tasdeeq, my
My
lords.
lord, in spite of my repeated request and the Tahsildar is not providing information and is not cooperating with me. And I have complained to the secretary also to this letter.
I'll have this matter after vacation.
Yes,
This
my lord.
matter as matter.
Let there
Date
be
may
a
kindly be
conditional
fixed,
order,
my
my lord,
lords.
otherwise
Then
R1
council,
to be present.
then a DG is submitted.
Yes, my lord, please.
In spite of an order passed by this court, the Tehsildar
Tahsildar,
has-
R3
R3 has failed to file his objections.
and non-cooperative.
On Lizzie's matter as parter, on 3rd of June, the Tehsildar shall appear before the court
Very well, please. Oblige.
as parter.
My lordships, serial number 26, one humble submission, my lord. This court granted a moratorium for 30 days in that matter, my lordships. But the petitioner intimated the respondent bank tomorrow there is auction and they are not listening. So we are requesting for a hand delivery of the order. That's
Handle it.
where IA1 is filed, my lord, where the notice also is there.
Right here only.
Court officer. Madam, ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಯಾವುದು ಎಲ್ಲ ಹೋಗಿದೆ MF
ಮೇಡಮ್ ಯಾವ್ದೋ MFA ಕೆಲವು ಬಿಟ್ಟು ಇದನ್ನೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ. ಹಲೋ ಕಟ್ ಮಾಡೋದು WP ಎಲ್ಲ ಹೋಗಿದೆ, MFA ಮಾತ್ರ ಅಲ್ಲಿ ಯಾವ್ದೋ ಚೇಂಬರ್ ಅಲ್ಲಿ ಐತೆ ಅಂದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
ನಾಳೆದು ತುಂಬಾ ಇದೆ, ಅದು ಅವ್ರು ಎಂಡಾಕ್ಮೆಂಟ್ ಬರೀಬೇಕು. ಇದ್ಯಾವ್ದು? ಅದೊಂದು ರಿಪೀಟ್ ಕೊಡೋಣ. ಒಂದು ಇನ್ನೂ ಬೇಜಾರಿದೆ.
welcome,